Can I just say something about Andrea?
Well, hey, everybody, and happy Saturday before Christmas. It's a little chaotic out there. I noticed we had to take my grandma over to Walmart today, and boy, things are kind of wild. So hope everybody is all geared up for your holidays. I know Hanukkah, of course, has been underway for a few days now. Any other holidays that you're celebrating this time of year? I'm really looking forward to tomorrow, right? Tomorrow is really one of my favorite days of the year, the shortest day of the year, because once it's over, the light comes back. And it's something I very much look forward to every winter. So I do want to apologize to those of you over in the UK, if any of you are in fact still hanging out at this rather late hour for y'all. I know it wasn't a particularly good time. The Pacific time is a little bit challenging to find the best opportunity to stream. But hopefully those of you that are interested in the Richard Allen appeal will get a chance to check back in if you aren't able to make it with us live here, because, yeah, we got a lot to talk about. We have been waiting for this brief for quite a long time, haven't we? It's been over a year since he was convicted and sentenced. It's extremely voluminous, the whole case record, the brief itself, of course, 113 pages. And so this is kind of our first glimpse at, well, kind of a chance to predict, evaluate where they stand, and, get a little bit of an idea about what they're doing and whether we think it's likely to succeed or not. So I do want to kind of lay out my game plan here. I do not intend to read the entire brief out loud. It is a lot. But I do have it. We're going to kind of scroll through it. I've got several sections highlighted, and we're going to just basically talk about it kind of on a lot of different levels. I want to talk about it, of course, from a 10,000 foot view, what it tells us about kind of some of the strategic decisions and priorities and stuff like that. And then go a little bit more detail into some of the specific errors, the law that they're relying on, what kinds of, conclusions and inferences and so forth that we can make based on how they have presented the case for reversal. So the first thing, of course, I always have to start with, when we're talking about an appeal, guys, the appellant is always on the back foot. The appellant is always at a disadvantage. And this is for a couple of reasons. One of those reasons is just structural. You're the one that has to show that something warrants reversal here or warrants some other type of remedy. And that puts a sort of burden of persuasion on you, a burden of, it's not really a burden of proof because you're not in the trial context. But you gotta have facts you can point to. You gotta have law that works in your favor. Standards of review on appeal are often not favorable to the challenger, which is something we will get into in a little bit of detail with some of these issues. But then there is just, the more kind of institutional part of it, the more, it's not written in the law, but it's just the reality of how the courts operate and kind of how the systems work to reinforce themselves, which is that they have a conviction. They don't want to unsettle that. It's just a very, typically conservative mindset in that regard that appellate judges tend to have. Something that you have to bear in mind is that pretty much every single criminal case that goes to a jury trial, they're seeing it. They're seeing it on appeal. Because a lot of times that's the main reason why you're going to appeal at all. That's why you went to trial at all is so that you wouldn't waive your right to appeal. There was, some issue going on, or you just thought, I don't know, maybe the facts are close enough. You thought there's really nothing to lose here. And it's a right that you have. So you go to trial and you lose, you might as well exercise it. And so that means there's often a lot of, not very good appeals, appeals where it's just not a real compelling case that there's any kind of significant injustice there. So it's a big part of the appellate attorney's job to really single out the cases that are different, the cases that, this is not your run-of-the-mill difficult client who should have pleaded guilty but didn't want to, isolated suppression issue or something like that, and thought it was strong, and so didn't want to waive it, so went to trial for that purpose. Things like that. You need to really show that your case is different. And so my first instant reaction to this brief was, I think they did that. I think that was definitely a goal that was accomplished. And so we're going to go ahead and turn to it now. But the main way that they accomplish this is by their emphasis on the facts. You can kind of always tell what a brief's priorities are just by what did they spend the space on. They have, I think, 24,000 words they had to be able to make their case in this one. And so you can just tell what's important to them by what are they spending their words on. And in this appellate brief, it's really crystal clear. This is where they're spending their words. The statement of facts. This is a case they are trying to win on the facts. And I completely understand, because the facts, that they have to work with are pretty unusual. They are pretty compelling. They are pretty different from the majority of cases that run through the court where, guilt's pretty well established, and there might be nitpicky credibility issues or something like that, but nothing that's like a real, smoking gun, he didn't do it kind of issue. A lot of appeals, go forward because they just kind of want to relitigate what happened. And so you can't really fall into that trap. But being able to present what is there in the record in a way that is compelling, and that's going to leave the court after reading it with a sense of, this seems kind of not right. This seems like something's not right here. That's really your goal, because it's the first thing that they read. It's the basis for everything that you're asking them to do. And so it's a way to get them motivated to want to give you the relief that you're asking for. They are going to be much less inclined to give you any kind of relief on appeal if they're like, well, he's probably guilty anyway. Who really cares? Who really cares? But if you can raise significant doubt in their minds, like, I just can't be convinced that this guy got a fair shake, they're going to be much more inclined to look at everything through the framework of wanting to be able to give you what you want. And that's really important in appeals, because, as I said, the standards are not always favorable. And there's a lot of conflict in kind of how the standards are articulated and what the law is. And so often you can kind of, the judges can kind of pick and choose, what law do I want to go, depending on where do I want to go with it. If I want to affirm the conviction, then I'll focus on the law that says, the standard of review is stringent, and the appellant has a heavy burden of showing the nature of the error, and you look for the language that makes it sound like the task of getting a reversal is almost unachievable. But on the other hand, if you want to reverse, you look for the language that makes it a little bit more permissive. Well, there's a legal issue here. Legal issues are reviewed de novo. We exercise our own independent judgment. We don't defer to the trial court on these things. So The focus on the facts here, I think, is really one of the most significant decisions that was made in how this brief was put together. Very heavily focused on the facts, heavy priority on emphasizing like all of the many ways in which this was wrong. And I think the goal of that is because, again, yeah, you can show that there's procedural unfairness. You can show that a lot of times. This guy wasn't treated fairly. Yeah, but if your guy's a raging asshole who's probably guilty anyway, they're not going to care. So you have to show it's not that case. And that's really what they focused on extensively here. Now, the next thing that really stands out to me about this brief is the organization. It's extremely well organized. And this is not always easy to do, to find ways to kind of group, because there's a lot of errors here. They are raising a lot of errors, but they've been able to group them in a way that breaks them up into these three categories. And that makes it much more digestible, much more approachable. It doesn't look nearly as much like, oh, this is, just a shotgun thing of where they're throwing up issue after issue, which if you looked at a table of contents and you just saw, like 18 assignments of error or something like that, you'd be like, geez, they're really trying to throw the whole kitchen sink at us. So they haven't done that. They've been able to organize it into these three main categories of errors. The search of his home was an error. The admission of his statements was an error. And then the evidentiary rulings that deprived him of a defense was an error. And then all of that can be, further broken down into kind of, just more specific details. So then let's go back to our conversation about priorities and where they spend their time. And you can kind of see from this, I think, what the appellate attorney's priorities were in terms of what they thought was most likely or maybe most important. Like, what did they really want to win on? And you see they spent about 8 pages briefing the search of his house. They spent about 18 pages briefing the statements that he made while he was in solitary confinement. The argument that they were not voluntary, just kind of related issues along with that, along with the process of how that decision was made. Bringing up independent state constitutional grounds, which is very helpful if you have that to work with. And it appears that Indiana does. And then about 26 pages on the right to present a defense, broken up into, several sub issues, most of which are, 2, 3, 4, 5 at the most, really, pages independently. So that tells me, I think that the appellate counsel is really focused on the issue of Rick's confessions. We'll talk some more about that when we get to that section of the brief. But I think that's the one that they really want to win on. I don't know if they're going to. I'll just say my personal opinion at this point. I don't necessarily think that's the strongest argument that they have for reversal, but I think it's the one that they want to win on. And I think it's the one that maybe they think they have the best chance at kind of getting a hold of the judicial conscience, of getting them to be horrified. I've talked in some context about the substantive due process standard of shocking the conscience. When something shocks the judicial conscience, that's a argument that it violates due process. Like, you're not supposed to do shockingly unfair and atrocious things in the U.S. justice system. So if you can kind of get a hold of that and get them to take it real seriously, that can be very powerful, both legally and then, of course, just in terms of the motivation. We got a little chaos out in the hall. I don't know if you guys can hear it, but I'm trying to entertain the cats because they're in their evening chaos mode, and they will be all over me in here and everything soon enough. But they have their little electronic toy that they chase around. It makes all kind of noise. So if you guys can hear that, that's what's going on in the background. The kittens are thundering around after their little chasey toy. So many cases, lots of cases that they rely on. A lot of them are familiar names. Some of these are real, classic cases: Chambers versus Mississippi, Chapman versus California. A lot of case names that Glossop is in here. Inri Winship. These are like a lot of landmark cases that stand for very broad propositions. And so the court looking through this is often going to kind of look through the table of authorities to get a sense of what the issues are. And so they'll know, Inri Winship, we're going to be talking about due process. Winship is a due process case. Glossop is a prosecutorial misconduct. Chapman is about harmless error. So it'll give them a little bit of a preview. They also probably have a lot more name recognition with some of the state cases than I do. Very common for states to have, their own kind of landmark cases on certain issues or certain topics. And so you just know whenever you see this case, we're talking about a search and seizure issue. When we see this case, we're talking about a voluntariness of a confession issue. Procedurally, of course, I don't practice in Indiana. I don't know their court. I can't say what is normal for how they handle things or how they don't. But I will say this, that what is extremely common in appellate courts at this level is that the brief is first processed through the chambers by the clerks, either the clerks or sometimes the staff attorneys. And so what they do is they will get the brief, they will read through the brief, they will check all of the citations. They may or may not independently read the entire record. With a case like this, it's probably going to be a little bit more challenging to expect them to do that. But that really is ideal. That would be preferred most of the time. Because, the parties are giving you the facts and they're giving you their take on it and stuff like that. But sometimes the court will have its own ideas. And so it's good for them to be familiar with the big picture as well. Sometimes based on things that they see, they'll call for supplemental briefing on something. You might go to argument and they'll be like, look, you briefed this and you raised this facts, but you didn't address this thing that I found in the record. How is that going to factor in? So the clerk will often then, just after having done that initial processing, they'll give it to the judges in a memo form. They'll write up a memo that's basically their own kind of restatement of what's at issue in the case, what the appropriate legal analysis is, and what they think the outcome should be, what they think the law points in this direction for a decision. So I bring that up just kind of for a little bit of context, because it can, just depending on how the court operates and who they have for clerks, how that system, really works, you can sometimes get a little bit of a, trying to think of the right way to put this. Clerks are often fresh out of law school. They don't have the jaded perspective, that the judges have developed. I don't know if this is going to go nuts pretty quick here. They don't have the jaded perspective that the judges have a lot of the time. And so they are often kind of more receptive to things. They are potentially more affected by, situations that are like hey, you got through law school, you expected things to be a certain way. Welcome to the real world now. Here's how it really is. And so we might potentially expect clerks to be a little bit more affected by, you know, the case and the issues, and for that to potentially play into their analysis of the case, their recommendation that they're making to the court. Again, it's not always the case, but it's just something that is a little bit favorable sometimes in the context of appeals. The fact that the clerks are involved, and just depending on how heavily the judges rely on their clerks, some judges will never look beyond the memo. You know, others will, you know, go through and independently research a lot of the stuff themselves. So it just depends on what you get, but having that extra input can be helpful. Always notice when there's a lot of secondary sources. So we've seen a lot of primary law here: cases, rules, statutes, constitutions. These are all binding sources of authority. But then secondary sources are explanatory law review articles, for example. These are much more like policy level types of resources to include in your brief, because they're not binding for anything. You're bringing them up because they're providing context, or they're providing kind of like broader application, broader principles and stuff like that. What are you doing, Buffy? I don't know what you guys can hear, but it's madness in here right now. So, you know, clearly they are going to be focusing on, you know, things like, look, there's a whole law review article, happens to be by the defense expert here, on psychiatric effects of solitary confinement. So just a little, it can be a way of sometimes bringing in a little bit of extra factual information. If you don't, you know, maybe there's like a specific point you want to make, it's not there in your record. But a law review article has been out and talked about this, or a study or something like that has talked about it. You can use it in your brief. It may not be the most persuasive thing, but it might. You just never really know what's going to catch a judge's attention. So here's those three categories of the issues, right? Search of the home, whether the search of the home was unconstitutional, whether the statements made while gravely disabled during unprecedented pretrial solitary confinement were involuntary, is really going to be the hook here. Product of unconstitutional detention and inadmissible. And whether the trial court denied Allen his right to a fair trial. To present a complete defense, explain the scene, and impeach the investigation. So 1 second here. Gotta get that toy out of this room. So it makes it sound very simple, right? It makes it sound very accessible. It doesn't seem overwhelming. It's very easy to follow. 3 issues, very standard in an appeal. That's like a good number. And so the ability to kind of take everything that you have to work with in this case and to synthesize it into one of these 3 errors, that represents a lot of just mental work. Like a lot of thought went into that. I can just imagine a process of, there was probably at some point like an idea dump. You know, they read through the record, they spotted issues, they dumped them all out, they kind of weighed them, they probably almost certainly like eliminated some. You've got limited space. Some are not going to be as strong as others. Then you have kind of this pile left, and then you spend time trying to figure out, you know, what's going to be the best way to sort and organize these piles. How does it make sense to fit them together? What do they have in common with each other, and that type of thing. So very, very organized, very well done. The statement of the case is just the procedural version of what happened. He was charged. There were some pretrial hearings. He got convicted, and he got a sentence. Is really all they need to know as far as the basic procedural outline. So then the statement of facts. I'm going to spend a little bit more time on this. One, because again, this was the priority that the defense chose to spend their time on. The appellate attorneys, focused very heavily on the facts. How they chose to present the facts, I think, is also quite important. And so this is our very first introduction to what the case is about. On February 14th, 2017, 14-year-old LG and 13-year-old AW were found dead in the woods. 2 days later, Allen, like many others, came forward and reported he had been on the trail that day and saw 3 girls. Because law enforcement wanted to know whether he had seen any possible suspects, he was interviewed in a parking lot. After the interview, the lead was marked cleared and the report was misfiled. Allen then returned to his job, family, and home in the small Delphi community. For the next 5 years, he did not sell his car, destroy his clothes, dispose of his gun, or relocate, but continued his normal routine. No witness identified Allen as Bridge Guy. When the report was rediscovered in September 2022, law enforcement insisted Allen was Bridge Guy without a single eyewitness. Over the next several years, the state built its case against Allen. So I've highlighted this last bit because this, I think, is the real point that the appellate attorneys want the court to get from these facts. They want the court to have the impression that this case was manufactured. This was not an organic, investigation, developed a lead that led them to Richard Allen. They had to construct it in order to get the conviction. And so they've cast it through this general introduction of the girls were dead. He came forward. He acted normally, did nothing to conceal himself or make himself hard to find or anything like that. He didn't do the kinds of things that you might expect a guilty person to do if they have a guilty conscience, they're worried about getting caught or anything like that. He didn't hide himself. Now, they're going to have to, there's always challenges in how to tell a story about a case. And so some of the challenges that they have here are things like no witness identified Allen as Bridge Guy. We don't know yet what Bridge Guy means. We don't know who that is. We don't know yet from the story how that fits into the case. We don't know really if it's significant that he was interviewed in a parking lot, what it means that the report was misfiled. The lead was marked cleared. Why was it marked cleared? Was that wrong? Was that right? You can only kind of do so much in your introduction, but they are going to spell some of that out later on. And so the overall point here is just this introduction is meant to leave an impression that this is a normal guy. He behaved in a normal way. Nobody suspected him at all. And then years later, they built a case against him. So that's kind of the commitment. Talk about like an opening statements. It's like a commitment to the jury. Here's what you're gonna see, and here's what you're gonna think about it. This is serving a very similar function. This is a commitment to the court. Okay, this is what you're going to think after you read through these facts. You're going to be left with the conclusion that the state built this case against Allen. It didn't discover it. It didn't find the evidence. It had to put it together itself. So they started with some facts to go specifically to the warrant issue. So what was the warrant issue? What was the warrant issued based on? So starting with the Bridge Guy video gives the context of what the Bridge Guy video was. It was the best evidence that they had. It was really what they had. It was at 2:13:51, very important time, 43-second video. And law enforcement enhanced it, and they got this guy. So we've seen him many, many times. We know who Bridge Guy is. So now that part of the introduction is satisfied. Here's Bridge Guy. The man is heard telling the girls down the hill. So the tip line was set up based on that. Various people came forward and they described the man that they saw. The 4 girls saw the man near the entrance to the Freedom Trail. Betsy Blair saw the man standing out on the platform. She thought it was Bridge Guy because he was wearing the same clothes. Then we have Sarah Carbaugh, who saw, according to her initial statement, a muddy man wearing a tan coat walking west towards town. So warrant is based on these different individuals and the idea that they all saw the same man. So that is going to be fleshed out further on down into the brief. Then 5.5 years later, we just kind of skip through time. That's all we have to work with at this point. There were several descriptions of a guy on the bridge. Then 5.5 years later, they rediscovered the tip. Not a whole lot of detail about how that happened, but that's because it's not really relevant to their issues on appeal. So he called and said he was on the bridge between maybe 1 and 3, saw 3 girls, shared all of his information. They started investigating. He said he saw 3 girls, but they believed that, 4 girls saw him. That the man that the 4 girls saw was Bridge Guy. So the question is going to be, was he the same guy? The 3 girls he saw, really the 4 girls that claim that they saw Bridge Guy. He was still in the same place. They showed up 5.5 years later. He agreed to talk to them. He patiently answered questions. He was cooperative. Explained after spending the morning with his mom, he went home to get a jacket, then went to the trails, walked out to the first platform, looked at the fish, and then walked back. He came forward after law enforcement had asked to speak with anyone who had been on the trail. I couldn't catch it. So he was interviewed by the DNR officer in the parking lot. So this now is our tie-in with that interviewed in the parking lot. So said he was on the trail between noon and 1:30 or 1:45. Now we already have the time discrepancy, right? 1 to 3 versus noon and 1:30 or 1:45. He could only recall seeing 3 girls leaving the trail, so not 4. He didn't remember what car he drove or what clothes he wore. He remembered wearing blue jeans and a jacket, did not remember what kind of a jacket, could have been wearing tennis shoes, could have been in a sweatshirt, could have been in a hoodie, could have been in a fleece, could have been a Carhartt, could have been not a Carhartt. And so, we remember this. This is the Mullen interrogation. I remember it very well. And they, start, let us just go ahead and go through your phone. Why don't you give us your phone and we'll just extract your phone, make sure there's nothing there. And he's like, yeah, I'm not sure I want to do that. So expressed concern they were making him somebody's fall guy by trying to fit pieces together that do not fit to close the case. That's his view, and the appellate attorneys want the court to think he was right about that, right? State had to build this case against Richard Allen. So they had to fit the pieces together that do not fit in order to close the case. So he was bothered by the time that had passed. They became more confrontational. They didn't like that they were contacting his wife and daughter. He consistently denies any kind of involvement. They accused Allen of admitting he wore the same clothes, and he corrected them, reminding them that he said he could have been wearing a sweatshirt. He is not, he handled this interrogation very well. I remember that so clearly. He did not let them, suggest things to him or slip him up or gaslight him, tell him that he said things that he hadn't said. To him, it didn't even look like Bridge Guy was wearing a Carhartt. It's so unclear, that photo. It's so unclear. It could be a windbreaker. Like it's hard to tell. So good luck finding anything that points to that. Telling them, arrest me or take me home. They would not stop. Allen eventually had to get up and walk out to end the interview. Now, they spent a lot of time on these facts, and these facts are really not particularly relevant to the legal issues, right? They're not challenging this interrogation. They're not arguing that, because of this, he said something that they're trying to use against him. You going to come up here, sweetie? You can go ahead and come up if you want. Too exciting down there. So, you know, a lot of times you might just leave this out because it doesn't really matter. And you remember the words, you got your word limits. So you got to prioritize. What am I saying? And what am I not saying? So this is not technically critical for them to have in here. They could have just said police interrogated him and he denied it repeatedly. But they made that commitment to the court that this case was constructed, right? This case was constructed. And so that to me is why they have gone to the trouble of putting this in, even though these facts are never going to be used to support any legal argument that they're making for an assignment of error. This is part of the storytelling that they're doing about the case. They're showing us, you know, I told you they constructed it. Now I'm going to show you how that played out because he denied it repeatedly. They kept trying to put words in his mouth. He kept pointing out how that didn't fit, and they wouldn't listen to him. They were determined to pin it on him and had to fit things together that didn't fit in order to get there. Now, I really like what they did here. The story Detective Liggett told to the judge. They do it later on in the brief too, with the stuff the jury heard, the stuff the jury did not hear. So here's what Liggett told. Here's what Liggett told them. This is going to put it in context and frame it for the court. If you were the judge that was handed this search warrant application, here's what they would have told you that the evidence was. So he said, Allen's the last person to have contact with the girls. He's the individual depicted on the Monon High Bridge Trail. He reasoned that Allen admitted he was wearing a blue jacket and a head covering like Bridge Guy, was on the trail bridge around the time, and that everybody saw a man, and implied that they all saw the same man because they similarly described his jacket. And that would be important, right? If they all see the same man and they all believe this man is Bridge Guy, if they're describing all different people, then, well, that's not very helpful. You haven't gotten any closer to identifying who Bridge Guy is. Detective Liggett concluded that Allen drove his black 2016 Ford Focus and parked at the old CPS building based on witnesses that saw a car backed into a parking spot at the CPS building. They felt that the car driver was trying to conceal the license. Wilson said the car was a purple PT Cruiser or small SUV type. Blair and Wilson drew a diagram and had the video they saw parked in the same general area and manner. So this is everything, right, that the defense has summarized as far as the contents of the probable cause affidavit, the parts that would lead the judge to think, hey, maybe a possibility that this guy is involved. Because that's your standard with a search warrant, is your probable cause to believe evidence of a crime is going to be found in this particular location. So if he's Bridge Guy, we might find evidence that he's Bridge Guy. And that's the basis for getting into his home. Now, the part of the story he did not tell the judge. I love how they point and counterpoint this. Because I think it's a very powerful way of just getting the court's attention, really getting the court's attention. It's easy to understand, you know, as long as they're not like misrepresenting what's in the probable cause affidavit, they're not leaving out stuff, you know, that is that's a significant contribution to probable cause, for example, and they're not really contributing to that. But they're not at this point in the investigation. Remember, there's basically nothing. There's the circumstances of the timing, the car, and what he said during that interview, which was not a whole lot. So now here's what they did not tell the judge. Didn't tell the judge that the descriptions didn't match, that nobody matched Richard Allen, but they didn't even match each other. So Betsy Blair described the man, white, 20, medium build, brown, curly hair, and prepared this sketch. We've seen this sketch before. He had a beautiful visage, I think the description was radiant, something like that. Very young and attractive. Renewed that description in 2019. Youthful, boyish, in his 20s to early 30s, no facial hair. At the time of the murders, Allen was 44 years old, 5'6", and had very short hair. And we had the photograph from him. The thumbnail, we had several that the state introduced into evidence that they seized from his home for the sole purpose of being able to show these were photos of what he looked like right about in this time frame. He's a little bit on the chubby side there. He's, his hair is shaved, pretty much bald. He's got facial hair. I used that photo in the thumbnail of him and Kathy. That's one of these photos from this time frame. So that's what he looked like. Doesn't look like this guy. Doesn't have hair like that. Nothing like that at all. And they're going with 5'6" because that's on. It's in, I forget which one, if it was the fishing license or the driver's license or whatever. But I'm telling you guys, he's not no, he's not 5'6". He's 5'4" on his tiptoes. I mean, the man is very, very small. Blair's description of the Audley Park's car did not match Allen's. She described it as resembling a 1965 Ford Comet, as having the sharper angles. So Liggett didn't mention any of this. He didn't mention that the car that she saw doesn't fit the description of Richard Allen's Ford Focus. Here is the profile of his Ford Focus. Here is the profile of the car that she saw. Those things do not match. She said the Audley Park car was a nondescript color, but not black. His car, as you can see here, is black. So again, painting the story of the omissions, the things he didn't tell. And by doing that, we are now continuing to emphasize this point we made at the very beginning. This was all constructed. They had to build this against him. And the only way they could do that was through deception and by not showing so much of what the evidence was, because, these things kind of tend to undermine the conclusion that Richard Allen was the guy that they were looking for. He omitted that Blair told him the man Carbaugh described walking down the road is not the same man she saw on the bridge. So if they're both describing bridge guy, they saw different people, because this guy is not the same person as this guy. We can see with our own eyeballs, those are not the same people. So Sarah Carbaugh described somebody different. And in fact, ISP themselves issued a press release where they said, these are not the same people. These aren't the same people. They're both people of interest, but they're not the same people. And that Blair's sketch is the person captured in Libby's cell phone, the bridge guy. So the young guy is bridge guy, not this guy. But they're not the same guy. Detective Liggett also made false statements in the affidavit. He claimed an interview was done of Sarah Carbaugh in 2017 where she saw a man wearing a blue-colored jacket and was muddy and bloody. But in her 2017 interview, Carbaugh did not describe the man as bloody, only as muddy, and she said he was wearing a tan jacket. Sarah Carbaugh's description of the man that she saw evolved significantly over time. I don't remember offhand now what the timing was of all of the different interviews. And so this, I don't know if this is going to be an issue or not, because by the time they're getting the search warrant, of course, it's all the way up in 2022. And so if she's, been led to, are you sure it's not blue jacket and also bloody, kind of thing by that point, that's one thing. But if she has already come up with that, then, including it in the affidavit isn't necessarily dishonest. It would just be potentially misleading not to point out that wasn't how she initially described him. So they don't ever talk about the way that Sarah Carbaugh's identification, her description of the man that she saw evolved. So that might be just a little bit of an issue when it comes to that particular argument. Allen never said he was wearing a blue Carhartt. Detective Liggett falsely said he was wearing a blue or black Carhartt with a hood and head covering, but in fact, he told them specifically he didn't know what he was wearing. It could have been a Carhartt, it could have been a sweatshirt, could have been a skull cap in his pocket. And Ellen's wife said he had a blue Carhartt in 2022. He left out that she said Ellen purchased that coat a couple of years ago, which seems to be probably more recently than 5 years previously in 2017. So all of the things that he left out, that he put in that were not true, such as the things that Allen said, such as how Sarah Carbaugh at least initially described the person that she saw, and then the things that he didn't mention, the ways that it didn't fit, the fact that Betsy Blair's description doesn't fit with Sarah Carbaugh's, and even ISP knew that, and even they didn't think it was the same guy for a long period of time. The car doesn't match, and Betsy's description that they think is Bridge Guy, at least at one point they thought that was Bridge Guy, and he seems the most likely candidate to be Bridge Guy because he was the one seen on the bridge. He doesn't fit Richard Allen's descriptions. All that stuff gets left out of the search warrant affidavit. So based on what they got, they issued the warrant. They seized the Sig Sauer gun, knives, Carhartt type jacket, casings, and these items featured prominently during his trial. So now we get into the bullet, right? Because that's how they got really to the next step: the gun, the bullet, the casings. So the background at the scene, they had found the unfired .40 caliber Smith & Wesson cartridge near Libby's right ankle. Melissa Oberg did her bullshit analysis where she couldn't compare it. She couldn't find anything that Richard Allen's gun did when she treated the bullet the way the bullet found at the scene had been treated. So she treated it differently and then said it matched. And that, of course, became a big piece of their evidence. So they did that, of course, also very quickly, right? They signed the warrant. They didn't give us the date, but it was, October 22nd, 23rd, something like that, 24th. And within days, Melissa Oberg has figured out how to make this match. So then they interrogate him again. This was the Detective Holman one. It's not real fun or pleasant to watch. And once again, he continued to deny any involvement. He denied that the bullet from the scene was from his gun. Holman even claimed the methodology was scientific and like fingerprints. He said it was like a paternity test. He said it was like as reliable as a paternity test, which is like, even when done correctly, appropriately, the way that the AFT methodology says to do, it's not a paternity test. And I just can't even think that any of them, if they're being honest at all, would ever even describe it like that. But maybe the qualifier there says everything we need to know. It's like fingerprints. But he consistently said, don't know what happened. Can't tell you. I didn't do it. And all of these lies Detective Holman told him, the expert identifies you. You've been seen on video. Your voice has been seen on video. Allen is not. He's not buying it. He's not going along with it. It didn't happen. I don't care how stressed out I get. I'm not going to admit to something I had nothing to do with. This again, remember, he's not challenging this interrogation or anything that was said during this interrogation. None of these facts are going to come into the analysis of the legal issues. There's no argument that he's presenting that depends on these facts. And so it just really, again, underscores the importance that the appellate attorneys are placing on the story of how this was constructed, how it was predicated on dishonesty, and also just, I mean, potentially just showing them the context so that they can see, judges, you've looked at hundreds, if not thousands of cases like this. You've looked at hundreds, if not thousands of interrogations. You've seen how the evidence has, hi, sweetie. You've seen how the evidence has kind of turned out in those different contexts. So you've seen what people who are lying or making excuses in an interrogation, or just coming up with stuff. You've seen what that looks like. How people that are lying, handle a situation, or how people who really are guilty, how they respond under these types of circumstances. And what I would say from the many, many times I've seen it is that the most common reaction when somebody is really guilty, but they're getting leaned on with these types of things, is they explain. They like to explain, and they will come up. Let's not chew on that, kitty. They come up with all kinds of different explanations for why things are, or why things, could be. And sometimes they're just not, sometimes they're like remarkably unbelievable. I just have a hard time comprehending, like, you really thought that was going to be a viable explanation. It's like the "they're not my pants," kind of explanation. Oh, what's this crack pipe in your pants? Oh, they're not my pants. Like, literally nobody buys that. But people say it all the time because they feel caught, but there's not really anywhere else to go with it. So what you don't routinely see is that's not a crack pipe, or just flat denial, repeated denial over and over and over, especially when they're, presenting stuff to you. If you did it, you suspect that they might have stuff. And part of what you're doing in this interrogation is trying to figure out, what do they have against me? So that I can try to get ahead of it, and I can try to make it go away, or I can try to get a witness who will say that's not right, or I can try to explain it. It's a real back and forth that you see with that type of interrogation with a guilty person. And so you just rarely see a situation where the police are saying, we have all this evidence against you, and the person is saying, no, you don't. No, you don't. All right, I got to turn this thing off. It's this thing, guys. I don't know if any of you cat people, I don't know if you can see that, but it's got this little tail, and it rolls around and like waves it at them and stuff. And so they go a little nutty with it. So it's all part of the story of trying to show, again, this one is different, judges. This one is different. You've seen a million of these cases. You've seen how they usually play out. You've seen how the people usually behave. This one is different. It's not like that. Even used his wife as an interrogation tool. And some of this may too be leading into, again, it's all going to the building, right? The building of the case. That was the commitment that was made. And how this kind of pressure that's put on him gets ratcheted up when they get into the solitary confinement point, which is where we go next. Just a few days after 50-year-old Allen was arrested for the first time in his life, he was sent to IDOC as a safekeeper, in irony quotes. I'm sure it's not irony quotes, but I see them that way. Irony quotes, as a safekeeper. He was transferred to the WCU, max security unit, for the worst of the worst. The movies refer to it as the hole. It's the hole. Dropping in like what the movies say about things, it's there in the trial record, so you can. I mean, you might as well. Somebody went along with that description of it. But it's being a little bit literary, it's being descriptive in a way to try to get you to visualize what it is that we're talking about here. This is not, oh, just he went to a prison and he went to a normal cell block or something like that. He went to the hole. So in your mind, you instantly go to like, oh, the Green Mile, or when, in Shawshank, when Andy Dufresne was thrown in the hole, the movies. Which movie do you get in your mind when you think about being in the hole? Maybe Batman, when Christian Bale was Batman and he was like in that cave thing for a while. That was like a hole, not really a prison, but I don't know, similar. So inviting the judges to kind of imagine for themselves based on what you've seen in the movies. He was the first safekeeper in any IDOC's employee's memory to be placed in the WCU. They're normally in the mental health unit. They knew he had major depressive disorder and was hospitalized in 2019 for suicidal ideation. He had a D mental health code, the most severe. And so he got these psychologist visits. And during those visits, he was shackled, treated like an animal, separated from the psychologist. No face-to-face interaction unless shackled or separated by bars, restrained in this degrading, guilt presumptive type of way. Other West Mill inmates, people who had been actually convicted of crimes, lived in the dorm, walked around freely, watch TV, do all the things, work out, do all the things that that the homies do on the block. But not Richard Allen. He got the hole without having any criminal history whatsoever. Placed in the strip cell, nothing in it but the bare necessities. A camera, a mattress on a concrete slab, and a bug infestation with a view of a razor wire fence. Meals passed through a door slot. He doesn't even get the companionship of going to the cafeteria with your tray, getting your meal on the tray and having the common meal with the other folks in prison. Eats alone by himself. Had the suicide companions, recorded 24/7, guards filming his showers, his movements, his attorney meetings. IDOC knew solitary confinement could worsen his MDD and even cause psychosis, and their policy restricts the time inmates with serious mental illness can stay in solitary to 30 days, but they didn't apply that policy to him, and he remains in the most secure solitary cell in WCU for 13 months. This is a very concise, I think, and just direct way of being able to communicate to the court kind of what is coming when we get to this part of the argument. They knew. How do they know? Well, because of this whole IPAS lawsuit and the settlement and so forth. They already knew this. So this was completely foreseeable at a bare minimum, if not potentially a little bit purposeful. So then the decompensation that they describe, now we are getting into facts, right? These are very pertinent to the issues. We're going to see a lot of these come up again when they get into the legal argument. But he went from the 180 pounds to 135, psychotic and gravely disabled in a period of 5 months. From the beginning, when he got there first, he maintained his innocence, said he recognized what was happening here, trying to break me down. And tells his wife, if it becomes too much for you, call the detectives and I will tell them whatever they want to know. I was pretty sure, I didn't go back and check my notes, but I was pretty sure this was an issue at trial, because I think that's what Harshman said he said, but then you can actually listen to the phone call and he says, I'll tell them whatever they want to hear. Pretty sure that was an issue. And if that is the case, if it's in the record where he said, I'll tell them whatever they want to hear, I probably would have gone with that, So I'm not quite sure what the thought process is behind, using this formulation of it, the Harshman formulation of it, because this sounds more incriminating, doesn't it? It sounds like he does have something that he knows to be able to tell them. But I'll tell them whatever they want to hear is something quite different. By January 26, he was becoming paranoid, a prodromal symptom of psychosis. And then by the time of late March and early April, when he was receiving his discovery, his behavior suddenly worsened. The guards described him as acting up. He was doing all of these things, acted like he was from medieval times, ripped his mail, all of the stuff that's not very pleasant at all. From early April, video showed him extremely thin, frightened, bleeding, shaking, contorting, and interacting with non-existent stimuli, pacing back and forth, eating his Bible, hitting his head on the door. April 12th, things are getting quite worse. By the 13th, it's dire. So now he's found very psychotic, hallucinating, and incompetent to consent to treatment. So by April 14th, they decide we're going to involuntarily medicate him. He's gravely disabled. And so they give him the Haldol, but it produced minimal improvement. He continued to have these, behavioral and internal dysfunction that was going on. So April 23rd, he's, still doing the feces thing. Symptoms continued through May. On May 3rd, Walla diagnosed him with a brief psychotic disorder, but no delusions or hallucinations. On May 25th, his shot was still not working. This is when he did the, he was banging his head on the door. Next day, he had 2 black eyes. And on June 5th, he got another 30-day emergent Haldol injection. Then there's another part of the record that says he got another one on June 16th. That's a lot. That's a lot of Haldol, right? If it's a 30-day injection, you got one on June 5th, you're getting another one 11 days later. I got to wonder if that's on purpose or was that an oversight? I don't know. Did somebody just read the records wrong? I don't know. But, continuing to give him the Haldol. On June 20th, still after this, potentially third shot, he's catatonic and extremely skinny. The same day, Dr. Martin claimed Allen was coherent, oriented, not psychotic, and had been free of psychosis for 7 weeks, returning to baseline on May 2nd. May 2nd, way back here. Way back here. May 3rd, Wall is saying he's psychotic, diagnosed him with psychotic. May 25th, he's still showing the symptoms, and so forth. And of course, he's still getting the injections in the meantime, but had returned to baseline back on May 2nd, according to Dr. Martin. Now the story of the confessions. I really like this, how they just lay it out. Here's the dates: April 3rd, May 10th, May 17th, June 5th, and June 11th. Because we've just gone through the timeline of the deterioration, and all of these things fit within this description of the deterioration that the defense has given us. Now, I will say that I think there may be a little bit of an issue with this, because I remember from the trial, there were some later ones too, after he was transferred out of Westville and they took him to the other prison. There was at least one other later on, I want to say in August. And it may be a mistake to not mention that, just because we know the state is going to, they certainly did during the trial. It was part of their argument. Oh, well, he's not psychotic anymore. Everyone says he's normal. He's out of that environment. But here he is still confessing. It's a bad fact for the defense's argument. And so they are kind of choosing to deal with the bad fact by not acknowledging it. And I don't think that is generally wise, because it does potentially jeopardize, your credibility, but it's just handing an opportunity to the state to be able to discredit the argument you've made. They can say, look, you can just put their whole argument aside because it's predicated on this factual scenario, and that factual scenario isn't accurate because here's what isn't mentioned. So that could potentially be a problem. But otherwise, I think it's good how they do that, so that you can see, we just gave you the timeline. Here's the confessions. And now we'll get into a little bit of the substance of what he said. Maybe I did it. I think I did it. Real compelling stuff, that. Super incriminating. The one day he insisted that he killed the girls. The next day he was banging his head against the cell door. Putting it in context, I think, is quite helpful. June 5th and 11th told his wife he did it, but that he's lost his mind, is probably going to kill himself, feels like he's already in hell and doesn't understand what's happening. Now the guards. The guards report repeatedly. They hear him saying, I killed Abby and Libby, amidst bizarre behavior while these other things were going on. April 29th, he made a more specific statement to a guard claiming he killed 2 girls in Delphi with a box cutter that he stole from and left in the trash at CVS. He was going to rape them, but he panicked and killed them. They were screaming just the day before. This is end of April. This is still in the quite highly psychotic state. Now, Dr. Walla. Dr. Walla, the story of Dr. Walla. It's not going to be, they get, I think, the critical facts in here. The challenge with the Dr. Walla, and frankly with all of the witnesses, is that the judges on the Court of Appeals, so they're not going to weigh credibility. That's like one of the kind of hardline rules on appeal. It's not their job. They're not at the trial. They're not watching the people testify. They're not the kind of firsthand recipient of the testimony and so forth. So it's hard to tell the story of how awful somebody is, in a way that isn't going to potentially alienate the court, because they think that you're just trying to smear somebody and that you're trying to kind of play to their emotions and instead of to their logic. So you really have to do that from a dispassionate kind of perspective. And so I think they have accomplished that pretty well, but it's a little bit dissatisfying, I think, just for many of us who kind of watched her unfold, and I don't know, just the horrifying lack of professionalism and the callousness and so forth, the manipulation that she engaged in with him. So it doesn't really give you that emotional satisfaction, but they're limited. There's reasons why it would not be prudent to do that. So starting with April 5th, again, the early part, when he first wanted to confess to the warden, he first tells Dr. Walla, I killed Abby and Libby. I'm sorry. He had intense eye contact, bizarre smiling, and circumstantial thought. So what she's doing now is the appellate attorneys are doing now is drawing from Walla's notes, just to, again, continue to try to add to the context of what's going on when these statements are being made. Sometimes he would go off on a tangent and sometimes never return to an original topic. Dr. Walla claimed his confession was concise. So you can't say Dr. Walla is a lying scumbag. You can't say Dr. Walla is making shit up. You can't say Dr. Walla is trying to help the state get evidence against Richard Allen, and so is trying to paint these as rational and reasoned and the product of just a conscience wanting to clear itself. You can't say that, but you can kind of show it, right? And so they're going to do, they're going to do plenty of this. And this is a good example. He was going off on a tangent, but she would just characterize that in a positive way. It was concise. That makes it sound reasonable, makes it sound logical, makes it sound rational. All of these confessions about, things that weren't true, things that he didn't know. Then 2 days later is asking Dr. Walla if he had confessed. May 2nd, he's tangential. He's jumping around. He's saying all these other, strange and bizarre things. He's talking about World War III. Randomly saying methamphetamine. He loves everybody. The day before this, Walla was unable to have a meaningful conversation with him. May 3rd, confessed to following the girls. This was the detailed confession. Following the girls to the bridge when the bullet fell out. And then he said down the hill, he was going to rape them, but saw a van cross the creek, slit their throats, covered their bodies with tree branches. Also in the same conversation, he's talking about missing Easter, thinks his interactions with Walla were fake. He's paranoid about his safety. And then after summarizing this, Dr. Walla destroyed her notes. That's a good little fact to drop in there. Because it may, it may not mean anything. People do destroy their notes, if your notes are just there to kind of be a guide for you to be able to, enter the data into your system or, write a report in, a digital document or something like that. They can be duplicative, but it can also be real sus, right? So they don't tell us which one it is. They just drop it in there, By the way, she destroyed her notes. She's telling us this in what we do have, like what's in her notes that we're not getting. On May 10th, with Dr. Walla present, Allen told his wife, "I did this." This was the phone call where there's like Kathy clicks off at the end, and it sounds like Richard is still talking to somebody. This was a very sus phone call, but he's also insisting he's losing his mind, believing he's dead, water's poisoned, world would blow up if he fell asleep, that type of thing. And then finally here at the very end, yeah, she was a true crime junkie. Listen to the podcast. Research the subject. After she treated him, she posted on social media about his case. These are pretty inappropriate things. They don't come out and say, by the way, she lost her job over all this. I'm not really sure why. I mean, it could have just been a judgment call that maybe that looks like too much of a smear or something like that. But it does emphasize that if, you judges aren't clinical psychologists, you're judges. So you don't maybe know what's normal, what's ethical for a clinical psychologist to do. This would just emphasize for you that this is not normal and okay, because we're giving you facts that might give you a gut reaction, but I'm not sure that they are going to, necessarily be real swayed by that if they're kind of being asked to judge it independently outside of their own, frame of reference. So it's there in the record, and maybe they'll find it themselves. But I do kind of wonder about that choice too, to not emphasize the fact that this was problematic from an ethical standpoint. She even admitted that herself. So then the witnesses in the trial, once again, the state built its case back to this theme of it being constructed, and again, we have this breakdown. Here's what they heard, and then we'll talk about what they didn't get to hear. I find it just a very persuasive way to kind of lay out, here's what's at stake. Here's Just very simply, you can look at it, you can read through it, and you can have your gut reaction about knowing that this evidence was available and that they tried to use it. Did he get a fair shake? So the jury saw the bridge guy. They heard from the witnesses. Witnesses all believe they saw bridge guy. This is a lot of the similar testimony that we already heard. He was, 20s or 30s, brown, poofy hair, youthful or boyish appearance. Her Fitbit data placed her near the bridge at the time. So that is kind of, compelling for her from the timeline standpoint. If the guy on the bridge that she saw is bridge guy, and bridge guy is the person that killed Abby and Libby, then her description, seems pretty significant. That's not necessarily helpful to them, though, to Richard Allen, because the jury did hear that. And so for whatever reason, they decided to disregard that. Carbaugh reported seeing a muddy man in a tan coat. By trial, she claimed the man was muddy and bloody and wearing a blue jacket. So we do get in the fact that her story evolved. But the thing is that it had evolved over a series of different interviews. And that came out in the cross-examination. It grew. So I think the timeline for that could potentially be problematic on the search warrant issue, but we'll have to see. It's going to potentially be on the state to kind of go there. So then surveillance video captured the car. Prosecution argued it was his car, and that Carbaugh saw Allen walking back to his car. At trial, no eyewitness identified Allen as bridge guy. This is, to me, it's like it's so significant. Nobody identified him as bridge guy. It sounds, the way that this is written kind of sounds maybe a little bit more definitive than it is, because the problem, right, isn't that they didn't identify him. It's that nobody asked. Nobody asked them to identify if Richard Allen was bridge guy. And I have a little bit of concern about that. I'll get into that, I guess, a little bit more when we get to that point in the legal argument. But they point out, at least nobody on the stand said that's the guy I saw, and that's important. But nobody also said it's not the guy, or that, it's not the guy that I saw, which would have been super helpful to the defense, right? But nobody asked because nobody, I guess, knew what the answer was going to be. But despite that, prosecutor argued he must be bridge guy because every witness is adamant the person they saw is bridge guy. There's no doubt in their minds. And it must have been Allen, because Allen said he went out to the first platform, which is what Betsy Blair said. Never mind the problems with the timeline and, who Richard Allen reported seeing. But it's, with Richard Allen, it's one of these things where they take his word for it when they want to, right? But if they don't want to, we can just dismiss it as like he's not reliable, or he's not being honest, or whatever. So it's very self-serving in that respect, the way that the state handles the statements of the defendant. Trooper Harshman believed it was Allen's voice on the video. Yes, he did. So then they had the battle of the firearms expert. Once again, now this, if I were going to be nitpicky, this is where I might be. Because, you have your word point, your word count, and you have to prioritize, and you have to decide what to spend your time saying. And a lot of this is repetitive. And I understand why. It's because it's the same thing with Betsy Blair and Sarah Carbaugh and so forth. There was evidence that the state had at the time they went to get the warrant. And then now we're at the point of trial, and we're talking about what they're saying at the point of trial. So they are like technically like two different things that are being described. But the substance of it is a little bit repetitive. Some of this you might be able to say, she repeated what she said, in her initial report that led to the search warrant. And then to the extent there's stuff you want to add to it, you can generally do that. And, for a large, I guess to a large point, that's what she did. They didn't get too much into, repeating the fact that she compared an unfired casing to a fired one and said it was all good and stuff. So she gave an error rate, makes it sound real sciencey and real objective, and that she in fact has never been wrong, not a single time. Should be such a red flag, and yet for whatever reason seems not to be. So then the defense called their AFT expert, who said that this is not an appropriate methodology, and in any event there was no match here based on what Oberg was relying on. Then the timeline. Christopher Cecil testified regarding the movement and health data. So here's our timeline, 2:13 to 2:32 p.m. Here's the data. They are walking up to the Monon High Bridge by 2:08. By 2:18, they are on the bridge at this point. They have filmed that video, and then from 2:25 to 2:32, there's the 2 flights climbed and the final movement recorded. So the data, they argue it overlaps with him being on the trails, Allen completing the murders. There's we've gone over a million times what the problems are with this data and how this does not line up with the description that the state has given of how the crime took place and how the crime scene is configured and all of that. So we don't need to revisit that. They're not making a point out of it. There's really not a point to make out of it on appeal. It just is, I guess, one of those areas where, again, you can see the priorities, what the priorities were, because they've told us a lot of stuff that isn't critical to the issues that they're raising, but just for purposes of being able to put it in context. So they could have potentially, brought in the distance, from the point, like the, descent down the hill was however many feet to the river, and how far the crime scene was from the end of the bridge and so forth. Like some of that was in the record. They could have pointed that out to try to show it's inconsistent with the state's theory, but they didn't. And that's largely because I think the problems with the data, for the most part, they're not factoring into the appeal, and they kind of do get confusing and a little bit in the weeds. But it's just something that I noticed because, some of the things seem to be pretty obvious. Like, why are you climbing flights at this time when, you have to come down off of the bridge to get to the river, and then from the river up to the scene where the bodies were found, there's a little bit of a climb, but it's more of like a, 6 to maybe 10-foot bank. It's not a significant flight. Maybe just because it is too ambiguous. I don't know. So Allen then brings in Stacey Eldridge. She testified about the wired headphones being plugged in at 5:45 and removed at 10:32, that it would silence the phone. There was an incoming phone call that occurred moments before. So the plugging the headphones in would have silenced it. And in response, the state asked Cecil whether water damage could be responsible. And over a hearsay objection, Cecil testified he Googled it, found some unspecified non-peer-reviewed troubleshooting forums reporting that water damage or dirt within the headphone socket could mimic headphones being inserted. So it's this is a dry description, right? They're not being super colorful or dramatic or anything like that. But there is still a great big WTF that you get unspecified, non-peer reviewed, quote, Googled it, troubleshooting forums. They have done this description in a way that's factual, and yet at the same time, I think gives a good evocative, sense of what on earth even is this? What even is that? Is that supposed to be evidence? Confessed motive. So originally he had no explanation, but then while he was psychotic, he confessed and then provided these motives, says he was going to rape them, but panicked and killed them. Argued that the jury should believe his confessions, and argued that they were logical and organized, the product of free will and his newly found religion. Almost every guard testified his bizarre behavior was orchestrated. Yes, the expert prison guards, who may or may not have graduated high school, had strong opinions about malingering. One guard knew Allen was truthful in his confession because of the look in his eye. Ooh, science-y right there. They do these things for attention. Each time he confessed to Dr. Walla, she said he was not delusional. On cross, she admitted she might have been wrong and he might have been genuine. And with hindsight, she was on the fence. Now, most of this, I think, goes to the confessions far more than it goes to this header here, this confessed motive. Because they're not, other than just this brief, description of this is what he says the motive is. The rest of this is really going just to the context of, again, the things he was saying at the time and the condition that he was in, and also the kind of qualifications of these reporters to be able to offer meaningful opinions about it. They introduced all of these notes. She at times labeled him as feigning for secondary gain. The day before he was deemed gravely disabled, she wrote he could be exaggerating or consciously deteriorating. When he ate feces, she called the behavior unclear. So again, they're trying to just paint the picture of her as being inconsistent with the facts. Like, she's not reliable because you can see from these other sources what the reality of the situation is, and her description is not aligning with that, at least not in a way that I think most people would expect. So again, got the psychotic but in remission after the mid-April, back to baseline by May 2nd. Described psychotic symptoms, yet concluded he was much improved. And when either doctor acknowledged psychosis, they attributed it to factors other than solitary. Regarding his phone call confessions, they said his demeanor was calm and solemn and not under duress or stress. And he opined that Allen was acting that way for attention. Allen called Dr. Westcott. So her report showing the decompensation, all of these things that he experienced. She believed he was psychotic or delirious, and she found no evidence of malingering. Then Dr. Grassian talked about solitary confinement in particular, and the kinds of behaviors, kinds of psychological damage that can do to a person, and how what he saw in Richard Allen's behavior was consistent with what he saw from the psychosis that results from solitary confinement. Also described the false confessions and the way that you construct it out of, I think I did it, to, you got nothing else to do for 13 months, right? And there by yourself, except go over things in your head. And so you start imagining maybe how it could have happened. And then once that line has been crossed, it can reach a point to where it's accepted. So again, all of this whole section, I don't think this really has to do with confessed motive, but I think it's more detail about the context of the confessions and why they are involuntary and should be regarded as involuntary, not the product of a rational mind. I think they maybe just tried to like break it out so that that wasn't like a massively large section, with a lot of facts associated with it. I don't really have another explanation for how this is, why this is organized the way that it is. But I guess it's just how they thought maybe they wanted to break up kind of that part of the story with the confessions, come back to it, be able to emphasize it again. I'm not sure. Then getting to the detail that only the killer would know, Brad Weber claimed he left work, got to home around 2:22 to 2:27 in his white van. And the state claimed that Allen gave this detail in one of his confession to Walla about the van that he saw. And that was a detail only the killer would know. And that therefore that corroborated his confession. The murder scene was unusual and complex. Before I get to that, because remember, this is just what the jury heard. This is the stuff that the jury heard. When I first read through this, I was like, ooh, I would have maybe brought up here how there's problems with that timeline that was in the motion to correct error. But I realized, after I got through and kind of read through the whole context, and again, the way they'd broken it down, oh, this is the part that the jury heard. So it's the kind of the one downside of having it structured in that way is that you kind of are going to have to carry the details from a lot of pages that we just read here about the evidence that came out in trial. And we're going to have to kind of be able to mentally reference back to those when we get into the section on what the jury didn't hear. So it's a little bit of a trade-off, with how they've chosen to kind of lay that out. It can be helpful to have as like a point counterpoint, right? The reason to do it here would be so that the court doesn't go through this and form the impression that, oh, this is a strong case. This is strong evidence. They have that. He had a detail only the killer would know. Well, then he probably did it. And so now I don't really care anymore, about the arguments that you're raising. If you bring it up right here, there's a problem with this timeline, or there's a problem with this detail, then, you mitigate that risk maybe a little bit more, but you trade the experience, I guess, that the court, you're trying to invite the court to have, where you're experiencing this trial through what happened. But then we're going to go ahead and then experience it again through what didn't. And that kind of maybe invites a little bit more imagination about, how would that have been different? How would these impressions have come across not the same as they did when they were just, allowed to kind of be out there in isolation. So then the murder scene, yes, we did hear about the murder scene. It was unusual and complex. The diagram that's on the thumbnail is the exhibit that was admitted in court. That was a diagram that was prepared. It's, here in the brief, so we'll see it. Describing some of the details of how it took place and how the girls were found, what the situation was. Here is the diagram. The weird sticks, the sticks that the state has explained were there to conceal them, but nothing is really concealed. One person is clothed, one person is not clothed, one person has been moved. It's unusual. The sticks were deliberately arranged, covering no more than 3% of their bodies. Yeah, this, if you just like threw a handful of sticks on somebody or something like that, you would not expect them to land in these types of patterns. right? You wouldn't expect them to be like stacked on each other and stuff. Why are you putting sticks on a blood puddle? I will never understand why that could, even with a straight face, be put out as like trying to conceal things. The blood pattern on Abby's hands was noteworthy. It was so noteworthy to me. You know, seeing the photos, her hands were pristine. They were pristine. They were so clean. Libby's were not, Abby's were not. The blood spatter expert said he had never seen clean hands and sleeves in a case involving this amount of blood loss, because, as he describes, it's instinctive that you do that. You have a major wound, it's instinctive to reach for it. It could be consistent with unconsciousness or restraint, but there's no indication of that. There's no bruising, there's no ligature, there's nothing that suggests she was restrained or held or anything like that. The blood patterns flowing upward over their chin and faces, very important detail, because it's not consistent with the position in which they were found. They're found flat on your back. Blood's going to flow, you know, according to gravity. But gravity acted in a different way, and that tells you about the position in their bodies when that bleeding was taking place. So it was clear that the bodies were lifted at some point in a position where the neck was higher than the chin. So you are upside down. There was a notable blood pattern on a tree. The F tree. This is what the F tree looked like. Now, of course, they're going to describe, the state explain this as it's just transfer. You know, she leaned on it with her arm or something like that. I don't buy this for a second. Look at this sharp angle. Look at this sharp angle. Like, I'm not buying it. That's, I mean, look at, you can see here's a 90 degree. It's a sharp angle. It's not like a smear or something that rounded or something like that, a more organic type of shape. But that's the F tree. So that is a detail of the scene. No physical evidence of sexual assault. That was correct. No DNA from Allen, despite all of these testing that they did. Never found any of his DNA. So the state had this theory of, you know, how Allen did this, why he did. I mean, not really why he did it, because they never explained that. They never really explained, like, why would he have done any of this other than the sticks being camouflage, which just, you know, it should be obviously contradicted by the diagram itself. But couldn't explain. They suggest it was moving Libby that would have made the blood flow. Maybe, but they don't have that same explanation for Abby. Don't have any explanation for why Abby was dressed in Libby's clothes. None of that. The pathologist, quote, speculated, I like that quote, that a single blade such as a box cutter caused all of the injuries, including a scallop mark on one of the wounds. Blood stain was just a transfer from the arm as she propped herself against the tree. I'm trying to, I guess, imagine are you trying to say it's this? You would think if they're saying it's a transfer from the arm that, you know, you might be able to find material transfer, right? The bark from the tree. That's the principle of forensics, isn't it? That when things come into contact, they will leave traces of each other. So if her blood is on the tree, then some of the tree should be where her blood came from. It should be on the arm. Doubt anybody looked for anything like that. You know, you prop yourself up, but like, don't get any abrasions either. Like, wouldn't you expect you get like at least a little bit of abrasion from leaning up against a bunch of tree bark? I don't know. A female hair and multiple incomplete profiles were seen contamination or background DNA from the girls sharing clothes or through incidental contact with the people they knew, because this is the only case in history where the state has explained all of the DNA is just from environmental transfer. That's it. Nothing to see here. Nothing to see here. The manner, quality, and thoroughness of the investigation. We're still at what the jury has heard and not what they didn't hear. So they heard about the investigation from the day the girls went missing to a few days later when he met with Allen, when he met with Doolin, and then jumped forward 5.5 years and heard nothing about what was going on in the meantime. So just pointing out the absence at this point. Because it's going to be, of course, significant to their argument about what the jury should have heard. So then he's convicted, he appeals, and now we get to what the jury did not hear. So now, because of how this is organized, we can go back to Bridge Guy. We can go back to Bridge Guy for what the jury heard. We can look at Bridge Guy, what the jury did not hear. Jury didn't see the sketch, didn't see Betsy's sketch. Doesn't look like Allen. Doesn't look like him at the time. Doesn't look like him at trial. Doesn't fit the description. Not him. Blair rated it as a 10 out of 10 for accuracy. Insisted she could identify Bridge Guy if she saw him again. It really makes me wish they'd asked her. This guy that you see here, is it Bridge Guy? Nor did the jury hear that Blair, and at one point the ISP believed the man she saw was not the man Carbaugh saw. She saw, Betsy was shown Carbaugh's sketch and said, I think it's wrong. So she doesn't agree with that description. Jury didn't get to hear that. So they're left with the conclusion they saw the same person. They didn't get the details they would need to know otherwise. The jury never heard that firearm and tool mark evidence is flawed and unscientific. This was the William Tobin. He was the critic of the methodology, the conclusions that they reached from it. He's a forensic metallurgist, had the PhD, background in statistics, familiar with these criticisms, the PCAST report. He reviewed Oberg's work and was prepared to explain the flaws in the methodology. He's been an expert many times, over 297 cases. That must be like from his CE or CV or something like that. So it's very specific. 297. Jury confessed motive. Okay, remember this is how they broke it up. So the jury never heard Allen's confused, disjointed ramblings and screams during the months that Dr. Wallace said he was making logical and organized confessions. They permitted him to play 15 videos of him in solitary to impeach his confessions, but required him to mute them. So because of that, here's context that they didn't get to hear. Scream for dad, yelled Roger. Marvin, wait for it. Begged to be put on an airplane, told them not to believe his last confession. The inmate yelling, "Kill yourself, Richard Allen." This corroborates what the defense had described as kind of part of the environment, the torturous environment and what was happening, the way that the other inmates were screaming at him, yelling at him, threatening him, stuff like that. April 17th, when he's being transported, he's saying things that don't make a lot of sense. He is clearly in a great deal of distress. The guard is talking about how long the feces has been on him. He seemed confused during this haircut on April 21st. His answer is kind of non-responsive. It's not a logical answer to the question. The shower transport, again, he's distressed, make it painless, wants to be euthanized, making claims about who he is, stuff like that. June 20th, showing his catatonia and what the medical professionals are talking to him about and not talking to him about. And this is really important to them because they are telling the court specifically, please watch these. Please watch these. They think these are really, really significant to the point we're going to ask you real clearly. Don't just take our word for it. Watch the videos and listen to them. Then there was the 3 phone calls on April 3rd. The first call where he says he's losing his mind. I would never do anything like this. I'm being tortured. And then right about 2 hours later when he calls his wife and I think I did it. Maybe I did it. Couldn't remember what he told his dad 2 hours later. And then 3.5 hours later, calls his wife again. Not sure if his original call was a dream. Not sure what's going on. He's not drinking the water or the coffee. Thinks they have drugs in him and stuff. And all the jury heard was the second part. I think I did it. Maybe I did. Maybe I did do it. And Trooper Harshman getting to opine, oh, he's totally fine. No duress or stress. And they didn't get to impeach him with the context that would let the jury be able to evaluate his opinion about that. A detail only the killer would know. Jury never heard that this could not have happened because they had video showing his van getting home 25 minutes after the phone stopped moving, after the pause in the movement, and 15 minutes after it stopped moving. So it wouldn't have interrupted according to their timeline because the crime would have already been completed by the time the van was getting home, specifically as on security camera, and then the report prepared by the FBI confirming he arrived home at 2:50. Also never heard that he provided details. He confessed details that were wrong, including that he said he shot the girls because Dr. Gracian wasn't allowed to bring up one of the hallmarks of, providing false confessions in this psychosis induced by solitary confinement, including the facts that he got wrong. And it's super common in the false confessions. They'll keep trying, they'll put out a version. And is that it? No. Okay. Try something else. Is that it? And it becomes this dance where the interrogator, knows where they want him to end up and is like able to figure out how to kind of nudge him there without being too suggestive. Sometimes they will just be super suggestive, but getting the facts wrong is, that's kind of important, kind of goes to the reliability of what it is that you're saying. The alternative exculpatory explanation of the scene. The jury never heard that the investigators thought this was related to Odinism. The investigators came up with that theory and they investigated it and they came up with evidence that the scene had textbook features of it. There was always a discussion that it had these types of features. They brought in the FBI's BAU about pagan rituals. BAU says we're not going to exclude. This is a plausible explanation. Maybe it doesn't fit squarely within what we normally see, but it's possible a new believer or a rogue believer, somebody who might be like mimicking it or something like that, is involved. A Purdue professor also consulted law enforcement, found it quite plausible that the sticks were inspired by Norse runes. They consulted with an undercover ISP trooper regarding these things. The sticks and the blood stain on the tree. Officer, because of his undercover work, was familiar with this type of thing. He agreed blood on the tree looks like a Fehu rune. And there were similarities between the stick formations and pagan bind runes. Alternative explanation to camouflaging them with sticks that don't cover anything at all. And then the defense as well consulted with Dawn. I don't know how to say her name, but Perimeter. I'm not sure. Anyway, she found these 7 features of the Norse pagan ritual. The location, it was outside in a clearing near a creek. It's in the right place. It's occurring on a Norse holiday, one that's incidentally related to Odin's son. Involve a knife or a ceremonial knife. Involve symbolism at the scene, including arranging natural objects in a specific way, like sticks and runes or blooding the runes, and that these are part of the magical thinking. Difficult to explain the sticks as hiding the bodies because they're not actually hiding anything. They aren't functioning like that. And, I keep coming back to, if you wanted to hide the bodies, there are like at least 6 inches to a foot of leaf litter on the ground in this clearing that you could just kick over them. You could just put leaves over them. And then, if you're looking from a distance, what are you going to see? You're going to see a mound on the ground, a leaf mound. It's going to be nondescript. It's going to be indistinct. It could be a rock. It could be nothing. It could be a shape in the ground. It'd be extremely easy to hide the girls with all of the leaves that are in the area, but they didn't do that. So the sticks look like these different types of runes. The manner of death, consistent, often involves blood loss and torture. The body arrangement is significant because it's got the upside down, the Abby's posture looks like the hanging man symbolism, like Odin. And this is an Odin related holiday, right? Odin's son. Finally, there would be an unusual blood pattern, and that's consistent with the F tree and the Fehu rune. So seven features the jury never heard about, that these things might explain some of the bizarreness here that doesn't really get accounted for by just a random guy deciding to do an opportunistic crime out of nowhere in the middle of the day. And this is what happens. The manner, thoroughness, and quality of the investigation. So they never heard about the errors, the bungles, how they bungled Brad Holder and Patrick Westfall because they lost evidence, mishandled interviews, and conducted a poor investigation. Because by excluding all of these names wholesale, you're not allowed to get into any of that. Then the defense wasn't able to show how maybe they should have gotten more into that they stopped looking into that without good cause. And that perhaps had they followed that road a little bit better, they might have gotten some better answers, than they have relative to the explanation that Richard Allen is who did it. So the ritual killing, several believed it was too complex for just one person. There was this discrepancy between the conditions of Abby and Libby, suggests possibly a different feeling about Abby. And of course, we know Abby had been meeting up with LH, had this secret relationship. We did not, this is a new fact I didn't know about, that on the day she was murdered, she had invited him to meet her on the trails. I don't know where this is from. I don't know if this is from like Libby's phone extraction. I would assume so. But I don't know. We haven't seen that before or heard about it before. He had school, so he declined. And who is he? Oh, he's the son of Brad Holder. Who's Brad Holder? Brad Holder, father of AW's boyfriend, promising alternate suspects. So they have a connection with Abby. Abby is treated differently. Abby is dating Brad Holder's son. So when they're looking for the girls on February 14th, learned about the secret relationship, they went and pulled him out of class, searched his phone, and he texted his father, "She's missing." We'd love to know what Brad texted back, wouldn't we? I know Allie and Bob were talking about that the other day, I think yesterday when they were streaming. I could not agree more. I would really love to know what the answer is. They suspect there's no answer. I also suspect there's no answer, but I'd like to know how that fits in the pattern of their communications. Did he usually answer? Would it be common for something like this to just kind of go unsaid? Did police, contact Brad at any point? How did their contact with Brad play in with, this interaction with Logan? I would have liked to have seen how all that unfolded. Lost and missing interviews. They interviewed both Logan and Brad. They already suspected the murder involved a pagan ritual. Holder admitted he's involved in a pagan tribe. He does these rituals every weekend in Delphi with Patrick Westphal and a bunch of other people. And gosh, they do animal sacrifice and human bloodletting. He knew about the relationship, but denied ever meeting Abby. They recorded over their copy of the interview. So all they have is a one-page narrative of what was said. And according to that, he admitted he owned a .40 caliber Smith & Wesson, but they never asked for it, never collected it. Also, never got his cell phone. Starting to see the comparison between this and Richard Allen, aren't we? They're trying to get Richard Allen's cell phone from the very first interview, when all they have is he admitted being out at the trail, probably in kind of this time period. But apparently did they even ask? I don't know. Then they interviewed Westphal, didn't record that one, have a 5-paragraph narrative. According to that narrative, he knew the woods very well, so he's familiar with the crime scene. Denies ever meeting the girls, but knew them. So how did you know them? How do you know these random girls from the community if you had never met them? He's the religious leader. No indication they ever asked him if he's got a gun, and they did not search his phone at that time. Did they search it later? When asked for an alibi, Westphal claims he's at home with his minor son, and Holder told the officers he was at work at the Liberty landfill. So this is presumably why they were cleared, right? They were cleared because if they have alibis, they couldn't have done it, no matter how promising they might otherwise look as suspects, because they have actual connections with the victim. They may have knowledge that they were going to be out at the bridge, right? If Abby is asking Logan to meet her at the bridge, possible Logan communicates that to Brad, and now Brad knows that they're out in the woods, they're out at the bridge. So they would have the opportunity, the foreknowledge of where to find them. The different treatment of Abby. Why would she be treated differently than Libby? Well, maybe you feel a little bad because it's your son's girlfriend. Explanation for that, and then just all the Odinist stuff. So here's what they did to investigate the alibi. Back in 2017, in April, they went out and spoke to the employee who just showed them the printout showing Holder swiped off of work at 2:45. They invited the officers to review the video to confirm it, but they declined. That was it. Didn't interview anybody else. Marked him as cleared based on the printout showing he swiped out of work at 2:45. Tipsters continue to identify Holder as bridge guy. Contrary to Richard Allen, not a single person ever called the tip line and said, we think that guy at CBS is bridge guy. But Holder, they did. Repeatedly. He posts half-dead women and shows fascination with symbols out of tree branches. Check the father of one of the girl's boyfriends. He fits the description. Every time it came in, nobody does any follow-up. They just treated it as already cleared. Sometime around March 2017, Detective Purdy interviewed Holder to get his assistance in connecting the murders to Norse paganism. A month. Maybe less than a month. After the murders? Before. They have confirmed his alibi, which I, do with the irony quotes. They hadn't even gone and checked if he was where he said he was. And they're using him as their witness because he wasn't a suspect. He was a suspect. How is he not a suspect at this point in time? You've interviewed him. His son's got the connections. And you haven't checked out his alibi. This is wild. I hadn't heard that before. I don't know if that was already out there, but I guess it was. It says it's from the trial transcript. Maybe it was at a sidebar or something. I'm really not sure. But that is just crazy to me to hear. They declined to re-interview, despite reports he is posting pictures of young girls believed to be deceased with sticks placed over their bodies. Yeah, his Facebook posts, which are alarming. Could have put those in here like they have some of the other visual stuff. It might have been worth it. Might have been worth the space to do that. I'm really not sure. I guess it's a trade-off. If you think they're really, really similar, you would probably post them. But you might have to make a decision about leaving out something else if you're going to put that in. Also noted a similarity between his bind rune on his hand and the stick formation on AW. He took these two runes and put them together, and he made a bind rune, and that's what Dawn Perlmutter had said. That stick formation on Libby looks like a bind rune. So this investigator Trooper Winters, recommended that they investigate him further, but they never did. They said his alibi was cleared by the FBI. So every time this comes in, they're just like cleared. He didn't like that, want them to do more, but they didn't. In 2018, he paints Odin in the hanging man position, just like Abby's posture. And also, look, a red Fehu rune. I'm sure that's a remarkable coincidence. They found other social media postings that mimic the crime scene, but nobody ever did anything about it until Allen gets charged and the defense team insists that they be re-examined. So law enforcement goes back and interviews Holder again. And now his story has changed. Normally, this is the type of thing that police get suspicious about. They'll call it out specifically. They'll sometimes even kind of manufacture it. The structure of the read technique is, I invite you to tell me the story, and then I invite you to tell me again in more detail. And then, we might talk about like follow up on some of these details you provided. And so it's really common for, your second, third, fourth recounting to be more detailed than your initial one. And that can sometimes be cast as, oh, it's a change. When he first said it, he just said this, but then he started adding all these details, omit the fact that they literally asked you to do that. So normally this gets suspicion when stories are not consistent. So back in 2017, he never met AW, but in August 2023, he said he met her once. And then in a 2024 deposition, he said he met her 2 times, including at Patrick Westfall's house shortly before she was murdered. I'd love to know how shortly before. How shortly before? Minutes? Hours? Or days or weeks? Exactly how short are we talking about? Significant there too, because it contradicts Westfall, doesn't it? He said he doesn't know, he knows who they are, but he's never met them, but they've been at your house. Abby's been at your house. Questions. Law enforcement finally examined Westfall's alibi in August of 2023, 5 years later, 6 years later. Westfall's son could not remember if he was home. Hardly surprising. This time they collected his phone, but he deleted data before turning it over. Another thing that's usually suspicious, consciousness of guilt, concealing evidence, that If you didn't do anything wrong, there shouldn't be anything incriminating in it, right? Then they deposed the Liberty landfill employee in April of 2024. The shifts were from 5 a.m. to 1:30 and a second one from 7 to 3:30. And Holder was scheduled to work the shift that ends at 1:30, not 2:45 when he clocked out. But his badge swiped out during the second shift. So hour and 15 minutes later, not sure why he's still there, what he's still doing. Nobody bothered to interview any of the other employees or anything like that. He also didn't have sole custody of his badge. They just keep these badges out on a rack with the name prominently displayed where anybody can grab them and swipe each other in and out. And the employee even acknowledges if somebody left when they were supposed to, but someone else clocked that person out for an hour or so later, would that be known? No. Nope, they would never know. I guess unless you looked at the video, which is probably long gone by now. So they had the motion on the state's motion to exclude the third-party evidence in July of 2024. And at that hearing, Holder's wife testified that in 2018, he told her he had a fight with Westfall because Westfall wanted to up from animal slaughter to a different type of sacrifice. That seems kind of incriminating, doesn't it? What's up from animal slaughter? What's up from that? And she testified that Holder claimed that Westfall killed Abby with others and that she needed to keep her mouth shut about it. Did they follow up with any of that? Did they ever go ask Holder about that? Doesn't seem like it. Doesn't seem like they followed up with him in 2018. So now we get to the argument. That's the facts. That's the facts. It's kind of a strong place to leave it, isn't it? With the third-party culprit stuff that's, you know, they have like this whole other confession. I mean, it's super, super incriminating. And so leaving it at that as this is the part of the story that the jury didn't hear. You know, what's the court? As the court moves on to the argument, they're moving on to it from this. These things Holder said. The fact that their, cleared alibi was really not cleared at all. The story's been changing. They're behaving in these sketchy ways. They have all the connections with, the Odinism, the girls themselves, the knowledge. Much more explanatory power for so much of what characterizes this crime. So here we are on page 57. Page 57, just to get through the facts. So the goal here was to, like I said, leave the court feeling that something's wrong here. Something's not right. You think they've accomplished that? I think this is an excellent statement of facts. I think it's very well done. I've pointed out certain things, questions about, points where I can see it looks like there was a strategic decision that was made. Priorities always have to be weighed and things like that. I do have some questions about some possible points where it might have been better to bring in some facts that are not so good, not so helpful, because we can anticipate the state is going to bring them up, but they weren't brought up. But overall, I think they've achieved their goal of demonstrating that this is not your run-of-the-mill case. This is not your standard appeal where, the guy really did it and there's a lot of evidence that he did it, but we're going to nitpick about details and then try to kind of blow up the significance of those details. because he's got a right to trial. He's got a right to appeal, and we got to argue something. This is very distinct from that, both in the strength of the other suspects, the process, the dishonesty. They started off with the promise of the state built the case, right? This did not organically develop. They built it, and they walked us through the process of, here's how they disregarded what he said. Here's how they manipulated the evidence and the facts. They presented it in a misleading way. Then they brought in this junk science. Then they made him psychotic and relied on these confessions. And then they took it all to trial, where they told an extremely incomplete story. Up to and including all of the reasons to believe that these other people are the ones who were involved, and never Richard Allen from the very beginning. So we'll get into the argument now. So they have these summaries of what the issues are. First, the unconstitutional search. It was misrepresentations and omissions in the search warrant affidavit is the bottom line of that one. Unprecedented confinement. His confessions were involuntary and the product of grave mental disability. They were indifferent to his deterioration, violates both federal due process and Indiana's protections. And then the unfair trial, through a series of arbitrary and prejudicial rulings that crippled his ability to present a complete defense. They're presenting this in a, which I expect. They're presenting this as a constitutionalized issue. And it's something that you kind of have a little bit more leeway to do as a criminal defendant than you necessarily do if you're appealing from any other type of judgment, like in a civil case, for example. Because we're really talking about evidentiary rulings for the most part. She made evidentiary rulings, but evidentiary rulings are, the standard of review is not favorable. And so to the extent that you can kind of elevate that to being more of a constitutional magnitude, you're a little bit more likely to kind of get the court's attention, get the court's sympathy if they agree with you, and then get them to potentially moderate how they apply that standard of review in your particular case. So just this, rough description, rough outline, excluded critical inculpatory evidence, barred expert testimony, permitted inadmissible hearsay, blocked him from impeaching the credibility of his own confessions, prevented him from introducing substantial evidence of third-party guilt, and an incomplete investigation, which deprived the jury of context necessary to assess reasonable doubt, collectively violated his constitutional rights, created a fundamentally one-sided proceeding. I like this this sentence, the way that they concluded it: a new trial is constitutionally required to restore the integrity of the adversarial process. The adversarial process is key to this idea of the constitutional right to a trial, because if you have two people, it's like a boxing match, and everybody brings their goods and lays it all out on the line, and may the best man win. And so when you are forced to go in the ring with one hand tied behind your back and the other person has two, it's not a fair fight. It's not functioning as an adversarial testing process, because you're not allowed to bring your goods. So you're not meaningfully challenging the other party's side. So it's, this isn't like a strong legal thing. This is philosophical. This is principle. This is structural. This is why we do trials the way that we do. They're supposed to function in a certain way. And so when you tilt the scales, it doesn't work that way. It's emphasizing that that's what happened here. This was not an even weighing of both parties' positions. he wasn't allowed to bring. He wasn't allowed to bring anything. So his end of the scale is real light. So now let's go through and talk about the arguments and how they presented them and how they rely on them and so forth. So they start with this issue about the warrant, the unconstitutional search of his home, and if there should have been a Franks hearing based on the fact that they made a showing that Liggett omitted, materially misrepresented and omitted certain facts from his probable cause affidavit. And, because of that, you're normally supposed to have this Franks hearing, right? Where they go through and evaluate, was this false? How much of it was false? If it was false, then typically what you do is you sort of take that out of the search warrant. Or, if it was omitted, you add that into the search warrant, and then you kind of reevaluate whether there would have been probable cause to grant that warrant. And if there's not, then the fruits of that warrant are no good, supposed to be suppressed. And then you have to kind of evaluate what are the ultimate consequences of that. So the first thing I'm always thinking about when I'm thinking about assignments of error is, what is the potential remedy for this? Okay, what are we actually going to get if this is granted? And there's a couple of different ways that this one could go. In fact, they even kind of spell it out as they go through, and basically they're asking for reversal, but then in the alternative, give us a Franks hearing. It could go either way, depending on really what the court thinks about the situation and how they want to handle it. There's a little bit of a risk with an issue like this. You didn't give me a Franks hearing, that the judge can just say, okay, well, I'm going to kick it back down and you can have your Franks hearing. And that means it goes back into Judge Gull's court, and Judge Gull conducts her Franks hearing. And Judge Gull, listens to whatever ridiculous excuse that Liggett comes up with for why he wrote the affidavit the way he did. And she says, I don't believe he was misleading. Or she says, I don't believe it would have made a difference. She just does whatever she needs to do to justify what was already done, because we know that that's what she's going to do. And so then what happens? Then it goes back up on appeal. And now on appeal, you're in a different format. You're in a different appellate framework, where now you have an actual ruling that you're appealing. And how does that get reviewed? You review the facts for substantial evidence. You review the legal decisions de novo. So the interpretation of law is de novo, but the facts, you get substantial deference to the trial court. That's not really helpful, is it? It's not going to be particularly helpful. It can often be a situation where it gets remanded for hearing, and they just figure out how to fix the problem. They just figure out how to set it up the way that's going to insulate it. Like they know the assignment. They're not idiots. They know the game. So they don't really want that. I have to believe they don't actually want a Franks hearing, because it's unlikely to really get them anywhere. What they want is they want the court to look at the evidence independently and decide for themselves, hey, based on what the defense has presented, if there had been a Franks hearing, they would have found, we would have found based on this evidence that, Liggett was being misleading and so forth. So, you gotta kind of wonder about that. You gotta kind of wonder about that, because the court is never really inclined to be the decider of the facts in the first instance. That's not really what they do. They're there to review what the trial court does. So, I did look up a little bit. They've written the standard of review here, right? Reviewing the admission of evidence after a denial of a motion to suppress. Okay, the motion to suppress has been denied. What does the court do with that ruling? They consider evidence favorable to the ruling and uncontradicted evidence to the contrary. So basically what this means is that they give every benefit of the doubt to the state when it comes to the facts. Only if there is evidence that is uncontroverted that helps the defense will they consider that evidence. So based on all that, I just think it's really unlikely that the Court of Appeals is going to take that approach of we'll just decide for ourselves that this was misleading and we'll throw it out. I think the best case scenario they can hope for here is that it just gets sent back to Gull to have this hearing. And then it comes back up, and here's what we look at with the evidence. They have to give the state an opportunity to contradict anything that the defense has said. The appellate court isn't just going to say, well, the appellant put it in their motion and therefore it's uncontradicted, because there was never a hearing. So they're not really in a position to be able to apply this standard. That's why I think the most likely thing is that they would just send it back down. And then if it comes back up, it's not going to be favorable. The way that this standard of review is described in some other cases, it's a clear error standard on the facts. So only if it's obviously wrong, like it's completely contradicted by what the record actually indicates, will they overturn findings of fact. It's very, very difficult to overturn findings of fact on appeal, because the Court of Appeals isn't looking at credibility. They aren't looking at if there's conflicting evidence. How do we decide which one we believe? They defer on all of that to the trial court. So, I don't love this issue from a standard of what is it actually going to get you from a remedy standpoint. And I thought a lot about this, because not only are they raising this issue, but this is the first thing. This is the first thing that we're bringing up. And you remember the whole doctrine of primacy and recency, first thing you argue, last thing you argue, likely to be the most influential. There was a decision made for how these issues are going to be organized and structured, and they put this one first. They put this one first. And the best explanation, the best kind of rationale I can think of for it is not because it's their strongest legal issue, because I don't think it is for a couple of reasons that I'll talk about in a minute. It's not because it's the one they want the most. I don't think they actually do want this. I really don't. But I think it's really potentially just because it sets the stage in terms of the dishonesty. It kind of needed to be raised in order to highlight how deliberate it was. This case was constructed, and it wasn't just constructed with legitimate things. It was constructed through deception and omission and misrepresentation. So that's kind of my best take on it. I think it's more of the story than necessarily an issue that they really particularly want to win on or are likely to think is strong. I think it's also it's kind of helpful from a standpoint of reminding the court how weak the case was against Richard Allen before the state started constructing it. Right? All they had was conflicting descriptions of bridge guy, and Richard Allen said he was out at the bridge that afternoon, and that's pretty much it. Is that enough? Well, that's where it kind of gets into the question of, does this issue have legal merit? Is this a strong legal argument to make? Because remember, what are they going to do? Let's say let's say we go through all this. Okay, the trial court erred by concluding Detective Liggett did not make false statements or reckless conclusions. So she did apparently make this finding in the process of denying the motion, just based on the showing that the defense had made, because of course they didn't have an evidentiary hearing on it. So they're going to review that finding for, is that clearly wrong? Is that clearly wrong? They might have a pretty good case for that, right? So they're going to make this point. Here's what it means for it to be misleading. Here's a lot of case that shows our burden is just to show reckless or deliberate false statement by a preponderance of the evidence. It's not a huge burden. And they omit it if they withhold a fact that any reasonable person would have known that the judge would wish to know. Here are some different examples about it. Details undermining an officer's conclusion. So, when you use the characterizations, it's always red flag. Red flag. Police are characterizing something instead of giving you the facts to be able to draw your own conclusions off about it. You should maybe be questioning that characterization. He seemed suspicious. We just saw this in the Luigi Mangione motion to suppress. Or like, he seemed scared and he started to shake when I approached him at the restaurant and asked him if he'd been in New York recently. And this was all suspicious. He seemed like he was nervous. This was this characterization of it. Well, we get into the motion to suppress. We're watching this stuff on the body cam video, and you don't see anything like that. And then has to get more specific. What do you mean? What did you mean when you described it like this in your report? Well, his fingers trembled a little bit. So when you get the actual facts, often might undermine that characterization that you get. Same thing with the whole example I used before about, he changed his story. He changed his story. Well, give the facts about what they said in the context of the interrogation, because often it's not. Often it's filling in detail. Often it's providing something that you didn't ask for the first time. It's different than how you're characterizing it. Now, one thing I definitely notice when they have, U.S. Supreme Court case law, that's good because that is binding. When they have Indiana case law, that's good because that's binding. When they use stuff out of the Ninth Circuit, it's not. The Ninth Circuit is never going to get a hold of this case coming out of Indiana. Indiana is in the Seventh Circuit, I believe. So, different court. Ninth Circuit case law isn't binding. It's persuasive. It's kind of a mixed bag to bring up authority that isn't binding, because it's easy for the court to dismiss. They can just say, Ninth Circuit isn't binding on us. We don't have to follow it. But sometimes that's all you got. That's all you can find. Not every legal issue gets fleshed out in every jurisdiction. So again, there's always trade-offs with how these things are done. They want this to have the power of law. This assertion here that material omissions include details that undermine an officer's conclusion. Why? Well, because we have examples of that in these two different cases. That's what they were able to find to kind of support it. So incorrectly reporting a witness's description of the suspect, equating the description of the defendant, that's a little bit similar factually to what we're dealing with, isn't it? Because he misled them about the descriptions like aligning with each other, didn't mention the fact that they don't, and also didn't mention the fact that none of them correlate to Richard Allen at all. Just left that part out. So factually, we kind of already know what these facts are, right? We know that they left out about he doesn't fit the description. The descriptions don't fit each other. The car doesn't fit the description of his car. It's not the same color. It's not the same shape. So they argue material omissions. Once again, we have an example from a jurisdiction that is not binding, but it might be just the best that they have. Change the witness's car description in a drive-by shooting. That is not an omission. That is a, it seems like anyway, this is a material misrepresentation. If the officer changed the description, that seems like more of a misleading thing, but maybe he just left out details or something like that. I'm not sure. The Carbaugh doesn't match up. Blair told him it's not the same person that Carbaugh saw. Lied about what Allen said in the interview, that he admitted what he was wearing, when in fact, Allen never said any of those things. He said he didn't know what he was wearing. And he omitted that the blue Carhartt that Allen did own was bought a couple of years ago in 2022. And that if the court knew that he just admitted owning a blue or black coat, it would have known there is no connection between him and Bridge Guy. That, I think, is too strong of a statement, but it certainly undermines the conclusion that he is any more likely to be Bridge Guy than anybody else, right? It doesn't give you anything specific as far as your suspicion of him, and warrants require the suspicion to be particular. It can't be broad. It can't be general. It can't be like all of you people. Like, a great example is the geofence warrant. The geofence warrant has, it's been litigated in a bunch of different jurisdictions. It was, I think, the Fourth Circuit that said, these are no good. You can't use these. They're not particularized. They are broad dragnet searches where it's not suspicious to any particular person. You're just saying all of you people, were here at a time in whatever, area is being described. And so we're going to kind of look at all of you with suspicion. We're going to gather all of your information, even though we don't have any reason to think any one of you is more likely to be our target than anybody else. Other courts have said they're fine. So it's still an issue that's kind of up there and in dispute. Tower dumps, another one. Tower dumps, I don't think have made it up to the appellate level yet, but they have been held unconstitutional at the district court level in a couple of different courts for the same reason. They're not particular. So guy owns a blue coat, guy owns a black coat. It's not really going to be it. And in the meantime, if guy doesn't match the description and the descriptions don't match each other, we can't even give you a clear description of who Bridge Guy is. His car doesn't fit the car. Don't necessarily have a lot to work with. Alternative standard, first he's arguing this was deliberate. Now he's arguing just it's reckless because any judge would want to know these things because it strikes at the heart of the conclusion that he was the man on the phone. It relies on the timeline. And so if somebody else was described, the judge would want to know that. And, the fact he lied twice shows more than reckless disregard because it's meant to suggest a more particular connection than the actual facts establish. So now, though, here's where we get to the meat of it, right? Because, it's a material omission. The question is, if we take that out of the picture, do we still have probable cause? Do we still have probable cause to get into his house? And that's got to be viewed against the fact that probable cause, it's got to be particularized, and it's got to be, there's got to be something there, but it's not a high bar, guys. Even though it's called probable cause, it doesn't mean like 51% likely or anything like that. It just means you got a fair reason to think that you'd find some evidence there. You got a fair reason to think this person could be involved. You do not have to have a sole suspect identified to be able to get a search warrant. It's very possible that, you could have multiple people that would fit within whatever information you have to identify a suspect, and you can still get probable cause to look at all of them, even though like only one of them could have been the perpetrator. So it's not that high of a bar. So their argument here is that they're left with Dolan's report claiming Allen told him he was on the trails between 1:30 and 3:30 at the right time, saw 3 girls, not 4 girls. During his interview, he admitted wearing blue jeans, owning a gun, knives, and a blue or black jacket, and walking out to the first platform of the bridge to watch fish. But he doesn't look anything like the person Blair saw. His car is a different color and shape. And the man Carbaugh saw walking was most likely not even bridge guy. If Allen being on the trail within the same 2 hours of the girls were abducted is enough for a warrant, law enforcement would have obtained one for Allen's home in 2017. This is a persuasive point, I think. Kind of like it makes a lot of sense logically, right? But this is also now, it's just not, it's not something the courts are going to do. It's kind of like second guessing Dr. Walla, reading the true crime blogs and watching the videos and all that type of thing. It's outside of their purview. They aren't clinical psychologists and they aren't cops. They're not going to necessarily second guess the investigative decision-making process or think that they know it. It makes sense, right? On a plausible level, like why did these facts generate a whole bunch of suspicion in 2022 when they didn't generate this level of suspicion back in 2017? But it doesn't mean they were wrong in 2022. You see what I'm saying? It could be that they were wrong in 2017, and the Court of Appeals isn't going to want to look at this and pass judgment on that kind of decision because it's outside of their expertise. It's not their call to make. They review decisions. They don't make those calls themselves. So this is the $1 million question right here. Okay, if you take it all out and you add in the facts that they would want to know, you still have Betsy Blair saw the guy on the bridge. Her description doesn't look a lot like Richard Allen at all. Could she have been mistaken? Could we explain it away like that? The challenge here is him being, at least according to the information, in the right place at the right time. Is that going to be enough to get him probable cause? I'm not prepared to say that's like an easy no. I can see a court saying, yeah, I think there's probable cause there. And I could see what I'm like particularly concerned about if they get a Franks hearing and it goes back to Judge Gull and Nick McClelland to be able to come up with whatever clever explanation they have. They have the opportunity now to fill in the facts, and they can fill in facts about things like, over the 5.5 years of the investigation, we were never able to locate anybody else who was in the right place at the right time. That would make it much more particular, much more specific to him. So I'm just not convinced on this one that even if they can show, which I think they can, I think it's pretty evident there's falsehoods here, but I'm just not sure it gets them where they want to be. I think the best case scenario is this gets you a remand for a Franks hearing in front of a judge who's just going to post hoc rationalize what happened with the insistence of her pet prosecutor, who will make sure that the witnesses have their marching orders and know what the approach is going to be. And that even if you get that, they're going to be able to come up with some way to say, look, probable cause is a really low bar. And so just because we didn't have definitive evidence that it was him, all we have to show, the standard I looked at in Indiana, it's just a fair probability. Just a fair probability. If they can make a record, he's the only one that was at the right place at the right time, then I personally think they probably get there. So that's the challenge with this particular issue. In 2022, yeah, they had no more evidence than at the time. It wasn't enough in 2017. It wasn't enough in 2022. I don't think they're going to second guess that. It's a little bit of the double-edged sword of you've impeached their investigation. Okay, you've presented already a bunch of evidence that these guys were bumbling idiots who couldn't do anything right. So why wouldn't the decision to not get a search warrant in 2017 be consistent with that? It wasn't because they couldn't have, but just because they were bumbling idiots. That's the problem, I think, logically with that particular argument. So the error requires reversal. This is the remedy they want, right? They want it to just be reversed outright. There was dishonesty here. It does affect the underlying probable cause. Because of that, they got the gun. Without the gun, there's no basis for the arrest. Without the arrest, there's no confessions. And without all of that, there is no case. The problem here is attenuation. Attenuation is just the idea that certain consequences are too, they're too remote to attribute solely and primarily to the taint of this illegality. So the problem is, like, from a but-for cause standpoint, you can get really, really remote with but-for causes, right? But for the British surrendering at Yorktown, you know, we're not evaluating this at all. But there is an awful lot that had to happen between the British surrendering at Yorktown and, you know, us reading this brief here in 2025 that, you know, has the potential to break the causal chain. A lot of decisions happened along the way. A lot of intervening things took place. And I just strongly suspect that's how the court would look at the confessions and the standpoint. The confessions weren't a necessary conclusion to the illegal search. If we conclude it's an illegal search, the confessions didn't necessarily have to come about because of that. There was a lot of other things that had to happen for those confessions to take place, not just the arrest, but also the safekeeping order and the delay in the hearing and the deterioration and the fact that he had the pre-existing mental vulnerability, like just all of these other things, they attenuated from this. So I don't think they're going to get to, you know, no confessions as a result of this search. I think the best you get is there's no gun. Without the gun, there's no arrest. But if you take those out of the picture, they still have the confessions. And that's why I don't think they're going to get reversal, because they're always going to look at that as even if it's weak, even if we think it lacks credibility, those are decisions for the jury to make. We're going to get into that a lot more with the next issue. I don't think they're going to get it there. But even without it, he should at least get a new trial, and they should bring out the direct fruits of the search. So no bullet, no Oberg, none of that. Just what you had in the first place, the statements that he made in the interrogation. You can have that, and then the confessions that he made in prison. Go ahead and have those too. Is that a better trial? It's definitely a better trial. It's not ideal, but it's getting a little bit closer to kind of a realistic presentation of how weak the case was. At a minimum, he's entitled to a remand for a Franks hearing. Again, we talked about this. I don't know that they even want it. Great. It was legally erroneous to deny it because he made a substantial showing. But if you send it back to them, you run the risk that they're going to fix the problem. And they're going to be able to overcome the difficulty and validate the warrant. And now you're just kind of back where you started, where it's harmless because all of the same evidence would have come in the first place. This point that they make, court was willing to schedule a Franks hearing when Allen was represented by Fort Wayne attorneys, but refused when the original attorneys were reinstated. It's certainly telling, isn't it, about Gull? Like we already know what a problem Gull is. I'm doubtful that the court is going to be real receptive to that as much as they should, because you would think they would see this is a huge problem that's landed on their lap because of her and that is, decisions that she made along the way. But the whole game, the whole political game and connections and everything, you're in a different class when you're the judge, and the collegiality, it runs deep. You don't want to have to be at a cocktail party with this person that you've called out for being biased about their handling of somebody's counsel. It's just kind of always in the background, so I think it's a good point, but I don't think this is ultimately going to win the court over. But the bottom line is, again, I don't think you want that Franks hearing. It's the appellate attorneys might want it because, it's a chance. It's a chance. And that's true. It's a chance compared to no chance. But it's just not much. It's not much of one. It's not really what I think is setting any of this right, really. Now into the statements. Now, I'll just tell you right up front before we get into this. The statements, the confessions, I think this is the issue that the appellant attorneys think is most important. I think this is the one they really want to win on. And I think you can tell by how they handle it and how they present it. They're starting with a Nelson Mandela quote, for heaven's sakes. They didn't start any of the other sections with a quote. And there's other portions in it where we'll see where they use literary references and things like that. We already saw, imagine the movies tell you, call it the whole. So imagine in your mind, where you've seen that in the movies. So you can kind of get into that context to evaluate what happened to Richard Allen. I think that they are like severely offended by what happened, what the state did to Richard Allen and how it affected him and how they use that, to their own benefit. This is the shocking the conscience realm, torturing somebody into confessing. That's not a good thing. And it's not something anybody should be proud of. And the defense in particular, they have a relationship with their clients. They talk to him at the very least. You talk in letters, you talk over the phone, you talk to the family. They've gone and met him. Doesn't always happen on appeal, but it happens. But they relate to the defendant as a human being in a way that so many other parts of the system just often just put that aside. He's just another body over here at Westville. And so the way that this treatment really undermined his humanity, I think it's to a defense attorney, it's particularly horrifying. So I think this is the one that they really want to win. But I think they're going to have a real uphill battle with it. And so we'll talk about that. So they start with a Nelson Mandela quote. I found solitary confinement the most forbidding aspect of prison life. There is no end and no beginning. There is only one's mind, which can begin to play tricks. Was that a dream or did it really happen? One begins to question everything. It's a great quote. Very fitting, isn't it? It's a form of punishment. It can be torture. It was well established at the time that he was in there for 13 months that prolonged isolation causes all of these issues, psychological pain. And it's because they know that that can happen, that their policy prohibits it for over 30 days for somebody with a serious mental illness. It was predictable that he would experience these. And when he did, they didn't do anything about it. The court didn't do anything about it. Question for this court is unprecedented. Unprecedented. Yeah, this is an unprecedented situation. I remember talking about this way back at the time. Like, these issues can be hard to raise because nobody does this. There's not law on this. Like, this is so far out of the norm that we're having to kind of play in fresh waters here and figure out if this is an area where the law needs to go or not. So it's unprecedented, but it's simple. Should the state be able to benefit from Allen's psychological pain that their deliberate indifference to his mental health caused? Human decency provides the answer. No. The appeal to human decency is really what tells me that this is the one that matters to them. They think this is really important. This is not about law. This is not about cases said so. This is about human decency. And they really, really want the court to see things the same way. Since we are in kind of uncharted waters legally, that means that for the court to evaluate this argument and make a decision on this argument, they're going to be considering policy implications, because you make a rule about Richard Allen's case, but it's not just going to apply to Richard Allen's case. It's going to apply in other contexts. So that can be really tricky to navigate as an attorney, because you certainly want to propose that they make a ruling that's going to benefit your client. But you have to think about how to craft that very carefully, because the court is not going to want this rule to be too broad. The court's going to be thinking about things like, okay, but if I throw out these confessions, does that mean that anybody who's in a mental health crisis in jail, their statements can't be used? Like, even if they're credible? If I throw out Richard Allen's statements, does that mean that no safekeeper can ever be kept in DOC? They can never be sent to the Westville Corrections Center? Like, what exactly? You got to be very precise about the parameters that you're asking for, because they're going to be thinking about what are the implications of this in other cases down the road. And is that a door we want to open? Because they don't want to, bring on a bunch of unintended consequences just because they're dealing with bad facts. There's a saying that hard facts make bad law, bad facts make bad law. And the idea behind that is that if the court just kind of knee-jerk reacts to a situation, they aren't necessarily thinking big picture about what the implications are for making that decision. So the court's going to be thinking about those types of things, and you, the appellate attorney, have to be thinking about, you got to have a theory of mind of the judge, to understand what they're going to be worried about. Why are they going to be? What about what you're proposing might they be disinclined to go along with, and why? And so how can you adjust your strategy and what you're asking them to do? Standard of review, again, substantial evidence of probative value that supports the trial court's decision. Very unfavorable standard of review on denial of a motion to suppress statements, because all you're looking at is there any set of facts here in the evidence that justifies what the trial court did. This is like the clear error issue. Is there any set of facts here that justify the trial court making the decision that they did? And that's where we get to what I think is the fatal problem with this particular issue. It obviously matters a lot to, the council, matters to me. I think it matters to a lot of people. But from the legal standpoint, with the standard of review, the problem here is that there is conflicting evidence. And even though I think they've done an excellent job of pointing out how, like, Dr. Walla saying he was rational and organized and coherent is a bunch of bullshit. And Dr. Martin saying he was in remission in May, long before he started, confessing again in June. These things are contradicted by the evidence, by his own behavior, inconsistent with what you can see with your own eyes. Those are all getting into weighing the evidence. And that's what appellate courts don't do. They don't make those types of decisions independently. They just review what the other court already decided. So this is an extremely unfavorable standard of review, and it's in a context where that really matters. That really matters. You don't have uncontradicted evidence, that Richard Allen wasn't faking, for example. It's highly implausible. Seems pretty common sense. But this is law. This isn't common sense. Sometimes it's I hate to be that black-pilled about it, but they don't want to rule for them. They don't have to. They definitely don't have to, because this standard gives them the out. You just defer to what the judge thought the facts were. And the judge thought the facts were, he's treated better than everybody else at Westville. Remember that? Any set of facts on which that could be justified? Yeah, if you believe the prison guards, you believe Walla, you believe Dr. Martin, you believe all their little scurrying explanations. You believe Harshman that he's just trying to get attention. He was, lonely and solitary, so he wanted to get attention. It's dark, but that's all it takes. And that's kind of how it's set up to go. It's how it's set up to go. Now, the voluntariness of the confession is a legal issue, but the voluntariness, that conclusion, follows from the facts that have been found. And so that's where you have the fundamental problem here. Is, yeah, you can definitely reach a legal conclusion that this was involuntary, but it's based on a certain reading of the facts. And that reading of the facts is not the reading that Judge Gull adopted. So as long as she had something in there to rely on, pretty much no matter how incredible it is, it's going to get deference. So here was her reasoning. They were voluntary because Allen failed to show that they resulted from state psychological coercion or coercive interrogation. The court found Allen's detention was intended to protect him, and that while he suffered from a major depressive disorder and anxiety, he did not have SMI that would render his statements involuntary. Now, this is not the total findings, right? But these are certain findings that she made. And these are important because these are ones they can potentially challenge. Like these are the ones that are problematic. Allen failed to show they resulted from state psychological coercion is burden shifting. That's burden shifting. It is the state's burden to prove that they are voluntary. It's not his burden to prove that they're not. So they can argue that this is legal error, and therefore, to the extent it's legal error, she didn't apply the facts correctly. This potentially an error. She concluded that he didn't have a serious mental illness. that would make his statements involuntary. Major depressive disorder constitutes a serious mental illness under the IPAS, order, the decision. So if they consider that, then that's contradicted. That finding as well is contradicted by, I guess, reality. But the question again is just going to be: is there anything in the record that would justify that finding being made? And that we just have this short summary of what the findings were and what they were based on. But there's a whole record of the hearing for them to parse through and find anything that would potentially substantiate it. So the IPAS report is important to them because, again, yes, it includes serious mental illness, includes his major depressive disorder that he already had. So that would mean that finding that she made was erroneous. And so if her conclusion, if that was critical to her conclusion, then her conclusion is undermined by that fact error. And just, what happens, the fact that it's predictable and, the reason why they had reached this policy limit, that if you have the serious mental illness, you can only be held for 30 days. You're supposed to be transferred if you decompensate. They're relying heavily on Dr. Westcott's report, which, is appropriate. I would expect them to. They paid a lot of money to get that report. She did a very thorough evaluation. The problem is it's contested. It's their case. And when you're dealing with this type of a standard of review, the substantial evidence type of standard of review, what you're really having to do is you're having to rebut the state's evidence, right? Because the presumption is if there's anything in the state's evidence that justifies it, it's okay. Doesn't matter how good your case is. And so you really have to be showing that there's a problem with the state's case. They're not doing that. And I think it speaks to, again, how much this issue matters to them and how important they think it is. But from a kind of strategy standpoint and just a practical standpoint of being able to meet this legal standard, this isn't going to get them there. Dr. Westcott's report isn't going to get him there. Because the court can just say, she could disregard that if there's other stuff in the record that she could have relied on. Dr. Westcott is contradicted by the guards, for example. May seem very logical who one should believe between that battle of the wits. But that's just not how the law is structured. So they want the court to know all these things and that a qualified expert said all this stuff. It's emotionally appealing, but it doesn't get them where they need to be legally. So the order should have come in first off because it's relevant, right? If the order contains facts that the judge relies on, and those facts have binding quality, then we would need to accept that, makes it more likely it was caused by his confinement because the order anticipates these types of things can happen and explains why and sets up the protective measures against it, none of which were followed. The settlement order, incidentally, they don't mention this in the brief, but I was kind of looking at this like it's presumably hearsay, right? Because it's an out-of-court statement that is offered in court for the truth of the matter that is being asserted. It is not sworn testimony that took place in Richard Allen's case. It took place in a completely different case, resulted in findings and so forth. However, there is a public records exception in Indiana law that I think would apply to this particular order. It includes things like findings of fact from an entity that's like appropriately legally engaging in this type of investigation, and it's like part of their their normal course of investigation. So I think they don't address it, but I think it would also satisfy a hearsay objection. Makes it more likely by showing that solitary causes psychological pain, shows how extensively they violated their own policy. This to me is the most important part, because I think you get to the rest of it. You can get there through, you can get there through Westcott, you can get there through Gracian, but even as I recall, the state's own experts acknowledged, yeah, extended solitary can be a problem, and it can cause these types of issues. So I don't know that the facts of it is really a huge part of the dispute, but showing that how they acted was so inconsistent with what the policy is and the reasons for the policy, that to me is really at the core of it, because that's getting into what shocks the conscience about how he was treated. It wasn't just that he was, they didn't know any better. And then once he started to decompensate, they didn't know how to handle it. And so they were all kind of winging it and, learning experience type of thing. No, they already freaking learned this many times over and got sued and settled. So they knew this perfectly well. It speaks to the intentionality of it. And that's going to be an important part of this argument here, the psychological coercion and the state agency. So we have a challenging factual situation, right? Because we've got disputes over what his condition was. Was he faking? Was he not faking? Was he in and out of psychosis? Was he rational during points of this? So on and so forth. So we've got a challenging factual situation, but this is ultimately like the advantage they have with this particular issue is the fact that it is the state's burden to prove the voluntariness of the confession. And so to do that, it was the state's burden to prove it's a product of rational intellect and freely self-determined rather than overborne will by state law enforcement conduct. So it's not that he had the burden to prove he was crazy. It's not that he has the burden to prove that he wouldn't have confessed but for this treatment. It's the state's burden to point to all of these facts and circumstances and prove this is still rational. This was fine. So, not sure I get there. Definitely not myself getting there. But that's where you'll sometimes run into these opinions in court decisions where they say, it's not our job to second guess. We're not deciding it in the first instance. We're just here to review. If they were exercising their own independent judgment, perhaps it would be different. But their job is to apply the standard of review. It's challenging in this situation. We've got some more out of jurisdiction law here, but it is helpful. It is certainly on point. Months spent in solitary confinement, deprived of light, adequate food, and contact with the outside world is by itself sufficient to sustain a finding of involuntariness. And then one that is from the Seventh Circuit, but it's a little bit less on point because it's a state psychiatric facility. Nevertheless, it created a coercive environment, rendering a juvenile's confessions involuntary. Now, let's just real quick from a legal standpoint, Seventh Circuit is not binding on the Indiana Court of Appeals either. It's not directly like in their kind of chain of command is sort of an okay way to think about it. But it's much closer. It's much more persuasive a lot of the time than citing law from other circuit courts of appeal. And the reason why is because there is at least a chance that Richard Allen's Indiana case could end up in front of the Seventh Circuit. There's a much better chance of that than there is that it would end up in front of the Ninth Circuit. And it gets there through habeas, through a post-conviction process. So knowing what the federal standard is that this could potentially be reviewed under if it goes up that far is a lot more persuasive a lot of the time to an appellate court than stuff that's from another circuit. So I wish like these facts were reversed, you know, because this one from the DC District Court, that's a good quote, isn't it? Like just being in solitary for months is enough to make a confession involuntary. That's what they want. They want that fact alone, because if that fact is uncontested, it's uncontested he spent 13 months in solitary. And so if that's all it takes to establish that that the confession is voluntary, well, then we've satisfied the standard. But that's persuasive. It's not binding. It's not in their circuit, not at the right level anyway. And it might be dicta. Not real sure. You know, you need to go read it in context. But that's a broad rule. And that's where it gets to that policy kind of consideration that I mentioned before. Appellate courts aren't necessarily going to be inclined to adopt a real broad rule like that. Now, you might want them to, and you might think they should. And there might be a good reason to do that. Do we really need confessions so bad that we'll hold people in solitary confinement for months to get them? Maybe they would be willing to make a kind of rule like that. But you got to be prepared to lobby for it and explain why. And you know, why does the line need to be drawn here? Why is this? How do we know that this isn't going to undermine, you know, significant, important investigative steps that police might need to rely on? When state actors use more subtle forms of psychological coercion, the defendant's mental illness is more significant in the voluntariness determination, but the state must still exploit the illness with coercive tactics. So Supreme Court law is good. This is this is binding. That's helpful. It's done through aggressive interrogation, but can also occur in other ways. So the example here is a truth serum. Truth serum would make it involuntary. It takes over your will to resist, your ability to, withhold information and to not give in to the questioner. And the state action must be causally related to the confession. So state action. Here's where they point out. I would like to have seen this, because this is critical for you to be able to win. This is a very important point, I think, is getting the court to reframe the legal posture of what needs to be decided here. It's not, did he prove that, you know, he was so psychotic that he was, you know, not speaking freely. It's the state's burden to prove it. And so when you look at all the evidence by a preponderance, did the state meet that burden? Now, preponderance evidence is low. It's low. And that's where you can run into the perspective of being like, well, you know, I know that Dr. Westcott is a professional, but she's also a hired expert for the defense. And she wasn't there personally. She's just reading the things after the fact. And so I'm going to find the guards more plausible. They can do that, guys. They can do that. To the extent he had a minimal burden of production, he met that. In other words, to be able to raise the issue in the first place, to justify having a hearing on whether it was voluntary at all. So prolonged maximum security, solitary confinement of a pretrial detainee, especially after psychosis develops, is state action. Yeah, technically, you know, confining somebody is kind of always going to be state action. And how you choose to do that, the circumstances you choose to do it under, the environment that you create, the way that you react, all that stuff. It's within the state's control. Because it was pretrial, Allen's solitary was unprecedented and borderline, if not unconstitutional punishment. Yeah, this is definitely an issue. As far as conditions of pretrial confinement, you're not in the 8th Amendment cruel and unusual punishment context, because the theory is you're not being punished at all. It's just pretrial. You're just being detained. These are just conditions that need to be met to ensure that you're not going to flee, but you're also going to be safe, and the community is going to be safe, and you will show up for court and all of that type of thing. It's not punishment. So when it crosses the line into punishment, that's a due process problem. But what do you do with that? What do you do with that? What's the remedy for that? That's where I'm real not sure. Like, could he have a civil claim for that? A 1983 claim? Yeah. I think that's pretty clear, especially based on the IPAS report. They'd already litigated that and decided it and had the policy and so forth. Doesn't necessarily mean that you have a trial-related remedy. And especially if this is, again, this is unprecedented. They're kind of making it up as they go along. They got to decide. So solitary is the most extreme. Yeah. Yeah, I think that's true. It exceeded the policy restriction. We already know that. And an important point, it involved the prosecutor, law enforcement, and the court. After he filed his emergency transfer motion, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which he confessed. The timing of this, April 5th, was that the day he called Kathy, or was it the day after? I forget, but it's right in this time frame. It's right in this time frame. So I don't know that this is this unusual to wait 9 days to respond? I mean, it's kind of normal that it's going to take some time to respond. Do we have a reason to think this delay was deliberate or problematic, for some other reason? It's rhetorically powerful, but I'm not sure that it's factually that persuasive, because the court's going to know these things don't happen like that. The prosecutor is going to have time to respond in the absence of like some order saying he needs to respond sooner. Is there some reason to think this was untimely? During the delay, he continued deteriorating. And then the prosecutor mocked the defense concerns as colorful and dramatic, while that same day IDOC found Allen gravely disabled. The juxtaposition that, yeah, I mean, that happened. That happened. That's the situation. Clearly offends the defense lawyer. I understand it offends me too. I'm not sure that it's going to offend the appellate court. The prosecutor is advocating. He's doing his job. They don't necessarily want to judge him. What did he know? Did he know that IDOC was finding him gravely disabled that day? Kitty, you got to stay off that desk, honey. They still, the court refused to transfer him, putting the onus on IDOC. Fundamentally wrong to keep him in solitary while using against him statements made to psychologists and suicide companions. I don't know if it's fundamentally wrong or not. This is kind of a conclusory type of statement. I'm certainly open to the idea that it's fundamentally wrong, but that conclusion needs to be spelled out a little bit more, I think. Explain why. Like the Sims, okay, you've cited Sims, but I don't know what that says or what it means. Shall we look it up? Maybe I'll go ahead and look it up. Let's see what I can find here real quick. Sims v. State. Sims v. State. Okay, I found it. Kitty, you're in my way. Kitties are going to start mashing my keyboard pretty quick here, and then I don't know what's going to happen. Okay, page 346. Let me just find page 346 here. Then we'll find this quote. This is a case that appears to be about physician-patient privilege. Let me go ahead and just give me 1 second here. Kitty, get off. Kitty, here. Go hang out with that dog. Let me go ahead and switch which screen we're looking at here real quick, and I'll bring up the case. You are really persistent today, aren't you? All right, here's Sims versus State. Everybody can see that. So his conviction had been reversed. This is the Supreme Court of Indiana, reversing, but for a different reason. They reversed because of a failure to object about believing. That's improper opinion on another witness's credibility. But the case presents a different question. The case at bar, it's not an expert. Whether we believe an 8-year-old child. So they don't agree that that requires reversal, but there must be reversal for another reason. The state called a family therapist, it looks like. Evidence showed these prior convictions. The counselor was allowed to testify to details related to him in the course of psychological treatments. Also permitted to give his clinical observations and his opinions about the defendant. And they say this is privileged. So this is a case about patient-therapist privilege. So let's get to 346. Alexander is not a physician, therefore that privilege wouldn't apply. However, we hold that this communication should be protected. The purpose of protecting is to ensure that such persons communicate fully and completely with their counselors in order to promote successful treatment. He was compelled to seek treatment. He believed, in all probability believed, it would be kept in confidence. So it circumvented his Fifth Amendment rights because he was in a situation where he didn't have a choice. He kind of had to participate in the treatment and didn't know that they would be revealing what he said in the course of that treatment. So in this case, Estelle, he'd been convicted, held the Fifth Amendment rights had been violated. This was based on a psychiatrist evaluation. Supreme Court stated the state could not compel the defendant to testify and that the attempt to use the psychiatrist's statements similarly violated his rights. Moreover, the court wrote that the situation there was different from one in which the defendant raises an insanity defense or makes a plea of not guilty by reason of insanity. The trial court had caused the evaluation to be conducted for a neutral purpose. The state then used the evaluation in a manner clearly adverse to the defendant. They declined to apply that. The situation present is analogous to Estelle. He was convicted, ordered to undergo counseling. Purpose of counseling was for treatment, then used the prognosis in a manner adverse to him. His Fifth Amendment rights were violated by the admission of the testimony. Okay, so that's Sims. Let's go back now to what they were using Sims for, because I think it's not really quite that. It does not say it's fundamentally wrong to keep him in solitary while using against him statements made to psychologists. Like the case does not say that. So they think you can draw this conclusion from that case. I don't know that I really agree with that. You need to make a better case for why that applies here. The problem I see in part is Sims itself excluded insanity, or basically when the defense chooses to use their mental condition in a defensive way. We can kind of maybe go back and forth about whether that's sort of what's at issue here. Did he put it at stake under these circumstances or not? He certainly didn't plead insanity. He didn't even raise competency as far as that goes. But it's just it's this conclusion does not clearly follow from what happened versus Sims. It warrants a little bit more explanation and a little bit more clarification of how you get there in light of that decision, and in light of the way that the facts in this case are a little bit different from that. Because remember, this court is looking at big picture stuff. They're looking at policy stuff. They want to make sure that if this is a comparative case, that they're comparing apples to apples, not like Melissa Oberg. 1 week later, the prosecutor sought all medical records, videos, and communications while confessions were ongoing. Yeah, that was quite a coincidence, wasn't it? The timing of all that. The timing was quite coincidental. I think that the challenge is the absence of direct evidence that they knew what was happening. They knew to go and ask for all that. They knew that things were going downhill. Was he told? $1 million question, but we don't have evidence for it. We just have circumstances that look awfully coincidental. But he'll just explain it away. Well, it was at issue because the defendant's arguing his condition is deteriorating, so we need to get all of the evidence to be able to evaluate that. Nevertheless, for this point, state action, yeah, I don't think that one is particularly hard to establish. He's being held in a state facility. Like, everything that happens to him in there is as a result of state action. He has no individual liberty at all. And there's nobody, outside of the prison system that has the ability to change his situation, other than the judge, who didn't. So I don't think state action is a particularly difficult hurdle to clear on this one. It might just be another one where this was kind of an opportunity to spell out some more of the facts, try to paint more of the picture of what was going on here that didn't strictly necessarily need to be brought in, but think it might have some influence, might have some power to change the court's motivation with what they want to do with this issue. His prolonged pretrial solitary confinement was psychological coercion. Because it was prolonged, it caused psychological pain and put him at the mercy of the state. So just given the nature of it, this is where they start getting into some more literature. Dickens talks about solitary confinement. IDOC knew what could happen because of the IPAS report. It's difficult even for healthy people, getting into some of the medical evidence, what the videos show. It was predictable that this happened. You can see him in pain, and it's predictable that that's what would have happened. It is undisputed he deteriorated to being gravely disabled and very psychotic. And IDOC involuntarily administered antipsychotics between April and late June. It's the involuntary administration that seems particularly helpful in this context, because it means he's not in a state to be able to make his own decision, for you to be able to get that order to do it involuntarily. So if you're saying he's back to baseline in May, then he should be able to make that decision for himself. If he wasn't able to make that decision for himself, then there needs to be a reason why. And it might be hard to document that with, in conjunction with also being highly rational. Although Walla noted concerns about feigning, I highlighted this because these are the problem facts. They have to acknowledge them. They have to acknowledge them, and I think they're doing the best they can to kind of try to minimize them or suggest that those shouldn't factor in. But the problem's always going to come back to that standard of error, that standard of review. She said she's concerned he might be feigning. He might be malingering. He might be looking for attention. He might be doing this on purpose. And so it's there for the judge to rely on and say, I think that's what happened. I don't think he was psychotic. I don't think this was all, the product of mental illness. I think it's murkier than that. So they are acknowledging the bad facts, at least kind of in passing here and sort of trying to minimize them. But that's going to be the hurdle that they have to overcome in this particular context. Talking with a psychologist while shackled in a cage is not treatment. I agree, but the court's not going to make a decision about that. The court's not clinical psychologists, and the court isn't going to issue a rule that says you can't give people mental health treatment in a cage. It's just unlikely. They don't want to become the supervisors of the prison environment. They don't want to be prison architects, They might they could maybe come up with a similar type of rule, something more general that would apply to treatment in a cage. But it's just unlikely. It put him in a vulnerable state. Yes, it will do that. Dr. Walla controlled all aspects of his life. She had a lot of control. I like how this is articulated. Privileges were contingent on pleasing her. Doesn't this make her sound like the puppet master? This is really kind of gets down to the power that she held. And that's the key to coerciveness. Whether she had ill intent is irrelevant. That's a very good point. It's not about whether she wielded her power malevolently or not, although we might suspect she did. It's just about the fact that she had that power at all. And it puts her in the position of, being the person that he has to appeal to. He has to convince, he has to persuade. He has to get her benevolence in order to relieve his pain. That's so much power. And if she has the power to do that, there will reach a point where he will give her anything she wants. There's a point where he would try anything to see if it works. Another anecdote, Senator McCain, a prison camp survivor, explains solitary crushes your spirit and weakens your resistance more effectively than any other form of mistreatment. Allen entered solitary confinement compromised. He left broken. I really think this is about as powerful a description of what happened as you could hope for. And I think that's why they've written it like this, because surely it would be hard for anybody to read this over and think, yeah, I don't really care. I think that's fine. Like imagine the court saying this is okay, an illegal ruling. I think they're gonna, because they're not going to describe it like this. They're going to describe it. They're going to describe it very differently. But I think that's what the defense is trying to do here. Is they're trying to paint this in such a way that the court will feel kind of cornered, kind of forced. Because surely nobody would say it's totally fine to throw people in the hole until they break and then use their ravings to convict them. Of course, that's not okay. And the court's going to get around that by saying that's not what happened. That's my prediction. We'll see how it plays out. It's not even that they're going to say that's not what happened. They're going to say the judge, the trial judge, who's in a much better position than us. What they're going to do is they're going to pass the buck. They're going to wash their hands of it. Little Pontius Pilate type of thing. You're going to say it was not our responsibility in the first instance to pass judgment on this. That was the role of the trial court, who was in the best position to observe the testimony, the demeanor of the witnesses, the manner of responding to questions and cross-examination, make determinations about credibility and believability, and to weigh the competing evidence and resolve disputed facts. And it is not our place to second guess the finding of the court. I'm not going to be shocked at all if we see language like that. His confessions were a product of solitary induced psychosis, not rational intellect. This is clearly what they think. And there's a lot of evidence to support that. And it's a critical part of the story. But again, this is the key. It's the evidence that goes against their position. That's all that there has to be to justify it. It doesn't have to be a lot. It doesn't have to be good. It doesn't have to be consistent. It doesn't have to appear to us to align with the rest of the evidence. It's contradictory. The trial court gets to resolve it. And she resolves it in favor of Walla. He's not really that ill. He's more organized than he's ever been. His symptoms were, things he was doing for attention. Guards believed he was faking. This is another one. Yep. But they're not clinicians. This is just establishing that there are conflicting facts, and that's not helpful to the defense in this context. So, a lot of descriptions about it. This here, the state action overbore his will. Now this is getting into the causation element. It's a pretty good argument that the fact that he confessed, well, so first he maintained his innocence. Then he confessed. He confessed a bunch of wrong facts. He didn't remember confessing. He repudiated his confessions. Then he confessed some more, and so on and so forth. These are all pretty good arguments that it's consistent with the solitary confinement, and a lot of that they could derive from like Gracian's testimony about how to identify when it's false, how to look for the symptoms of the psychosis from solitary confinement and so forth. This argument right here is not the strongest in my opinion, because it's just a post hoc ergo propter hoc. It happened afterwards, therefore because of it. that's not the most compelling part of it. I mean, it certainly needs to happen. Causes do always precede the things that they cause. But just because something precedes it doesn't mean it caused it. So I do think that there could be, better arguments than that to maybe lead with. Westcott's opinion, that's a good one. Walla agreed that a lot of the time it exacerbates mental illness. So you have these things that seem to be, in agreement, that go directly to cause. That's probably nitpicky, but I can't help but notice little things like that. Makes you question yourself. Dr. Gracian testified, how this works. You begin to think you are if you're treated like you're guilty. Starts with a belief, played out exactly like that in how these things happened. So this is all, I think, this is, like, in my opinion, really the best argument for causation is the way that Gracian described it. It fits the pattern to a T for when these things happen. So that makes it much easier to conclude that pattern played out in this case, that he became psychotic because of the solitary. Now, the Indiana Constitution, this seems to be a better argument, and might have been worth focusing on a little bit more than the just kind of due process based stuff that they relied on for the bulk of their argument. You have to raise the federal constitutional issue, the implication, the voluntariness, and so forth, because you have to federalize your issues as much as you can on appeal, and that's basically preserving them for them to be able to go up to federal court in the habeas process. So you can't just not bring up federal constitutional issues and only deal with it in terms of the state constitution. But when you have a state constitution that is more protective than the federal constitution, then it can be real helpful to really focus on that and use the federal stuff as like an afterthought, plug it in, make sure you mention it, make sure you preserve it, but don't make it your focus. If this is stronger, you can really focus on this. And so Indiana has a heightened standard for admitting voluntary statements, because it's beyond a reasonable doubt. That's a lot harder to meet. That's a lot harder to meet. So now we're in a standpoint under this standard where even if we accept the facts, are disputed and they could have been resolved in favor of the state in every situation where they're disputed, does that get us to voluntary beyond a reasonable doubt? I'm not sure, but it's a much harder hill to climb. It's a much harder burden to get there, because you really do then, I think, at this point, have to completely discount Dr. Westcott, the objective measures that she did, Dr. Gracian, and you really have to be, weighing very heavily the guards and stuff like that. Not saying they can't. Again, it still comes down to what did the judge find? And is there a basis for those findings? And if those findings, if correct, would lead to a conclusion that these were voluntary, he was feigning, whatever. They can still establish this, but it's just harder. It's much harder to establish this beyond a reasonable doubt standard. So hammer on Indiana on this one. It may just be because perhaps there's not as much law specific to this context, because this is unprecedented. They had some federal cases they were able to draw on, but if we're stuck kind of briefing this through the state the state framework. We don't have enough analogous to be able to work with. Also in Indiana, you don't have to have state action. It's enough for his statement to be involuntary due to his altered state and confusion, even though the officers didn't coerce him or even know about his illness. Excuse me. This seems like a really strong case to me. Oh, give me a second. I think my throat is getting very dry. One second, please. Okay, thank you. I can kind of talk again, but I'm talking a lot more than I expected. I told Jeff, oh, I think we'll be like 2 hours tonight. Ha ha, he laughed at me. He knew. Jeff is rarely wrong about stuff like that. Anyway, this seems like a really strong case. Okay. I feel like if this case is this strong, if this case really supports this proposition this directly, this is so on point with what we're talking about here. We could have maybe eliminated a whole bunch of the earlier stuff and really just focused on this. Like, bring it up early, bring it up often, spell it all out for me. Tell me all about this case. One thing that they have not done a whole lot, like at all in this brief, is really explain the cases. You don't always have to. I mean, there's different ways to argue and different ways that you use the case law. But when you have something that's really strong, that can be very powerful to lay out, like, here's this situation, here's the facts that the court was dealing with in this situation, here's how they reasoned it through, here's why they reached this conclusion, here's the principles that applied, and here's why they all should apply in this situation as well. So if this case is really that strong, front and center, man. Front and center, not kind of dropped in as an afterthought at page 80 here. This looks very compelling because we don't have any dispute that Richard Allen had an altered state. I mean, everybody seems to concede that. The psychosis diagnosis and everything. I guess we're still left with the guards. But now we're also still in that framework of they have to prove it beyond a reasonable doubt. So they have to prove beyond a reasonable doubt that he's malingering or fake or whatever, when, like, all of the medical professionals at least agree he's psychotic. He's gravely disabled for at least some of this time period. There must be some state negligence that contributed to overcoming his rational intellect. So negligence, that's a pretty low standard, but yeah, not applying the policy, that looks pretty good. Letting him deteriorate, not putting him over in medical. Like, there's a lot of steps along the way where I think we could identify negligence here. And look, they italicized it because of how important it is. That's the standard. Evidence doesn't show the statements were a product of rational intellect beyond a reasonable doubt. He was considered gravely disabled through June 16th. Though Wallace sometimes described him as more coherent were his symptoms not significant, the state cannot have it both ways, i.e. he decompensated to the point of forced medication but remained rational beyond a reasonable doubt. That's That's the core contradiction, isn't it? That's a pretty important contradiction. Doesn't mean the court can't say, well, maybe they were wrong, or maybe they just gave the Haldol for preventative, to just CYA purposes. He seems psychotic, so let's go ahead and give him the psychotic treatment. And hey, maybe that explains why he didn't react to it, why he didn't respond. Doesn't mean they can't come up with some bullshit, but it's harder. It's a lot harder. So I gotta say, we're at page 81. 2 pages on the Indiana Constitution when it seems so much stronger. To me, that's reversing. That's reversing. This is your strength. Hammer this. Don't hammer the federal stuff where it's just beyond, just a preponderance of the evidence and so forth. They didn't prioritize it. I don't know why. They could, I assume they have their reasons. And I just don't know what they are. Haven't read all their cases or anything like that. So maybe that it's not as strong as they're trying to present it. I really don't know. But that just it just strikes me as a little odd. Start with that, and then say even if you apply the federal standard, we still get there. Start from the position of strength. That would have been my preference, but even if the court finds the statements are voluntary, they are a product of unconstitutional detention. So now this is the argument that it's a due process violation. It amounts to punishment. Or under the Indiana Constitution as well, sections 12 and 15. These are constitutional violations. So what is the remedy for that? This is what I was talking about. Clearly probably have a civil remedy, but do you have an exclusionary remedy as well? If this is unprecedented, it's not clear. And so they need to make the case for why that should be appropriate in the case. So these are the provisions. Article 1, Section 12 guarantees for every person, for every injury done to him in his person, remedy by due course of law. So constitutional right to a remedy. Here, he was sent to solitary for safekeeping without even a hearing or notice. Yeah, that was a problem. That was a problem, wasn't it? He didn't even get to go to his own safekeeping hearing. He didn't get to say anything about it. He had the lawyer that they cut out of the process. Yeah. This one was procedurally real messy. And then even their basis for it, kind of sketch, kind of minimal. Wasn't really clear what it was based on other than just, we think we can't keep him safe. But you haven't really given any facts about why that is. And so they didn't have the hearing until, 8 months later, approximately. Fairness protections are found in different Indiana provisions. They also have a provision in the Indiana Constitution protecting citizens from unnecessary rigor. Article 1, Section 15, the framers wrote, no person arrested or confined in jail shall be treated with unnecessary rigor. That's a very interesting provision. I hadn't seen that one before. Apparently only 6 states have that. We don't have that in Washington. Typically, this provision requires a prisoner suffers severe mistreatment. So is that going to apply to solitary confinement, psychological coercion? So they have a case from 1860. 1860. Recognize humanity indeed forbids as unnecessary rigor that his confinement should be absolutely solitary, or that all his natural and civil rights should be temporarily annihilated. Is that the same thing? Are they talking about the same thing? Absolutely solitary. I mean, he gets to talk to people from a cage, right? I don't know. When I see an 1860 case, I'm always going to be a little bit skeptical because circumstances are very different now than they were then. And typically, law evolves pretty significantly over time. If this old case is, the best that we can come up with, I have to wonder why. I mean, this is not the first time that people have been kept in solitary. It probably isn't the first time that a pretrial detainee has been kept in solitary. We know it's the first time one's been at WCU in their hole. But, jails will have isolation cells and stuff like that. Has that come up? Does that count? Have we distinguished that? I don't know. Here is treatment rose to the level of unnecessary rigor. They define it, always helpful. Rigor is the act or instance of strictness, severity, or cruelty. When he started suffering from confusion, all of these issues, there was no longer a risk that he couldn't handle the harsh conditions, that it was a reality. And it's evident on the video where he's screaming in fear, confused about where he is, unable to respond. The rigor was also physical. And this is citing a case saying that solitary can result in physical harm, including self-mutilation as a maladaptive coping behavior. He lost 40 pounds, was unable to care for himself. He was tased. His face was black and blue. He was poisoned by fecal matter in toilet water. They were indifferent to his catatonia. So not just psychological coercion, but also they're arguing the physical torture, physical consequences to this treatment. It was unnecessary. Even an isolated infirmary cell would have been better than the whole. This is kind of what I was thinking of. Yeah, infirmary cells are often isolated, but they didn't have those in 1860. So I would think the law has kind of evolved since then. I don't know. Likewise, the court could have moved him when it learned of his dire condition. Finally, our last literary reference here, the Dostoevsky wrote, "The degree of civilization in a society can be judged by entering its prisons." This is very much what they want the Indiana court to think. This is what they want them to have in mind. That this makes you look terrible. Okay, if you uphold this makes you look barbaric. Like, this is Banana Republic kind of stuff. And you should be able to see that. It's powerful. I certainly see it. Just not sure they're going to get there legally, though. And the court's able to compartmentalize that. They will write an opinion very, very different. Very, very different from all this. And even if they do acknowledge all of these issues, all of these facts, all of these things that he went through, all of this evidence that it's based on, they will find a way to write it in a way that makes it sound like there's more questions really than there are, more validity in the conflict than there really is, because they're relying on that conflict to justify a bad decision, from at least a moral standpoint. I certainly agree with that. And so, yeah, they can distance themselves from that, from the emotionalism of it. They can buy all of this and say, well, but we still have to defer to the trial court, and she was in the best position to be able to make these judgments. So here's their argument for why we should apply the exclusionary rule. This is very important because there's no case law saying already, apparently, that that's what happens, that's what the remedy is for this. So they're saying you should, because it would deter abuses within the prison system and law enforcement. It would protect judicial system integrity by showing it condemns such conduct. And it would protect the human dignity of those unable to make bond while awaiting trial. So now they have another 1938 case, excluding a confession that was a result of physical abuse and solitary in part under Article 1, Section 15. Not sure what in part is. Was it the confession of, was it the result of other things as well? Was it based on other reasons besides Article 1, Section 15? Not entirely clear. But again, this one also seems to be helpful if there's case law like this that is, if it's this on point, fleshing that out a little bit might not have been a bad call. You know, the more you can do the work for the court, do the mental work for them, makes it easier. As it is here for me to be able to evaluate what they're saying, I got to go read this case. I got to process it, evaluate it for myself, and see if it supports this conclusion. So I'm still carrying most of the cognitive load of evaluating this argument. You can really take a lot of that away by doing so much of that for them. Just give me what the facts are that matter. What was the context of this confession? Tell me about the abuse. Tell me what the reasoning was that led it to be excluded. Indiana has a robust exclusionary rule, so it's not inconsistent with policy in general in Indiana. They had it long before the Fourth Amendment. Under the exclusionary rule, the court must ask if the statement has been come at by an exploitation of that illegality or instead by means sufficiently distinguishable to be purged of the primary taint. This is a way of describing the attenuation doctrine. Did they exploit the illegality or is it attenuated? Court considers the time elapsed between the illegality and the acquisition of the evidence, the presence of intervening circumstances, and the purpose and flagrancy of the official misconduct. That makes it sound like a pretty good test to apply it, doesn't it? I mean, it was ongoing. The illegality was ongoing. He was in solitary confinement against their policy without due process for the safekeeping hearing. So all of that was ongoing when they were getting this evidence. Were there intervening circumstances? Nothing in the record. Nothing I can think of. Something that drove him crazy besides solitary? And the purpose and flagrancy of the official misconduct. They had a policy that they flatly ignored for reasons that nobody really explained, other than they're like, well, we weren't sure it applied to him because he was a safekeeper. Wouldn't that make you more cautious? The fact that he hasn't been convicted of any single crime? There's nothing about that makes him less prone to these same problems, these same psychological consequences and physical consequences from the extended, the long-term solitary confinement. So it seems pretty intentional and flagrant. Yes, during it, no intervening, well-known connection, violated their own policies, and the court and the prosecutor refused to help. Even if they find they were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. This I find a little bit confusing. I think it ties back to a point that they were making kind of further up where, see if I can find it. No, this is the rigor stuff. Let me see if I can. Yeah, I'm not sure what I was looking for. I can't find it offhand, but even if the court finds the statements were voluntary because he was not interrogated by law enforcement. This must be going all the way back up to the state action stuff, because I read this and I'm like, well, why would I think that? Why would I think that? It's not explained. So I think this is going back to what they were getting into with the state action piece of the argument way back, that you can have that even if they're not like actively interrogating him, if they're creating the circumstances that are leading him to be in this condition. But I'm having to reach, to be able to get there. This is just this is maybe coming off as critical. I'm really not intending to be super critical of this brief, because it's so difficult to deal with, these many issues and this much complexity and stuff. I mean, this is a massive brief. There's a lot to cover. And you're never able to get it perfect anyway. You're operating under time constraints. Writing is one of those things. It's like art. A lot of the times you're never done. You just stop. You reach a point where you stop, because you could fiddle with it forever if left to your own devices. 1 second. All right. Had to see what the cats were getting into. It's nothing too worrisome. So I'm not intending to be like nitpicky and pick stuff apart. I'm just, trying to identify stuff that I notice. And, I don't mean it as like a criticism of them or anything like that. I'm not even suggesting that's wrong. I'm just, kind of noticing. This is my reaction to it. The court could have a much different reaction to this because they are in a different context. They have a much, broader familiarity with the Indiana case law, the Indiana culture, all that stuff than I do. So this may make perfect sense to them. To me, it's just, I have to think back. So I noticed that. But the brief is never going to be perfect. It's fine. And then finally, the error was not harmless. There we get our Chapman standard. Constitutional error must find it harmless beyond a reasonable doubt in order to say, hey, no harm, no foul. Confessions are given so much weight and so inappropriately. They really are terrible evidence, but we have this idea of them as being so inculpatory because people always think, well, why would anybody say something like that if they didn't mean it? I would never say anything like that if I didn't mean it. Well, we saw Richard Allen say that in his initial interrogations. Everyone thinks that, but that's not reality. It's not reality. Everybody can find themselves in situations where they'll implicate themselves if they think it's the lesser evil. There's been a lot of study of this. I've talked before about Duped, Saul Cossen's book. It's a great book. He talks a lot about it. A lot of reasons why people will do that. One, you just have short-term thinking. You're trying to get out of the present situation is very uncomfortable and painful. And if you give them what they want, it will end. Another part of it is they think, well, it'll get the truth out. It won't actually go anywhere because people will figure out it can't be true. It wasn't really me. So they don't necessarily take it that seriously. There's so many reasons that go into this, why people will confess falsely, but people still just think it's super strong evidence, really compelling evidence. And just a lot of the time it's not. They were a large part of the state's case. Yeah, they really were. The prosecutor particularly concentrated on it, especially the fact only the killer would know. And they countered his confident and unwavering pre-solitary protests of innocence. If they get to the confessions being a problem, I don't see there being a harmless error issue. I think the bottom line is the problem with this is that the court is just not going to want to be the arbiter of the truth of what was Richard Allen's condition. The Court of Appeals, that's not their role. They don't want to do it. And then they're also going to be thinking big picture about this is a novel situation. This is unprecedented. So we are making law that's going to apply broadly. And can we do that? So as much as I think they want to win this issue and think they should win on this issue and think it's important to win on this issue, honestly, legally, I think it's their weakest one. I think it's going to be the hardest one for them to win. Maybe that's why they focused on it so much, knowing that. And it's buried in the middle, primacy and recency, that does comport with that general philosophy. So it might be that they know, and they're just swinging for the fences with it. Factually, it's so powerful and so persuasive. But legally, they're just not on a good footing with that one. So this has been a little bit depressing so far. So now let's talk about the good stuff, right? Because this is where, in my opinion, if he's going to get a new trial, I think this is what it's going to be about. It's going to be about this failure, this breakdown of the adversarial testing process. The fact that he had one hand tied behind his back, at least, I think Brad, or maybe it was Andy, said they had to fight this with both their hands tied behind their backs. And they kind of did. Like, all you can do is dodge, try to dodge. And then the court says, no, you're ducking. I'm going to take a point away. It was never a fair testing process. And because of that, you can't rely on this as being fair, as being just, as getting the right outcome. Because the whole point is two people opposed in competition present their best case, and may the best man win. So if you don't get to present your best case for arbitrary reasons, then the process is not worked the way that it's supposed to. And this, I think, is very easy to understand. It's very consistent with the facts. And I think it also provides the remedy that is going to be the most inviting to the court, the most acceptable to the court. They look at this whole situation and they see there's like we agree, we think there's a big problem here. They're not going to be inclined to just throw everything out, right? Which is what they kind of suggest from the first assignment of error, the warrant. You should throw it all out because you're left with nothing once you take out the confessions, the clothing, the gun, all that stuff. You're left with nothing, but he's got some blue clothing and so forth. They're not going to want to do that because, again, they don't want to be the arbiter of what's true, what's real, what the facts are. They want other people to decide that, and especially a jury. But a fair trial, remanding it for a fair trial. Now, granted, they don't want to order a new trial. Nobody wants to do trials, especially big, high-profile trials, over again. But it's much more of a it's consistent with the role they see themselves playing in the process, and it's also consistent with the kind of respect and honor that they want to pay to the jury and the jury's ability to make good decisions. This argument, presented well, is gonna kind of get you to think this jury has been swindled. This jury has been swindled. They reached a decision that they wouldn't have known any better because they were so misled about what the facts were. And so give them an opportunity to get it right. Let's just do it over and have a fair fight. Nobody really wants to do it over. But if we're buying that, yeah, there is something fundamentally wrong here. We do not have confidence that we have the right guy. There's too many factual problems. There's too many procedural problems. Too many ways in which he was not allowed to put his best foot forward. Then the remedy gets a new trial, and that's gonna resolve that problem. It's just it's very direct. It's very responsive to the nature of the issue. Just do it over. Okay, and also you judge, don't mess it up so bad next time. It's your fault. We're having to do this all over again because here's how you acted in a way that was not reasonable in restraining this guy's ability to make the case that he didn't do it. So always constitutionalizing it when you're a criminal defendant. Yep, you have a 14th Amendment due process right to a fair trial. You have a fair opportunity to defend against the state's accusations. Can't be arbitrarily deprived of that. You must be permitted to confront and cross-examine witnesses, and operates in conjunction with the Sixth Amendment, which also has a right to complete a defense provision to it. Although trial courts have broad discretion in conducting trials. Now, here's where these principles kind of come into conflict, because you have a constitutional right to present a defense and to call your own witnesses and cross-examine the states and so forth, present relevant evidence. You don't have a right to present things that are not allowed under the rules. So you always kind of run into conflict with these types of decisions because the court, at least ostensibly, has applied the rules of evidence to say you're not allowed to do this. So you're always in that framework of evaluating the evidentiary ruling, and the evidentiary ruling is abuse of discretion. It's another deferential standard where we kind of presume they got it right unless it's so out there, it's so misguided, it's so misapprehending the law or the facts that it's based on, that no reasonable judge without those misapprehensions would have reached the same conclusion. So it's a tough standard, showing an abuse of discretion. And that's why, to the extent you can, trying to cast it in constitutional terms can be helpful, but you're still always going to have to show the underlying ruling itself was a problem. So they're going to do that. They're going to make the argument that there were several reversible errors under the rules of evidence in Indiana's trials rules, and in many instances, because of the nature of the rulings and the effect they had in the overall picture, they led to him not being able to present a fair defense. Now, this is an interesting description of the standard of review here. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion, like we just talked about, to the extent those claims implicate constitutional issues, this court reviews them de novo. It's kind of an awkward sentence, an awkward way of describing it. Here's what I understand it to mean is that you'll look at the evidentiary ruling itself as an abuse of discretion, but you decide independently de novo whether that abuse of discretion, assuming you find it, amounts to a deprivation of the right to a fair trial. There's no deference on that. The Court of Appeals decides independently. That's kind of how I understand this explication of how that standard of review works. Errors will be disregarded if its probable impact in light of all the evidence is sufficiently minor so as to not affect the substantial rights of the parties. But when the error is constitutional, the standard is higher. So in other words, it's normally if an evidentiary ruling is wrong, you don't have this constitutional error of harmless beyond a reasonable doubt. It's much more just contextual. You know, we don't assume that it was harmful. We just look at it in context. With the constitutional error, we assume that it's harmful, and then it has to be shown beyond a reasonable doubt to be harmless. So that's the general advantage that you get when the evidentiary ruling implicates the right to defense. So first, excluding Blair's sketch of Bridge Guy. Powerful evidence, wasn't it? Violated the rules of evidence. She, as far as I recall, kept it out as hearsay. That was the argument. It's hearsay. It's out of court statement. Out of court statement, or at least it was based on her statement, you know, offered for the truth of the matter asserted. That was the person that she saw. So first they start with relevance. It was definitely relevant how she described Bridge Guy, because it proves she did not see Allen on the bridge. And that's a pretty relevant fact. The guy that she saw is Bridge Guy, and that is not Allen. That's an issue. This would have been, you know, I think about what this would have looked like if anybody had asked her at trial, Richard Allen, the guy sitting right in front of you, is that Bridge Guy? Is that the man you saw? And she'd said no. You know, where would we be at now? Like, assuming the jury rejected that, would we be in a stronger position on appeal, or would we be in a weaker position on appeal? In some respects, we're in a weaker position, because then the court would be thinking the jury already knew that he didn't match the description. So it would kind of maybe take some of the weight, the persuasiveness, the significance of this argument out of the picture. It might make it more likely to be seen as harmless. You know, okay, they didn't get to see the sketch, but they already knew she said it wasn't him. So it's less significant in the grand scheme of things. Maybe it was a smart strategy to not ask her. She shows he looks nothing like the person she saw. Yeah, this is all relevant. This looks nothing like Allen. We've got the pictures of him from the time. He looks nothing like that. Also shows she and Carbaugh saw different people, and the state's timeline is dependent on them seeing the same person. It also impeaches the investigation and shows law enforcement bias against Allen. This is a good argument. I hadn't thought about this, but this is another reason why it's potentially admissible. Now, I don't know how much the Court of Appeals in Indiana will credit arguments like this that weren't made in the trial court. This is one of those things where they can kind of do with it what they want. It's the issue hasn't been waived, right? The issue of whether they should be allowed to present the sketch to the jury. They didn't waive that by not arguing it in this particular way. So it doesn't come up like that. But often courts will say, you know, this issue wasn't raised below, and so we're not going to decide it for the first time. Or, you know, we're not going to rely on it or something like that. So I don't know that this is necessarily going to, like, let's say the court buys this argument. I don't know that this reason for it is necessarily going to make it into their justification because of the fact that it wasn't raised below. They might just kind of ignore it, you know, not even mention it. But I do wonder if it would factor into their thought process, because it certainly did for mine, because this is a non-hearsay purpose. using it not to show the truth of it, but to show law enforcement had this conflicting information and they handled it in all of these, strange and kind of contradictory and inappropriate ways. They changed their position. They never showed it for the first part of the investigation. It was just the Carball one. So 2 years later, they let hers out, distinguish it from the person Carball saw. And then only after Allen's arrested, now we changed the story again. And now it's all supposed to be the same person. I think this is a fairly decent point, that it shows that law enforcement doesn't have a consistent theory of who these people are or how they fit into any of this, or even if any of them fit into any of it. So that's a good argument. I hadn't thought about that. I think that's very clever of them to bring that up. It was reliable and probative of Bridge Guy's identity. It was made at the time. She developed it, said it was extremely accurate, affirmed her confidence in the sketch. This is important. It's not hearsay, she says. Not hearsay because it's not a statement. And although Indiana has not reached the issue, apparently no case law in Indiana about whether a sketch constitutes a statement or not, other courts have held that it's equivalent to a photograph. I can see that. I can really see arguments both ways on this one, because it's not a photograph. A photograph doesn't require any kind of input from a person at all beyond, deciding where to point it. And I mean, yes, there's all the little things like what's my exposure, my f-stop, and all that stuff, which really can change the appearance of the picture that you get at the end of it. But I think the issue here is that it requires her to communicate something in order to be able to produce the sketch. It's a representation. It's not a direct capture of what it is that she saw. So I don't know. I mean, good. They've got some case law that says that. Collecting cases tells me there's more than one. These are obviously not binding authorities. If they're collecting cases, they might also be collecting contrary cases. I don't know. I mean, they haven't told me that no court has said it is hearsay. The courts have universally agreed that these types of sketches are admissible. So I have to assume there's some contrary authority, and there is probably some reasoning for that. And if there is, it might be helpful to rebut it. But the statement is not hearsay if it's an identification. So this is another exception that they're arguing, that it doesn't fit within the hearsay rule because it's a statement of identification. I don't think it really fits within this either, because an identification is that's the guy. Now you could I could see how you might be able to analogize it, that I'm drawing a picture of the guy that I saw, that's the guy, and I'm trying to communicate it. But that's not really, I don't think that's typically what a statement of identification means. It means I have that picture in my mind and I'm being shown somebody and I'm saying that's the person, the photo lineup, that type of thing. So I think this is clever, but I'm not super sure that it fits. Now, this is a very interesting argument. I like this a lot, that it's an adoptive admission. These guys are very good with the evidence rules, very, very clever, and just skillful use of them. Like, I wish these guys had been at the trial counsel table, so they could bring all these things up. It's admissible as an adoptive admission. A statement is not hearsay when it is offered against an opposing party and is one the party manifested that it adopted or believed to be true. It's pretty critical to the state's case that Richard Allen is Bridge Guy, and the guy that Betsy Blair saw on the bridge was Bridge Guy. Therefore, it should look like Richard Allen. And it clearly doesn't. They said back in 2019, this is Bridge Guy. Yeah, they're the ones who said it. So being able to impeach their position now that Richard Allen is Bridge Guy with this photo, this sketch of who they said Bridge Guy was. Yeah, adoptive admission. I like this argument. I think that that's pretty strong, and it also just goes to the fairness. I mean, these guys can't surely be able to be allowed to just like jump between whatever position happens to benefit them, depending on what they want to accomplish, and not ever have to explain the change. Surely it should be like kind of there with testing the evidence and cross-examining and so forth, that you should be able to confront them on your inconsistencies and your maneuvering and how self-serving it looks for you to decide now that guy's Bridge Guy, when for years you've been telling people this guy that looks nothing like him in the sketch is who Bridge Guy is. I find this argument, personally, I find this particularly powerful because it goes to the heart of it, doesn't it? It goes to the sketchiness of this prosecution, the manipulation, the omissions, the misrepresentations, and so forth. The only way to get a conviction here was to skew the facts and skew the evidence. And so to be able to take this position knowing that they weren't going to be challenged on it, I like it. Admissible under the common law, helpful, but generally speaking, the rules of evidence tend to be interpreted as overruling the common law to the extent that they are not consistent. So if it was hearsay under the rules, the fact that it was admissible under common law, I don't think is going to get them there. But even if the sketch, this is an interesting argument. I don't know that it will win, but it is interesting. Even if it was hearsay, he's still entitled to use it because hearsay must yield to the constitutional right to present a defense. And when identity is crucial to the case, a defendant is entitled to defend on a claim of mistaken identity. And this right cannot be abridged through the application of arbitrary or disproportionate rules or the mechanistic application of otherwise rational rules. That's a strong statement of the law, basically saying sometimes the rules of evidence don't matter. The court's not going to be super inclined to go down that road, I don't think. But it is still clever. I think here's what they're getting to. It was critical to the case. This was crucial. And they tilted the scale when this evidence was kept out. I really like the adoptive admission point because it undermines the state's argument. It undermines the whole point that they're making. We think this is Bridge Guy. We've identified Bridge Guy. No, you haven't, because this is Bridge Guy and he looks nothing like him. How can you not be allowed to do that? So it was harmful under both the constitutional standard, under the evidentiary standard. They argue. They don't really go into a whole lot of detail why, other than just it's really critical to mistaken identity. Is it a minor thing that they didn't get to see the sketch? I mean, they heard the description, right? That's the argument for harmlessness, that they already knew she described him as a 20-year-old, beautiful face, poofy hair, no facial hair, etc. So they kind of already knew he didn't match Richard Allen's description. Does this add significantly to that? Well, picture, speaks 1,000 words. We'll see. I like that issue. It's not the strongest one of these, in my opinion, but it's a good one to start with because it really does, I think, emphasize how having that visual helps appreciate just how far afield this whole process was from something that was fair. That if you can't show that, you can't show like the picture that shows he's not bridge guy, then I mean, come on, why do we even have a trial? Why do we even have a trial? Excluding Tobin. This I think is going to be particularly strong. The judge excluded him because he was not a firearms expert. He was untrained in firearms identification. He did not examine the evidence in this case, and he did not conduct a firearms examination. These are unfounded and largely incorrect. And to the extent she says it's not relevant, that's wrong. It was clearly relevant. The bullet matching was relevant. There was potentially a question of, is it cumulative, right? Because the defense already had an expert. And so you don't, get to bring on like two experts to say the same thing just to kind of bolster each other and say the same thing over again. But that's not what this was. In multiple ways. One, he had the different level of expertise to be able to bring to the analysis. But also, he is not in favor of ballistics at all. The other guy they brought in was a ballistics examiner. He's like, we think it's great. It just needs to be able to be validated a little bit better. So the jury never got a critique that like this whole doctrine here is some horse shit. Okay. They never got the real solid criticism about that. Now, the state's going to probably argue that they got close enough with the expert that they did bring, because he acknowledged, yes, it's subjective and there's ways to, ways to limit that and things like that. But he has got the expertise. He's done it before. These are things that deal with the criticisms of this methodology. It was essential for assessing Oberg's credibility and determining what to believe. This, I think, is an important part of the context because what they were allowed to do with the expert that they had was basically disagree with Oberg, but they didn't really get to, undermine her on a real fundamental level of like, here's the fundamental problem with what you're trying to do in terms of your testimony. Being able to identify this gun to the exclusion of all other guns in the world is not scientific. Your standard to be able to make your conclusions is circular. It's self-referential. It's is there sufficient agreement between these things to make an identification? Who the hell knows what that even means? Oh, you just decide what it means. That's not science. So the jury never really got to hear that. They heard from somebody who believes in the methodology, but, has like light critiques of it. The jury is ultimately responsible for assessing the witness credibility. And so that's why it's important that you be able to challenge it, that you be able to test it fully. So she testified, yada, yada, everything she does is great and it's super sciencey and whatever. Tobin's experience would help a jury understand the scientific community's criticism of Afty's subjective methodology and force Oberg to engage with that critique. What does it mean? What does it mean to say that it's subjective, and why is that a problem? They really didn't get that. Again, I think that's where the issue is going to be with this one is it harmless in light of what they were allowed to do? Was this cumulative to that? I don't think it's cumulative to that, but they might have been able to get close enough to where a court would say, doesn't necessarily amount to a huge difference between what they were trying to do and what they were able to do. So here, Oberg's credibility was central to the case. The exclusion was arbitrary. Now they say that, but they haven't really spelled out, super clear. Here's the facts. He's an expert in the Afty methodology and his shortcomings. He's experienced, and he examined Oberg's materials. tie that back. It just would be helpful. It would be easier to follow, to tie that back to here's what she said, right? Here is what her reasoning was. But in fact, here is what he brings to the table. Just so that you have that juxtaposition and it's a lot clearer. He didn't waive his right to appeal the Tobin issue by calling Warren. That's a potential issue with it, right? Oh, she said you couldn't bring that guy, but you went ahead and called the other guy who presented the slightly different opinion. So they're arguing that's not a waiver of it. You're just responding strategically to what you have to do to deal with a bad ruling. So I don't know that that's really the issue, but I do think, at least that's what I'd anticipate. That's where I anticipate the state would go with this one, is to argue, well, it's harmless because this is not a big deviation from what Mr. Warren was able to testify to in the first place. And he did, in fairness, get into somewhat of the limitations and the critiques and stuff like that, but undoubtedly not to the extent that Tobin would have. So we'll have to see, but they did definitely bolster old Oberg's credibility about the never being wrong. And that's where Tobin might be the strongest, with having something to say about that and what it means to make a statement like that. What does that imply? How would you even establish that scientifically? Had they heard his robust impeachment of Oberg's methodology, the outcome of the case would probably be different. Maybe in reply, we'll see, like, where did Tobin differ from Warren? Where would he have added to it? Where would he have built on it? Where would it have been more substantial than what we did get from Warren? Because I do think that's going to be important, but they didn't spell it out for us here. Court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. The Googling. Yep. If Allen committed the murders under their theory, they said straight up he left the scene by 3:56 or whatever, it never came back. So shouldn't be anything going on with the phone, but there was, and they got to rebut that by Googling. Yeah, this is definitely hearsay. There's no, this is people talking on the internet outside of court, not under oath, being offered to prove that what they are saying is true. This is not only hearsay, this is the classic unreliable hearsay, because who the hell even are these people? And how do they know? They're at least double hearsay because the internet forum itself, the writing on the posting, whatever the question is, and the statements that are posted there. So everything has to fit within an exception to the rule. There's no exception to being able to just use your expertise. He's an expert witness, Cecil was, to be able to present stuff, parrot facts that the expert adds nothing to. You don't get to just be a mouthpiece for what somebody else says that you haven't evaluated and you have no idea whether it's true or not. So this is kind of the balancing, because they can generally, experts get leeway to base their opinions on evidence that is not normally admissible. Goes back and forth in different courts about whether they get to actually tell the jury what they relied on when they relied on stuff that isn't admissible. So, but it has to be stuff that experts in the field reasonably rely on. And how many experts in the field are reasonably relying on random shit they Googled? That's just not. That doesn't even pass the laugh test. It really doesn't. So this is just parroting. He was just a mouthpiece for what it said on Google that was convenient for him, and so he adopted it. This is a clear error to me. Absolutely an error. It's wrong. It was obviously hearsay. I've pointed out on Twitter before. I literally have won an appeal on an issue like this. A detective going and looking up random information on the internet and presenting it as evidence. It is not. It is hearsay. So admitting that is a problem. And the question is really just going to be the scope of it and the extent of it. In and of itself, does that undermine the state's case enough to cause reasonable doubt? It might. It might. Because the timeline is pretty important. And if Richard Allen never went back there, then you need a better explanation for who was plugging in and unplugging the headphones out of the phone. But chances are, I think it would be received more, and like the significance of the error would be regarded as more important if it's in conjunction with other stuff that they also find is a problem. So, continuing with that. Impeaching his confessions. When a defendant confesses, the manner in which the confession was obtained is relevant to the confession's credibility. The context matters. The context does matter. And so they allowed him to play it, but no sound. No sound. Why? Because the sounds were hearsay and self-serving hearsay when a defendant admits their own statements out of court. The problem is these were not offered to prove the truth of what was being said. Quite the opposite. Nobody is asserting that Richard Allen actually was in World War III, or that Rocky Balboa actually is his favorite actor, or anything like that. It's offered to show his state of mind, the fact that he was off his rocker while he's making these, confessions that the state is putting so much weight on. So these were never hearsay. There was not a valid hearsay reason to keep him from being able to present that context to the jury. To the extent there are older cases suggesting a defendant can never admit his own statements, those decisions are inconsistent with and should not survive the adoption of the modern rules of evidence. This is them using the rule I pointed out before when they were saying the common law allowed admission of sketches. I don't know that survives the admission of the adoption of the rules of evidence if the rules of evidence wouldn't allow them to come in. They're just, kind of taking the opposite side in a different context, which, you do sometimes, but pointing that out. It's also relevant because it impeaches Dr. Walla's testimony and undermines her medical records. It puts her claims in context, doesn't it? When she's saying, oh, he was perfectly clear and cogent and rational, and his statements were concise and he was organized and so forth. Seeing what he was like in the same time frame, potentially tends to undermine that. And so you can confront her with that and then make her explain. So are you saying that 5 minutes later, he was totally normal? Is that your testimony? Make her explain. Is this what you saw? And this is what you described as rational and organized and so forth? Paints a vivid picture of solitary confinement's harsh conditions. This is the context in which these confessions came about. Seeing it is one thing, but hearing it is another. So the audio shows his statements in solitary confinement are unworthy of belief. This one, again, as always, this is all going to go to harmlessness. I think most of these are going to go to harmlessness. Did the jury hear enough that this is adding anything new, anything material that they didn't already hear? Because they heard that he was raving. They heard that he was saying, nonsensical things. Is there something in this audio that really tips the scale? And if not, then why is hearing it for ourselves so much more important than just hearing somebody report it from a note that they wrote down? that argument just wasn't really fleshed out a lot, but I think it's there, that the whole reason we defer to juror decision making in the first place is because they are in the position to evaluate tone and demeanor, and we kind of recognize that those are important factors in evaluating a statement. And so if we're being told, hey, maybe Richard Allen is malingering, he's feigning symptoms, would it be helpful, more helpful for us to be able to see and hear all of this for ourselves versus just reading it in a cold transcript? I think that argument's there. I don't know that the court buys it, but I think it's there to be made. So definite error, in my opinion, on this one issue is going to be harmlessness. Trial court committed reversible error in prohibiting the jury from hearing 2 phone calls Allen made on April 3rd, 2023. These were offered under the rule of completeness, that these were necessary to be able to understand the context of the one phone call that they did present when he calls Kathy and says, maybe I did it, I think I did it, and so forth. So the context around it weren't allowed to come in. And they've got some additional arguments for why that's a problem. Okay, because Trooper Harshman, it should have been admissible to impeach Trooper Harshman when he said, no indication of duress or stress. What about right before? What about right after? Bookending that particular phone call. He was forgetful. He thought he was being mentally tortured, etc. These phone calls, I think, are important, but it's the weakest from a legal argument standpoint. As you look through this, you see they don't actually cite any law in any of it. And that's always going to be a little bit of a challenge. It's just another example of how heavily the defense is relying on the facts in this case to really make the case for reversal, much more than the law. Got to confront what the legal ruling was, right? It's hearsay, not going to admit it under the rule of completeness. It needs to be addressed why that was necessary, to put it fairly in context. The rules permit it, and since the rules permit it, it's arbitrary to not allow them to do it when it has such an important role in being able to evaluate what it means and how important it is that he made this statement in the second phone call. So I would like to see more law on that one. Would have been more helpful. Excluding the statements that were the foundation for Dr. Grassian's opinion that his confessions weren't credible. So he didn't get to provide the basis for why he's saying these look like a false confession to me. Why? He said a bunch of things that weren't true. And no, that's not hearsay, because we're not saying they are true. The fact that he said, I shot Abby and Libby, is not being offered to prove that he in fact did. It's quite the opposite. It's being offered to prove that he didn't. And therefore it makes no sense that he said it. And the things that he said he did are not reliable. That's why you're bringing it up. It's not hearsay. And now this is the other side of the opinions, this is a little bit risky, right? Because you just said Cecil doesn't get to do this with Google. This is the catch, right? This is where I see the difference between them. Relying on a random internet troubleshooting forum is not the thing that I would expect forensic data analysts to be looking at. These are apples and oranges. Does the phone behave like there's a headphone in it for purposes of being able to fix my headphones so that I can hear sound is a very different question from what sorts of codes are produced inside the phone from these different phenomena. So I wouldn't expect them to rely on, random Google user oriented stuff to be able to make that type of decision. Statements, records, documentation, all the medical notes and the the notes of the suicide companions and all that type of thing. Those are the types of things that I would expect an expert, on false confessions is going to be looking at. So there is a difference there. That even if it was hearsay, which it's not, because nobody's saying it's true, that's the whole point, is that it's not true. It's fine because he reasonably relied on it. And finally, it should have been admissible because of the whole argument that he knew facts only the killer would know. But he confessed to a bunch of stuff that wasn't true. They didn't screen him for delirium. He should have been able to counter that with arguments that it was false, it was inconsistent. I think that's pretty strong myself. It goes to his reliability. He's just kind of making stuff up and shooting it out there and seeing what works. It paints a very, very different picture than a guy who just out of the blue suddenly decides to provide details, and those details happen to fit their facts. It's a very different situation. Trial court committed reversible error in denying his motion to correct errors. This is based on the eliciting false testimony and allowing it to go uncorrected based on the Brad Weber van testimony. This one is a challenge to me. I talked about this at the time, back when the motion was filed. The challenge that this particular issue has is the fact that they had this evidence and could have brought it up. And so really this error to me belongs in the ineffective assistance of counsel framework. It just doesn't really fit in there on direct appeal. Other than the fact that it made it into the motion to correct error. And the reason why is because when you have conflicting evidence, it's really hard to say the state is knowingly eliciting false testimony, because people can be mistaken, timestamps can be wrong, there can just be different ways to reconcile stuff like that. And so if this had come in at trial, we would have kind of more of a record of how those things worked out. Maybe there's some explanation like, oh, his phone signal doesn't pick up until he gets all the way to the house, but he, drove past the bridge and then he parked to do something, there can always be something. And that's the problem. Because to get the court to believe, to go ahead and accept the prosecutor knowingly elicited false testimony, they're disinclined to do that unless it's indisputable. There's really no other conclusion that can be drawn based on the evidence. And I just don't think we have the record for that particular issue on this one. I think it's unfortunate. It's a situation that belongs more in the context of ineffective assistance of counsel, because they had this. And had they brought it up at the time to impeach Brad Weber, with the timeline, might have solved the problem. Would have at least gotten the jury aware of the fact that, oh, you're saying this after you've changed your story a whole bunch of times, depending on who and when you're talking. But when we look at the actual objective evidence of what happened, the timeline doesn't fit. So, this is what it turns on. Weber's testimony was false and the state knew it. but they're very disinclined to reach that conclusion. I don't think they're going to on this particular issue. Now, the trial court committed reversible error when it excluded Allen's evidence explaining this murder as a ritual killing. Starting to get into the third-party culprit stuff, aren't we? Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime. Yeah, it's pretty relevant. Pretty relevant that this crime scene is inconsistent with what the state's theory is. The state's described just an opportunistic, out of the blue guy with no criminal history decides to commit this offense in the middle of the day, does these extremely strange things out there for reasons they can't explain, and then goes back to work at CVS in Delphi for years, puts himself at the scene, all of that. The expert has a whole different explanation for why the scene looks the way it is that tends to imply, without even pointing the finger at anybody specific. This is the difference between the Sodi defense and the Toady defense, as they sometimes get called. Sodi is the some other dude did it defense. Toady is that other dude did it defense. And so that other dude did it defense, that can often be a harder hurdle to clear, to be able to present. They don't want you pointing the finger at random people for not good reasons, right? Don't necessarily agree with that rule. It should be the same rule of relevance that is applied to any other type of evidence that's presented in court. But some other dude did it. That doesn't have those kinds of implications, where I'm not pointing the finger at anybody specifically. I'm just saying, hey, here's why it doesn't look like me. And that's squarely in the situation here. This crime scene looks a lot like somebody else did it. And so why don't we get to bring this in? It explains she had the knowledge, skill, and experience to offer this testimony. It meets the standards for admissibility. It's explaining the trial scene, explaining the crime scene. It's explaining the investigation and the course that it went down. It's not conjecture. This theory originated with law enforcement and from a number of experts, the FBI's experts, the academic experts, the undercover guy who's like dealing directly with these people doing these rituals. It would have been helpful. Some good case law here, some good language. If this is good descriptions of what the cases say. When a murder scene is complex or unusual, it's important that the jury receive an explanation. Yeah, if you've got a different explanation, that seems pretty relevant, pretty pertinent. Jury would naturally want an explanation. What was going on with this scene? What they haven't told me in any of this is, why was she excluded? What was the basis for excluding her? Did this just get wrapped up in the whole no third-party culprit thing? Or was she independently presented, as an expert for any of these other kind of more generic reasons? It's important to know what the basis was for the ruling, because at least in theory, that's what we're doing on appeal, is reviewing the ruling. We're looking at the decision made and saying, is that right factually? Is that right legally? And so I need to know what the decision was. And that's not clear to me from this part of the briefing. So that is a weak point, I think, in it. But from a standpoint of like, should this have been allowed? Yeah, it seems like, barring everything else, barring some problem like, I don't know, Maybe they would say they didn't ask to bring her specifically in the absence of like identifiable potential third-party culprits. I don't know. So this is going to be one where I think we'll see what the state's explanation is. And if they provide some context to this ruling to suggest, that's why, she was excluded, that it wasn't based on her expertise or her relevance or anything like that that's been briefed here. It was for some of the reason. I just don't know. They didn't tell me in the brief. So that's not super helpful. Harmless, again, seems pretty important if the jury thinks, yeah, this is probably a ritualistic murder. What they're saying makes a lot of sense. It adds up with what we can see with our own eyes. We have no evidence that this guy, Mr. Allen, has anything to do with any of this stuff. Might that get you a different outcome? Yeah, it might. And then especially if you have that combined with other potential errors, like, should have been able to show the context of his confessions and things like that. It all just chips away at the conclusion, right? It has a they don't specifically argue cumulative effect, but that just, it kind of has a practical application anyway. You look at the total circumstances in light of what did happen and what should have happened. And so then the trial court denied his right to show the investigation was incomplete, overlooked plausible leads, and mishandled evidence relating to third-party guilt. They're dealing with the third-party suspects in a way that I think is smart, which is taking it out of the framework of the very specific toady defense and just putting it in terms of impeaching the investigation. This was the Karen Reed case distinction between the third-party culprit and the third-party culprit as to Bowden, based on this case that they had in Massachusetts, the Bowden case, that said you can bring up other people that law enforcement investigated in order to show they didn't do a good job in their investigation. And this is the same theory that they're bringing up here. The accused can create reasonable doubt by showing that the investigation was incomplete, overlooked plausible leads, or that law enforcement mishandled evidence relating to a third party's guilt. So we're not bringing up Brad Holder and Patrick Westfall to say they did it, not me. We're bringing them up to say law enforcement really never did what they needed to do to exclude these people. And that's kind of important because you got the whole 5.5-year gap between Richard Allen showing up and getting interviewed by Doolin, and then all of a sudden, out of the blue, we're looking at him again. He'd been cleared originally, but now we're going back and looking at him. Well, these guys had been cleared, hadn't they? And yet you never went back and looked at them. Why the difference? Why the difference? Hi, Joni. How you doing, sweetie? I know it's getting a little bit late. It's getting a little bit late. You're getting a little wild because you're sleepy. That's okay. We'll get to it soon. Here, Allen presented evidence that the state performed an incomplete investigation, mishandled and destroyed evidence, overlooked plausible third-party leads related to pagan rituals. Yeah, they had the connection with Abby and Libby. At least with Abby, they knew who she was. They knew where she was going to be. They have the connection with the paganism. They have the connection with Delphi because that's where Patrick Westfall is. You have the whole weird, series of Facebook stuff that is just deeply coincidental at best, right? Very deeply coincidental at best, because nobody's supposed to know, what the crime scene looked like. But, he's out here with his paintings and with his weird other images that just How many people normally are like posting images of dead girls with sticks on them on top of their bodies? Can't say I've seen that often in a lot of years on the internet. Various social media platforms haven't run across that very often, so it does seem like quite a coincidence. Westfall knew the woods too. They both changed their story about, or at least contradicted each other, about knowing Abby. Holder puts her in Patrick Westfall's house. So a lot of people suspected Brad Holder. Nobody suspected Richard Allen. The alibi was a bust. They never bothered to confirm. They never looked at the video to confirm. It was actually Brad Holder who clocked himself out an hour and 15 minutes after his shift was done. Nobody ever talked to his supervisor about, hey, was he working late that day? Why? What was he doing, etc.? Nothing like that. So those things could raise a question about, should we have been a little bit more suspicious of him under the circumstances? And should we have, if we're reopening closed leads and looking at them years down the road, why on earth are we looking at the guy who just came to us and said he was there instead of the guy who has the connection, shares the interest in the ritual activities that appear to be reflected in this crime scene, and so forth? Oh, and lied about knowing her and stuff. Crazy. The fact that law enforcement officers wanted to continue investigating Holder and they said no seems to strengthen this to me. Because it shows that this is not like a universally accepted investigative process. It had dissent within it. People thought this was wrong. You should be going down this path. And so it just tends to show you didn't have a good reason not to. Even your own cops who were investigating this wanted you to keep going down this road. The story about AW changed is a big one. Never met her once, met her twice, and at least once shortly before her murder at Westfall's house. At Westfall's house. What on earth is she doing there? The statements from Holder about to his wife. Now, these probably are hearsay. They might be statements against interest, because do they implicate him in and of themselves? I don't know. Maybe not. They implicate somebody else. But at least you should be taking these statements and investigating Holder and Westfall with them, right? Did this come up in their depositions? I don't know. I know Holder's deposition is in the record now, but I haven't had a chance to look at that yet. So anybody knows, I'd love to know. So it shows a shoddy, incomplete, and mishandled investigation into this murder as a ritual killing and raises a reasonable doubt that Holder and Westfall were responsible. Now, to the extent that they're getting it all into the nexus issue, that they should have been able to point the finger at these specific people and say that they did it. I mean, they're essentially saying there is a nexus. I mean, I've had that issue from like day one, really, with this third party stuff. Of course, there's extremely good reasons to think that these guys are involved. I mean, it would be one thing to be like, hey, this looks like a weird ritualistic scene, but we don't actually know any practitioners of this stuff. It's just abstract. But no, this is like real, concrete. We actually have somebody in the neighborhood who knows her, who does these things. So it kind of makes it less likely that they just came up with that out of the blue, doesn't it? If they just came up with it out of the blue, you'd expect not to really find anybody that fits it, because they just kind of fabricated it and it's absurd. But that's not what happened. They came up with it. And then it so happens, yeah, this guy with the connection happens to be into that. Looks pretty nexusy to me. The error violated the Constitution and affected the jury's decision. I mean, I would think so, right? Because if you don't have any reason to think police developed any better evidence than what they had against Richard Allen, then you might be inclined to think that the case against Richard Allen was strong. And so if you had perspective on what they looked at and decided, nah, doesn't get us there, might change your perspective. Because there is so much more evidence against these guys than there is against Richard Allen. And bottom line. That's the case. Those are the issues. That's the argument. The very premise of our adversary system, this is what I've been saying, guys, of criminal justice is that partisan advocacy on both sides of a case will best promote the ultimate objective that the guilty be convicted and the innocent go free. That's how it's supposed to work. Both parties, fair fight, best foot forward, not with hands tied behind their back. Because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. Now, notice this in this conclusion. This is really focusing on the last set of issues, right? The third assignment of error. There's nothing in here about, how law enforcement went down the wrong path. I mean, I guess that maybe implicitly goes to his confessions and how they set it up and then, took the context away and stuff like that. It doesn't really, I mean, it very implicitly gets at they built the case, they constructed the basis for the search warrant by being misleading and omitting facts and so forth. I guess it kind of is broad enough to encompass those to some extent. But to me, this is really focusing on what they weren't allowed to do at trial and the way that their hands were tied behind their back. And that's where they're ending their focus. And I tend to agree with them that that's, if that is what they're doing, I think that is the strongest case that they have to get it reversed, is to get the court to see it was never a fair fight. This was never a fair fight. The rules were not even-handedly applied in terms of who got to do what. The state is here getting to bring in random hearsay about Google searches. Meanwhile, you're excluding stuff that the defense is trying to offer under the hearsay rule that isn't even hearsay. It's not a fair fight. And so he didn't get a fair shake, and the system didn't work the way that it's supposed to. It's supposed to be a truth-finding process. And the only way you get that is if both people have the opportunity to present their case. So from day one, the scale was tilted. And I think if they can get the jury, if they can get the Court of Appeals to buy that and to agree with that and to internalize that and that resonates, then they have a pathway here to get a new trial. I think that's the challenge that they faced with all of this. You're at a bit of a legal disadvantage, but some of these issues, you are on strong footing. It's showing the court why they matter. Why does this evidentiary ruling, in the midst of this long, extensive trial with lots of stuff going on, why does that matter? It matters not just because of how limited the case was, and so how relatively important each contradictory piece of information has the potential to be. but also just because of how it fit in the total picture of what the state was doing in this case. From day one, they were going to build it against Richard Allen. They had nothing but he said he was there. Maybe at the right time, but also maybe not. Because he said originally, apparently, 12 to 1:30 or so, 11:30 to 1, something like that. After he got back from his parents' house, got the jacket, went out to the trail. So this is a difficult appeal. I don't envy these guys at all. I really don't. Just like I didn't envy the trial lawyers, you know, it's always just so much more pressure, so much more of a heavy sense of responsibility when you're defending somebody that you believe is innocent. You believe they didn't do it, what they're being accused of. You know, it's a big burden, and it's especially difficult on appeal because of how tied your hands are. Not just by the rules, the law, the unfavorable standards and all that stuff, the way that the court is going to bend over backwards to try to justify what's already happened. But you're also stuck with what happened in the trial court. You're stuck with the facts, so to speak. You're stuck with the evidence. You're stuck with the decisions that were made that you didn't get to participate in. And, you know, that can be a very difficult and frustrating place to be. So for all that I have, you know, pointed out things that maybe I don't understand, or maybe I think could have been stronger, you know, or done differently, or whatever, at the end of the day, I really do think that they've done a really outstanding job of articulating what this case is about. All of the ways in which this injustice built upon injustice and culminated in the situation where a man was convicted who doesn't look anything like the suspect, who doesn't have any plausible, you know, they have no plausible explanation for why he created this crime scene the way that, you know, they say he did, who just acted completely inconsistently with a perpetrator like this, no criminal history, out of the blue, opportunistically commits this crime in the middle of the day, goes back to work and lives happily after going to law enforcement and telling him he was there. And then just continues to go about his normal life for 5.5 years. So they've done a good job, I think, of showing how it got to that point, and also why it's such a travesty that it did. Because if he didn't do it, then the person who did it is still out there. The person who did it got away with it. The person who did it is not suffering any accountability at all. And we have at least as good a reason to think that these two guys right here are involved than we do that Richard Allen had anything to do with it. So I think they communicated that. I think they communicated that pretty vividly. That's my take on it. If the court is going to be in a position to, you know, to do something because they care about righting wrong, I don't know what they really could have done better to try to show them how important it is to do that in this case. So guys, that was a lot more than I thought I was going to have to say. And it's rather late here. It's after midnight. My goodness. It's already hey, it's already the solstice. It's already our shortest day of the year. So guys, I'm going to go ahead and take a look at what you guys have had to say. Jason McClellan, 9507. Can you cover Article 1, Section 15 of the Indiana Constitution? No person arrested or confined in jail shall be treated with unnecessary rigor. Only 6 states have this. Is this more protection than cruel and unusual punishment? So this is separate. I mean, it is, yes, it is more protection than cruel and unusual punishment because it is in addition to cruel and unusual punishment. The Indiana Constitution has also an 8th Amendment to it. That is Article 1, Section 16. And it's almost exactly the same language as the 8th Amendment. It just has an extra sentence at the end that all penalties shall be proportioned to the nature of the offense. So they come out and explicitly say penalties have to be proportionate. That's implied in 8th Amendment jurisprudence, but the 8th Amendment itself doesn't specifically come out and say that. So the unnecessary rigor is in addition to that. It's a whole separate provision. So yes, I have to assume that it is above and beyond the 8th Amendment, but it's also, remember, the context is different because the 8th Amendment, you're talking about punishment. So you're talking about post-conviction. And you're necessarily in a different framework when you're talking about pretrial detention because, you're not being punished yet, right? At least that's the rationale. So I kind of take it to mean no person arrested or confined in jail shall be treated with unnecessary rigor. That is specifically calling out the pretrial situation as opposed to the Section 16, which is dealing with the post-conviction punishment. Now, I'm not an Indiana practitioner, of course, but I did have a chance to look up a little bit of case law on this, and I'm just going to share. Let me see. Is this the right thing? I think it is. Moore versus State. Yeah, this is the only case I was able to find like on short notice that's dealing with Article 1, Section 15, and it's in a death penalty context. And he's arguing that execution delay violates this Article 1, Section 15. And so the only thing that I found here was just this point that the cases that are dealing with Article 1, Section 15 involve physical abuse of a prisoner. And so they are kind of specifically saying here, hey, defendant offers no argument why it should be extended beyond physical abuse to emotional stress. So this is a potential, limitation of that Article 1, Section 15 argument. This might be why they didn't focus on it so much, even though like what they did point to seems to be quite strong. It might be that like there's other problems there kind of in the background that they would have to overcome to make that argument. They did argue that there was a physical component, certainly to what happened to him in terms of what he suffered, the weight loss, the self-injury, stuff like that. He was tased, we know that if nothing else, he was tased. But it's just, detaining him, putting him in a place and not allowing him to leave, is that going to meet the standard? It seems possible that it might not. And so, to the extent that they do have to rely on psychological coercion, it just might not be a good fit for that Article 1, Section 15 in light of where the law is right now. Now, this might have been the case to argue why it should apply to emotional stress and to psychological coercion, because this is the risk of what happens. You undermine the integrity of the process if you torture people into saying a bunch of fake stuff that then gets cherry picked and presented to a jury as if it's highly rational and credible. But it seems like the law maybe isn't super in favor of that particular argument on the Indiana Constitution. So that's pretty much all I was able to find about it on short notice. But thank you for that question. Jason McClellan, stylistically, do you like the insertion of photos and the quote from Nelson Mandela in an appeal? I love the photos. I absolutely love having visuals, things like that in an appellate brief. I think it's very helpful to be able to see, instead of having to like flip through and just all you've got are the exhibit citations and stuff like that. And then especially with a record this size, you gotta go hunt it down. And then you're always like searching for what's what and stuff like that. No, if it's critical, just put it in the brief. So the picture abridged guide, the sketch, yeah, it's really important. Doesn't look anything like Richard Allen. Put that in the brief. The crime scene, I think that diagram, very helpful. It's important to understand that the crime scene is weird, and why it's weird, and why they were concealed with sticks type of explanation doesn't make a lot of sense. So seeing it easily, I think is a very smart thing to do with the appellate's brief. The Nelson Mandela quote is more of a, it's more of a personal choice. Again, it just goes to the sort of literary focus that they brought to that particular part of the argument. And it's again, I think because legally speaking, it might be their weakest, but it's just so evocative in your imagination. And so the fact that, we have these associations with people like Nelson Mandela and what he went through and how he wrote about it and the way that it affected him and how unjust that was, to be able to make that association and encourage the judges to make that association. I'm not going to say that's wrong. I mean, I've trying to think of, I know I have like used quotes like that in briefs before. I just don't necessarily remember off the top of my head. Can't necessarily think of one, but yeah, I think that can be appropriate. Had a couple new members come through, Veto Mama 22 and Truth Seeker for Justice. Welcome, folks. Appreciate you joining the channel. Low light recovery. Geofence data and its concealment from Diener. Didn't that correctable error do more damage than evidence reliant on the memory of witnesses? IMEI mentioned any chance geofence is in the exhibits. Great question. Great question. I definitely noticed that we didn't see a geofence argument in the brief. And so, not real clear why. Priorities, always going to come down to having to sort out what you think you have, what you think you have to include versus what is optional, without like really knowing the details of what all of the geofence data was. Kind of hard to know, I guess, how strong or weak that particular argument was. I don't think we have seen like each and every exhibit yet. There was a whole issue, with so much being under seal and nobody knows why it's under seal because the judge never said and followed the rules to properly put things under seal. So I don't know if the geofence data, I don't think it's out there yet, but I'm not sure if it is going to be available. So I don't have a good answer for you on this one, other than just I noticed it too. I noticed that it wasn't there, and I thought, that's interesting, because I would have thought it's one of those that from a legal standpoint seems fairly strong. You just have a self-serving statement from the prosecutor that this stuff isn't reliable, but the prosecutor's statements are not evidence. They are argument. So you don't have any actual basis to be able to rely on to reach that conclusion. So from a legal standpoint, it seems pretty clearly erroneous. It's just not entirely clear what's the factual significance of it. And was it evidence that was going to be super helpful, or was it going to muddy the water a little bit? I don't know. T. Dubba, if I passed RA on the trails, the first thing I would have used to describe him, short, 1,000,000%. That's his main distinctive description. It absolutely is. It's hard to really be able to express how short he is. I'm a tall woman. I'm like 5'10". I'm not used to seeing men way down there. It's like he's a small guy. I told a story a long time ago, many years. When was it? It must have been like 2015 or so, 2014. I can't remember. It was when Lomachenko fought Rigondeaux in Madison Square Garden in New York. So I went to that fight. I took my father-in-law. We went to that fight, and we were so annoyed when Rigo quit on the stool in the 5th round, just as Loma was starting to turn it on. Lomachenko is one of my favorites. He's just incredible boxer, amazing talent. Like really nobody quite like him. Anyway, they had an after party because the Ukrainians show up for Loma in New York, and so we went to the after party. And at one point in time, they come in, the fight team, all of them, they walk right past me and go up to the stairs. So Lomachenko walks right past me, and he's tiny. He is a tiny doll of a man, and they have him on his stats as 5'6". Okay. But I'm just telling you, not even close. Okay. Not even close. And so Richard Allen, you reminded me of that. He's like Loma sized. Okay. He's a small guy. It is the most distinctive thing that you would notice about him. Everything else is pretty nondescript. Yeah, he's got a little facial hair, might have a shaved head, might be a little round depending on when we're seeing him and stuff. But the main thing you notice is he's real short. I am a 5'4" female, and he appeared very short to me. Yeah. He's a small guy. It's just hard not to imagine that isn't what would stand out immediately. Truth Seeker for Justice. I want to wish you all a very Merry Christmas and thank Andrea for all she does for us all. You're the best, Andrea, and I'll do what I did again next time to when we take this back for round 2. Much love. Well, thank you so much. Merry Christmas to you too. And yeah, I mean, that's what we're hoping for, right? We want to do this again. As much as it was awful and painful and such a challenge that Judge kind of made us rise up to be able to go in and see what was happening. Hell yeah, we want to do that again. I'm ready. Let's get it done. Harbinger of imminent death. How high must a case rise to be used as precedent? Are district judges bound by one another's decisions or only higher courts? Does it vary by jurisdiction? So, I mean, everything is jurisdiction dependent, but the rule is always an appellate court is the only court that has precedential authority over trial courts, over lower courts. And so generally it's only going to be somebody who is above you, directly above you, is binding precedent for you. So for the Court of Appeals, the Supreme Court is going to be binding. For the trial courts, the Court of Appeals is going to be binding. Trial courts are not binding on each other. Trial court decisions are typically not precedential. In the Court of Appeals, depending on whether they have published and unpublished opinions, that can also affect whether it has precedential value. If they don't publish opinions, then it's just a system that they've built in to be able to say, well, for whatever reason, we're not going to treat this one as prejudicial or as precedential. It's maybe unique on its facts. It's not broadly applied. It's a simple, straightforward application of well-established law. It doesn't break any new ground legally. Washington, we do a lot of unpublished opinions. Probably most of the opinions that come out are unpublished. And so they really only make Court of Appeals decisions precedential when there's something kind of new or significant or noteworthy about them. So that is the general rule of it. Federal court decisions, likewise, are not technically binding on lower courts, except on like state trial courts, except that decisions of the U.S. Supreme Court are going to be binding on issues of federal constitutional law. But like federal district courts, no. Persuasive only, and same with the circuit courts. Harbinger of imminent death. Wait a minute. They recorded attorney meetings? Oh, yeah. Oh, yes, they did. When the lawyers showed up to have their meeting with Rick, and the attorneys stood there in the door with their little video recorder, their little handheld camcorder thing, and recorded them having their meetings. Indeed, they did. Yep. Seems like a little bit of impairment of your right to counsel, doesn't it? This is the issue. This is one of these issues that it's obviously problematic from a legal standpoint, but they don't have a particularly good factual record of, they kind of have a factual record of what happened, but they didn't have hearings on it or anything like that. There was no real record made of like, how did this impair your ability to present the defense or to be able to consult openly and things like that. What did you do when you found out you were being recorded? Is there any indication that anybody, watched it and listened to it and stuff like that? It's not really in the record. And so because of that, that issue, if it's brought up, is more in the realm of post-conviction, of habeas types of things, where you're not just limited to what happened during trial and we're reviewing it, but you have the opportunity to bring in new evidence and present new arguments and grounds for essentially why what happened was unjust, was unfair. Which, as you may know by now, is not what the appeal process is about. The appeal process is just about did the judge make mistakes? That's it. Jason McClellan, in your professional experience, have you ever come across a case where a 44-year-old man with no criminal history commits a double homicide of two strangers and leaves basically no forensic evidence? I can't say I have. I suppose technically that most of those cases, if they happened, would go undetected, wouldn't they? Because with the absence of forensic evidence, how are you ever even going to find this guy, out of the blue? It's just not a thing that happens. People do sometimes, commit their first murder, their first serious crime late in life. So I guess maybe some people get away with it. Yeah, nothing like this though. Nothing like this though. The only one I was thinking of off the top of my head is I had a guy that killed his dad, shot and killed his dad with a shotgun. And it was he was older. He was like in his 40s, so that's like the only thing that they had in common. Yeah, he left forensic evidence. When you shoot somebody with a shotgun, that tends to happen, but there are also witnesses and stuff like that. And it was just like a methy breakdown, personal dispute kind of thing. So that's the sort of thing I would expect from like a suddenly somebody at 40 something randomly, commits murder, but that certainly wasn't his first crime either. So no, can't say this is one I have a lot of experience with, although by definition, it would seem that cases like that would fly under the radar, wouldn't it? RM Productions YouTube, girl. Quis custodiet ipsos custodes. Who watches the watchers? Who watches the watchers who watch the watchers? Thank you, Andrea, for watching the watchers and for caring about justice in Delphi and like in general. Also for Kitty updates, cranks, Andrea, free Rick Allen. Thanks for being here with us, girl. Appreciate it. You're a couple hours behind us now, I guess. So, I don't know. It's probably not crazy late for y'all at this point, but hey, it's still the weekend, right? So we all get to sleep in tomorrow. It's fine. It's fine. We're all great. Shell herbs, because I love and respect so many here and wish we could all be doing a Delphi sit-in until Richard Allen is free. Free Rick Allen. Yeah, I mean, we can kind of in concept, of course, but it's going to be still a long process. You know, the next step is wait for the state to respond, and they're going to take their time too, you know, which is, it's not unreasonable. This is a huge case, big record. I always kind of complain a little bit because I'm like, look, the defense attorneys are new on appeal. I'm not sure about the prosecutors in Indiana. Do they get like attorney generals? I think they do, don't they? So they're kind of in the same position where you have new attorneys that come in and they all have to get familiar with everything. It's a big case. But it's just frustrating from the standpoint of, you know, we've already waited a year just to get to this point, and we might be waiting another year before we get a decision. This is not a process that moves quickly at all. Marvin CZ, I'll have to watch the replay, but I'm grateful for your coverage of this case. Well, I am grateful for your interest in it and for your checking in on the replay and for your support. Very much appreciate it. Bridget 039, can they add an addendum fixing want to know here? I mean, in theory, they could. I don't know what the thought process was behind that. I don't know if they overlooked it. I don't know if that was, you know, overstated at trial. I'm not sure. I have to assume they had some reason for doing that, but I don't know what it was. But they could, in theory, ask to to amend, file their amended brief, and then all they have to change is the one word, or just file a notice of. I mean, technically, the way to do it is to file an amended brief, which is a pain, but it's not out of the realm of possibility. Just not sure if there was a reason why they did that in the first place. Lucy Fair is gifted a membership. Thank you so much for that. Really appreciate that. Harbinger of imminent death. Totally off topic. But do you think it was a mistaken strategy for Walsh to plead guilty to the 2 charges he pled on? I don't think it was going to matter one way or the other. I really don't. You know, the reason I think strategically they did it was so that if he testified, he'd be able to say, oh, I took responsibility for this stuff, but I didn't do the others, to just try to give him some kind of credibility as if he's taking accountability by admitting to the things that don't really matter as much in the grand scheme of things. But of course, it didn't play out that way because he didn't testify anyway. So I don't know what the thought process was. It seemed like they had him pretty dead to rights either way. So Nick Starrow, I say this strengthens my theory that Brad Holder was an active informant. It certainly makes you wonder, doesn't it? It certainly makes you wonder. I have absolutely had this thought, him or Patrick Westphal, either or both of them. This was during the time frame when who was it? Was it the FBI? Was it Department of Justice was talking about how, you know, the greatest domestic threat is the white nationalism, and so developing informants and going undercover and all of that type of thing. You would expect that type of activity if that's going to become a law enforcement priority. We have some of this activity kind of over in Idaho. There's a lot of it in the prison, but it doesn't seem to be like real common elsewhere in a lot of other places. So I would think where there's a hub, like Indiana, you know, the home of the Nazi Party and stuff like that, you would expect there to be a lot of focus in that area. So yeah, I've definitely wondered about this because it doesn't provide a very satisfying explanation, does it? They just said, okay, great, he clocked out. That's that. Moving right along. Never bothered to check about Patrick Westphal's. Patrick Westphal's I was at home with my kid anyway is not a particularly good one. Get their phone data, you know, check their phone data, check their phones. Surely you have some PC just based on the connection here and the strength of the Odinism link, the changing stories, all that. Jason McClellan, the defense gets a reply brief. Is that 24,000 words less or more? Could they be saving stuff for the reply brief? So it is going to be less. I don't know. Let me see if I can find real quick. Rules on appeal. Reply brief. See if I can find it real quick. 14,000 words, it looks like. Let me be sure. Reply brief with reply brief. Okay, appellant's brief is supposed to be 30, appellee's brief is supposed to be 30, and a reply brief is supposed to be 15. So we already know, of course, that's been blown quite a bit up. So I don't expect they're going to be limited to that. They'll ask for more, more time. The appellant's brief was, it's supposed to be limited to 14,000 words. The reply brief is supposed to be limited to 7,000. So if the idea is it's supposed to be roughly half, then I'd expect they'll get 12,000. That's what I would expect. As far as saving stuff for the reply brief, they might be saving like some facts or some kind of explanations, I guess, for reply to just sort of see how does the state respond before we know whether we need to go down this particular road or not. But they're generally not going to be saving anything real material, real substantial for the reply brief. One, just because there is kind of a risk that it gets overlooked. The reply brief just doesn't really get quite the respect that the two primary briefs do. Doesn't necessarily get the same attention and focus. It should, but it's just, as a practical matter, it doesn't always. So you run the risk that the court's going to overlook it if it's just in the reply brief, if it's something that's really important. It can't be something that's like, brand new argument for error or something like that. You generally can't raise material things for the first time in the reply brief. It's really just there to respond to what the state says. So if it's something that warranted saying it, the first time, then you probably needed to say it and not hold it in your pocket. Ian Swit is gifted a membership. Thank you so much for that. Appreciate your support. Harbinger of imminent death. Do you think LWOP sentences should be considered unconstitutional? I've argued that LWOP sentences should be considered unconstitutional. I did it in Washington based on, we already have case law here that threw out the death penalty on the grounds that it is administered in an arbitrary way, particularly racially arbitrary. And so I argued that in the context of life without parole sentences as well. They didn't bite, which I wasn't really surprised. But the reasoning seems to be sound because there's not a substantial difference in how charging decisions are made when it comes to picking the harshest possible option. And then doing that repeatedly in 3 strikes cases versus doing it one time in a death penalty case. The reason for choosing the harshest possible penalty tends to carry over. So yeah, I'm not particularly a fan of life without parole sentences. I think they're sort of pointless too. It's what it's doing. Most people, even violent, like the most violent offenders, they typically age out of it. It's very, very rare that you have, somebody that's like 70 years old that's out still committing violent crime. And so at some point, the kind of benefit of doing it is really outweighed, in my view, by not just the cost, which is certainly a factor, but just kind of the inhumanity of incarcerating geriatric people. You know, just I'm like, what's the point of that? That seems kind of, I don't know, just seems kind of pointless to me. So I don't know that there's a strong constitutional argument for it at this point. Life without parole is a minority. When I did that brief challenging it, I went through and did a full 50 state survey on who has 3 strikes laws and how do you qualify for them? What are like standard sentences for murder and things like that would qualify for life without parole in Washington, and found that it is very much a minority. Like the average kind of seems to be somewhere in the ballpark of like 25 to 40 years sentence for murder. Seems to be kind of the average. So yeah, I think so, but my opinion doesn't matter at all. So harbinger of imminent death. Okay, last one. Any truth to the trope of defense attorneys telling clients, I don't want to know whether you did it? Absolutely. Absolutely. There's a lot of truth to that. I talked about this not even that long ago. I can't remember what the context was, which would have been helpful, but different approaches to this. Oh, I think it might have been when I was on Paramount Tactical with Gary Melton. We were talking about the Tyler Robinson case, because we were talking about one of the things that they have access to in terms of an information source that nobody else does, which is Tyler Robinson. They were able to ask him about, hey, what roads should we be going down with our investigation, and what things should we be looking at, and so forth. But the issue is that if you ask your client if they did it, you can potentially limit your ability to defend them, to present certain theories of defense, because you are ethically prohibited from, suborning perjury. I can't now put you on the stand and have you testify that you didn't do it, because I have reason to believe that that's probably not true. It can make it a little bit challenging if you give me lots of details, and then for me to try to present a case that like contradicts that, it's ethically problematic. And so the way a lot of attorneys will deal with that is exactly by this. I don't want to know. I don't want to know, because it will tie my hands and I can do a better job of defending you if I don't. And the reality is that most attorneys they're going to have their own impressions from the evidence anyway. And so if they're inclined to form an opinion, they're going to do that. And what you have to say about it is just one more piece of information. What clients say is not necessarily the most reliable thing out there in the universe of stuff to be building a case on. But it's often just, it's often just you spend so much time in the defense world looking at inconsistencies, looking at things like, yeah, you can have a whole bunch of eyewitnesses to an event and they describe things very differently, and it's unreliable, and none of it adds up with the physical evidence anyway, and the scientific evidence is kind of horseshit, and you can't really tell like how significant it is. Like, you're so used to dealing with skepticism that it's easy to have a mindset as a defense attorney of just, well, I don't know. I don't know what happened. I wasn't there. I know what the evidence is. I know what's going to be presented at trial, and I can predict what a jury is going to think about it. But in terms of some like greater ontological claim about, what the situation was, might be beyond my pay grade. I tend to look at things that way. But it doesn't mean I won't ask my client, about the facts and stuff like that. It's something that we kind of take case by case. Sharon TH Max with a super sticker. Thank you so much for that, Sharon. Really appreciate it. Dr. Von Decay, if Richard Allen is granted a Franks hearing for the search warrant, who argues it, the trial or the appellate attorneys? If he's granted a hearing, it goes back to the trial court. So it's going to be his trial attorneys or new trial attorneys. I mean, whatever the situation is at that point in time, but it's happening in front of Gull with trial lawyers, not with his appellate counsel. So Not really an ideal situation, is it? Torin3, up way too late and saw you were streaming. Glad you liked the braid. Thank you for reminding me because I keep forgetting to share it. This is the braid that Torin made, guys. Check this out, how cool it is. It's got the white side. It's hard to see, isn't it? But the cats, the fish, the boxing gloves. It's nice and long. It's like perfectly belt length. And then the blue side, you know, just the opposite. You can't really see the detail, you know, because of my camera, and I can't get it up. There you go. There you can see it. It's just this incredible weave. Like, I'm so impressed with the amount of work that went into this. And I was especially impressed, this tassel. You can really, you can't see that very well either, but just, it's so fine. I didn't realize how fine all of these threads are that are going into this weave. So this is the Kohimo braid. I am so grateful for it. It is very super cool. I plan to wear it proudly. Thank you for reminding me to show it off on the stream. And super cool. I learned about Kohimo through this. It's a Japanese braiding technique. They use it to make the obi closures, which I didn't know. So I always like learning new things. V-tubing enthusiast. Who do you think really killed Abby and Libby? I don't know. I don't know. Like, that's my biggest problem with all of this, is that the investigation was so problematic that it makes it very difficult to say. I can say I don't think Richard Allen did it. Feel pretty confident about that. But in terms of the other suspects, you know, was Keegan Kline involved? They had the whole catfishing thing going on. I don't know. Was Ron Logan involved? I don't know. Was Holder and Westfall? I don't know. Like, there's reasons to think all of these people could have done it. I just don't know. Love to see that geofence data. Really, I mean, not that people have to bring their phones to commit a crime. It's just that you kind of think that they probably would, especially back, I don't know, back in 2017. Was it really on our minds that your phone is tracing your location everywhere you go? I feel like that's kind of a more modern thing to be aware of. So no, I think that's really the big problem with this case, is the way that they handled it, you know, from the outset, with all of the just terrible mistakes they made. The recording over stuff is ridiculous, you know, the interviews disappearing. If that really was an inadvertent thing, as they've described. But it honestly it creates the impression of a very chaotic process. There are so many people involved, so many tips coming in. And so it's like everything got spread very thin, and nothing got the attention really that I think a good lead would have needed to be followed up on. It seemed like there's just yeah, I mean, unless Brad Holder's an informant or something like that, you know, and that's the reason why they cleared him so quickly. The kind of other way to interpret this is just, it looks like that's what they were trying to do. Like, they were trying to clear people more than they were trying to generate leads, because like maybe they were getting enough leads already through the tip line. I don't know. It looks like a lot of chaos. Not real good communication through all the different levels and everything. And they just didn't really have a good plan for how to manage it. And so because of that, that's my big problem with this case, is I'm not sure we'll ever know. Really not sure we'll ever know. 4D man, writing motions. Do lawyers spend much time crafting the prose for nuance and impact, and for brevity so the reader, the judge, doesn't lose interest? I think judges have a shorter attention span than kittens. Well, I'm sure everybody's going to have a different approach, but I can tell you, I couldn't count the number of times where I have like sat down and got up and paced around and went outside and sat down and agonized for far too long over exactly how to say like one sentence. You know, exactly how do I communicate this idea in the way that I think is the most powerful. And then as far as brevity, editing is so important. It's really critical. It's hard to do often especially when you're in public defense, because you got so many cases, you got so little time. You don't necessarily have other people. Like I was a solo practitioner. I didn't necessarily have other people to like have a fresh set of eyes on things and bring new impact. So we had to kind of improvise on some of that stuff. But yes, absolutely editing to cut out what isn't necessary and to make sure that what you are saying is as impactful as it can be. Critical, really critical. I mean, it's a persuasive work, an appellant's brief. And it needs to pack a punch because of how far on your back foot you're starting. You know, you got a big hill to climb, so it's challenging to be able to achieve that. Beyond the Pale Cherokee, usual time to decide a HC writ Q jurisdiction. So a habeas corpus writ Q, like just a question about jurisdiction. I'm not sure I totally understand exactly what the question is asking, but habeas corpus writs will often be decided a little bit faster than the appellate process. And that's because they're treated a little bit more like motions, like just kind of normal motions. What the court's often doing is looking at it to decide. There's like a lot of preliminary evaluation that goes into a habeas corpus writ that it lets them kind of shortcut a lot of thought process about it, because they aren't necessarily thinking a lot about the merits right off the bat. They're thinking, you know, does there need to be an evidentiary hearing? Is this clearly frivolous? Is it time barred? There's just a lot of like procedural hurdles that are kind of the first thing that you clear. So a lot of habeas corpus petitions, if they don't clear that, they are going to get, you know, tossed out pretty early. But then on the other hand, you have habeas corpus petitions that clear that bar, and they get complicated. They require remand and taking evidence and making findings and stuff like that. That definitely happens. I've seen it happen. And then you can be talking about, you know, a very extensive process. So on average, I'd say it's probably shorter, but that's just because so many get resolved on these kind of summary issues at an early stage. Guys, really appreciate you all joining me. It's got to be super late where some of you are. It's 1 a.m. here. The cats are really losing it. They aren't sure what to make of all this. Look at this big potato here. This is the big chonker. This is Jude. Jude is he's 6 pounds at the vet the other day. He's a real big boy. I call him my big butternut. But he's gonna be a big one. Yes, sweet boy. I know you're ready to go to bed. I'll get you your kibble. They get their little kibble treat to go into their room, and that's their kibble experience. So guys, yeah, it's kind of hard to get back into the mindset of this case. Honestly, there's still like so much so much residual trauma with it and stuff like that. But it is easier, I think, now that, you know, a lot of time has passed and it's not so acute. But at the same time, that also kind of just makes me that much sadder because of how it shouldn't be this way and how long it's been, with this kind of unjust result being out there and this unjust treatment of this guy for how long that's been going on, and kind of revisiting all that and stuff is just, it's just not pleasant. But I do have hope after reading the appellant's brief. I definitely want to share that for all that, I don't want to be overly enthusiastic. I don't want to set unreasonable expectations, and it's difficult to win any appeal. But I do tend to believe that most cases are won or lost on the facts. And that's why I think he's in such a strong position. He's got such good facts on his side. And I think they've done an excellent job of being able to draw out those facts, to be able to, use them to tell the story of what happened and to show how appalling and unjust and un-American that process has been, and just how unreliable. It makes it look like just a kind of box that was checked, a formality that was gone through, but with no real concern for whether, substantively it was right or not. It didn't really matter. They got a guy. Didn't necessarily matter if it was the right guy. And that's one of the most important things that you can have in an appeal, because probably 95 to 99% of the time, you don't have that. You don't have a sympathetic client. You don't have good facts. And so your big burden is convincing the court why they should care at all about doing anything in the case. So just the fact that he has that is very much in his favor. And I think that they have, they've done a good job of showing why you should care what happened, and why it really undermines what we expect the trial process to be, what we even have it for. So it just didn't function the way that the adversarial testing is supposed to function. So there's also a lot going on with the records in this case still to look at. I've only just barely started to scratch the surface with that. Still a lot of stuff that's sealed that probably shouldn't be. Not sure what's going to happen with that either, but continuing to kind of look at that. But other than those types of issues, I think the next thing that's going to come up is just whatever the state's response is. So I will be keeping an eye out for that, of course. Probably won't be till, sometime next spring. But definitely expect to revisit this case, if not sooner, by the time that we get that brief. So then maybe that will shed some light on some of the decisions that the appellant's counsel made with how they crafted things and how they chose to present things and argue them and so forth. So with that, guys, as far as other stuff going on, I got some Christie stuff coming out soon. If those of you who are watching the Jim Martin trial with me, this is the basis for the Christie movie that should have been better than it was. The fantastic boxer Christie Martin. We are just about to get to Christie's testimony. Some of it is real hard to watch, so I do kind of want to warn people about that. But it's a very important case, and it's powerful to see her, I think. So cat not on the keyboard. So we are about to get to that. Still working on my some more stuff to kind of wrap up the Luigi Mangione suppression hearing. Ongoing stuff with Tyler Robinson. He's got a hearing on the 29th. That isn't going to be any big deal, but I'll still probably watch it anyway. It's a ruling to give us a hearing to give us a ruling. And then I'm monitoring the Rob Reiner case. Very interested in that. The Nick Reiner case. This is looking like an unfortunately common situation that's shown up in a very uncommon context. This issue with severe mental illness and how to manage it. So, Yeah, can't think of anything else off the top of my head that's like right on my radar, but that's what I got going on in the short term, guys. So do keep an eye out here, Substack, if you're so inclined, and you know, get those as I get them done. Otherwise, enjoy your holiday. Enjoy this last day of darkness, guys, because it's going to change after this. Going to start getting light again. Life will return to the world and to my consciousness. I don't do well with the short days. It's not really my, doesn't really, I don't sleep as well. I don't just nothing really goes better. It's a very like hibernating type of period for me. It's just probably fine. I mean, hey, I'm getting like lots of reading done and stuff like that, but I do tend to like my my nice long sunny days. So ever closer to those. Mel Klomp, I skipped ahead on Jim Martin trial. Christy was amazing. Yeah, she was. She really was. What a difficult thing to have to do, to have to get up and tell that story. Do it, right in front of him there. But she's a tough lady. I have so much respect for Christy. So all right, guys, it's a night. I'm going to call it 6 hours. It's like old times going back to Delphi. So I do appreciate all of you. Thank you once again. Merry Christmas to everybody. Happy Hanukkah, all the other holidays, whatever you might celebrate, or nothing at all. Try to find something to celebrate, even if you don't, even if it's just, hey, the days are about to get longer again. So thank you, everybody. Appreciate you. Appreciate your attention to this case. We'll be back soon, and we'll see you next time.